umaga, ito ang UNTV News Break. Nakatakda ng pagbotohan ngayong araw ng Senator Judges ang mosyon ng prosekusyon na ipasabpina ang bank at tax records ni Vice President Sara Duterte at asawang si Atty. Manasseh Carpio. Gayunman kahit bumoto pabor sa pagsummon sa mga naturang dokumento, malamang na kailanganin pa rin ng impeachment court na magpadala ng request sa Malacanang para makakuha ng pahintulot mula sa Pangulo upang buksan ito. Samantala, umaasa ang House Prosecution Team na pagbibigyan ng korte ang kanilang request. Ayon kay legal spokesperson at isa sa counsel ng prosecutors ng House of Representatives na si Atty. Benjamin Tolosa Jr., mahalaga ito upang mabigyang daan ang Senate Impeachment Court at publiko na maikumpara ang actual financial transactions ni VP Duterte sa assets na idiniklara nito sa kanyang Statement of Assets, Liabilities and Net Worth o SALNs. Sinabi naman ni Atty. Michael Powa, isa sa mga abogado ni VP Sara at tumatayong tagapagsalita ng depensa, paglabag sa due process at legal standards ang nais mangyari ng mga umuusig sa pangalawang Pangulo. Antabayan na ng pagpapatuloy ng impeachment trial ni Vice President Sara Duterte, ihahatid ng live ng UNTV News and Rescue susunod na. Ako si Bernard Dadis at dito sa UNTV, Diyos ang aming sandigan. Serbisyo publiko ang aming pinahalagahan. Magandang umaga.
The Senate President, Sherwin Gatchalian, opened the session at exactly 2 p.m. on July 15, 2026, with 21 senators present constituting a quorum. As to administrative matters, the impeachment court is in receipt of the House Prosecution Panel's request for issuance of subpoena duces tecum and ad testificandum to Land Bank of the Philippines and its branch managers today, July 15, 2026 at 4:52 p.m. The presiding officer initially confirmed his ruling that the vote will not be per issue but per motion as preliminaries at the start of the proceedings. The oral arguments started and the House Prosecution Panel manifested that the oral arguments will be done by Congressman Chel Jokno, who argued that no law can limit the constitutional power of the impeachment court as it is supreme in trying impeachable officers. The respondent, however, manifested that the oral arguments will be done by Atty. Michael Powa, who argued that the power of the court cannot be exercised by disregarding due process and cannot be used for fishing expedition. Rebuttals were done by the same counsels. Afterwards, the senator judges went to a caucus which lasted for 1.5 hours. As to manifestations and motions, after the caucus, the presiding officer stated that the senator judges wanted more time to study the motions and confirmed the agreement of the senator judges to resolve the request for issuance of subpoena on Monday, July 20, 2026. He further confirmed that the senator judges are going to ask the parties about their positions for 10 minutes per senator and not more than 1 hour per side. House Prosecution Panel lead Jervil Luistro manifested that they will not anymore present and formally withdraws the following names of the witnesses for Article 4. Number 1, PNP Firearms and Explosive Office Representative Michael Flores, Bons Magsambol, Sheriff Abe Andes, a family member of a victim of threats, and an unnamed psychiatrist. She further manifested that Atty. Matibag will be presented on Tuesday, July 21, 2026, and requested for the issuance of subpoena ad testificandum and duces tecum for the following witnesses for Article 1 based on their submitted request for subpoena. Number 1, Marivic Pareja for July 21 and 22, 2026. 2 land bank employees including Violeta Constantino, Branch Manager of Shaw Boulevard Branch, Ninita Camposano, Branch Manager of DepEd Branch, for July 21 and 2022 as well. A subpoena should also be issued based on their request to Lynette Ortiz, President and CEO, but for subpoena duces tecum only. Upon clarification of Senator Judge Bam Aquino, the presiding officer confirmed that the defense will present its evidence after the House panel of prosecutors have finished the presentation of evidence in chief of all the articles of impeachment. The lead defense counsel, Attorney Season, manifested that the counsel for prosecutors made lengthy and unnecessary statements during yesterday's hearing and asked the court to remind the parties to refrain from doing so. The presiding officer granted the same and reminded the parties to refrain from making unnecessary statements in their manifestations. Senator Judge Kiko Pangilinan manifested that the proposal of the presiding officer to allow unnecessary statements to both parties would have been the better ruling, since the impeachment court is a political proceeding as well and shouldn't be bound by very technical rules. Following rulings by the presiding officer on various evidentiary motions and objections by both parties, the trial was adjourned, and pursuant to the rules of procedure on impeachment trials, the impeachment court will resume session on Monday, July 20, 2026 at 2 p.m. The agenda is the arguments of and clarificatory questioning by the senator judges to the parties relative to the issuance of subpoena duces tecum to the BIR, AMLC, and banks. Any questions? Walang questions?
Sir, hindi ngayon, pwede yung kahapon.
Alin po?
Just one manner lang po kahapon. When Defense Counsel Senator Judge Padilla po attack the credibility of NBI Regional Director Lotok. Ordinary po ba yun sa, sa court proceedings that a sitting judge attacking the credibility of a witness?
The senator judges are already in possession of several information aside from the fact that they are also hearing and reading the cases and the evidence being presented. So yung mga senator judges po natin, because they have certain information, are free to ask questions to the witnesses to establish whether they have to believe or not to believe the testimony or the credibility of the witness. So it is within their prerogative to ask matters that might have come to their possession in mga information na yon para i-clarify kung ano po yung katotohanan doon sa information na yon. So I think that is what Senator Judge Robin Padilla did yesterday when he asked Attorney Lotok about yung career niya.
Kanina po na-clarify na the prosecution will present first on all articles before yung defense. Posible pa ba itong mabago? And meron bang effect kung mababago siya or mariretain na ganon yung flow ng presentation nila?
Hindi na po yan posibleng mabago kasi yun yung nakalagay sa Senate impeachment rules na bago yung isang panig magpresenta ng kanilang evidence in chief, kailangan tapusin muna lahat ng mga artikulo doon sa pagpepresenta ng House Prosecution Panel of their evidence in chief. Ganun din yung mangyayari doon sa pagbobotohan on the ultimate question. Kailangan nilang pagbotohan din yun pagkatapos ng lahat ng pagpepresenta ng mga ebidensya, hindi per artikulo, hindi pagkatapos ng bawat evidence in chief nung magkapilang panig.
Attorney, doon po sa malamang nabotohan doon sa pagpapasabpina sa bank and tax records, ano po ang magiging batayan dito? Simple majority po ba ng 24 senators or ng present sa trial.
Tama ka dyan, Nympha, no? Pag mga ganyang mga ordinaryong mga botohan lamang, simple majority lamang ng quorum. So only those senator judges present will be able to vote. And yung mananalong boto doon is 50% plus 1.
So kung 21 po on Monday, 11 votes lang kailangan.
Tama po.
And in-expect na po kaya yan sa Monday?
Yes. Again, iba yung expectation sa realidad. Kanina natanong din ako, no, kung may expect ba mag-i-issue na tayo ng resolution on the issuance of subpoena. Sabi ko, yan ang expectation at pinaghandaan na rin ng presiding officer na magkaroon ng resolution today. Pero because of the agreement between the senator judges to have more time, and since this subpoena dos estecum naman for the AMLC, the banks, and the BIR, is relative to the sa Article 2 pa, which is the last article to be discussed by the prosecution or to be presented by the prosecution. Kaya siguro yung mga senator judges opted for more time. And also, dahil nabawasan din yung mga witnesses sa Article 4, so technically we are expecting na baka before July ends, matapos na natin yung Article 4 at mag-umpisa na rin yung susunod na artikulo, which is Article 1 sa pagpepresenta ng ebidensya ng prosecution.
Sir, ano ko lang, yung majority, sir, dun dapat yung present sa floor, hindi po yung nagpa-attendance. Kasi baka nagpa-attendance 21, pero pagbotohan po, 15 na lang. So, paano po?
Ang binibilang po yung present na nagpa-attendance. So, ibig sabihin po nun, kasi po lahat sila mark as present nung time na yon, then pag nagbotohan po, dapat kasama rin sila sa numero. Kasi yun po yung nagko-constitute ng quorum, yung mga nagpa-mark na present po. Doon po ang bilangan.
Siguro po ang hugot doon ni Manong Jan, attorney, ay meron
pag biglang
minsan
nagpa-present, pagkatapos umalis, di na bumalik, di na makaboto. Siyempre, tatawagin ulit, magro-roll call ulit yan. Pwede naman magkaroon ng ganon. Nasaksihan na natin yan sa mga proseso naman ng Senado sa legislative body. Pero kung wala pong magko-question nung quorum at that time, then the quorum that was established at the start of the roll call nung umpisa ng proceedings, yun yung mananaig. Pero kung may mag-question po, then magpapa-roll call ulit para matingnan kung ano na yung bagong number for quorum.
Sir, mababago din yun. Halimbawa, may humabol na senator, judge, before the vote.
Tama po.
19 yung una, then nagdagdagan ng dalawa, naging 21.
Tama po. Tama po.
Sir, kanina, bukod sa Articles of Impeachment itself, may ilan pang mga natakal na issues, no? Like yung SEA Games probe nga ng NBI. Do we have a rule po that prohibits senator judges from making manifestations that may be unrelated to the proceedings?
Wala po akong nakikita sa Senate Rules on Impeachment about that matter. Kung kailangan niyo rin po sana maintindihan yung ating mga senator judges, this is the only plenary session na nangyayari, no? Yung sa impeachment court. Dito lang sila nabubuo ulit ng isang buo bago magsona. Kasi ngayon naka-recess pa ang Senado. So, kung meron silang babanggitin about certain supervening event na nangyari, then wala silang ibang chance na banggitin yon kundi dito sa plenaryo ng impeachment court. So kaya ganun din ang paraan ng pagtayo ni Senator Judge Robin Padilla and Senator Judge Alan Peter Cayetano at saka nila Senator Judge Pia Cayetano. Kaya kanina nasaksihan natin na wala silang ibang recourse but to raise the issue during the proceedings of the impeachment.
Sir, ask ko lang, yung pagbawas ng mga witnesses ng prosecution, with that, how do we see yung pacing na nung trial? Mapapabilis na ba or ano po bang tingin nyo?
As katulad ng sinabi ko, hindi na natin kailangan gugulin yung 11 days para sa Article 4. Now, yung 11 days na yon nakatakda yon dahil sa 10 testigo nila na nakaplanong ipresenta. So, dahil nung makikita ninyo, bawat testigo halos 2 days, di ba? So, kung ganun yung takbo ng mga dalawang testigo, lahat ng mga testigo na yung ipresenta nila, then kukulangin talaga yung 11 days, baka umaba ng 20 days yung pagtalakay lamang sa Article 4. So by reducing the number of witnesses, nakabawas din yon dahil hindi na natin ini-expect na kailangan pa nating tapusin yung 11 days na yon. So, kaya sinasabi ko kanina, baka before the end of July, and tinatalakay na natin yung Article 1.
Ang oral argument ng magkabilang panig. Doon sa depensa, tumayo po si Attorney Michael Poa. And of course, sa part po ng prosecution, tumayo naman po ang ating kasama, si Congressman Chel Jokno. We are very much happy and positive with the arguments that were raised and articulated by Representative Chel Jokno in behalf of the prosecution, and we want to express our positivity and hope that on Monday, kamukha ng sinabi po ng ating presiding officer, kapag nagdesisyon na sila, ay sana kami po ay umaasa na mapaboran ang aming mga request or pakiusap na issuance ng subpoena. That includes bank documents, AMLC records, and BIR records. No? And then also, just today, nagmanifest po ang prosecution about the withdrawal of 5 names from the list of prosecution's witnesses. It is for the same reason na sa amin pong pananaw, ay yung sasabihin pa nilang testimonya ay napatunayan na sa mga naunang testigo na inilahad po ng prosecution. And of course, for Monday, as announced by our presiding officer, magkakaroon po ng pagtatanong ang ating mga senator judges, and we are very much confident that Congressman Chel Jokno will be able to answer and explain all the questions which will be raised, no? At inaasahan naman po na ang huling testigo para sa Article 4 threat, who is Attorney Melvin Matibag, the NBI Director, ay mapapasalang sa Tuesday, no? At ang kasunod po nito ay ang pag-uumpisa na ng presentation of witnesses on confidential fund. Doon po sa confidential fund ay ganap po naming ipinahayag ang aming paghingi ng subpoena kaugnay ng aming mga susunod na testigo. Yun pong aming officer ng archives sa House of Representatives in the person of Marivic Pareja, and of course yung dalawa pong land bank official or employee. No? So, for the opening statement, that would be all. Thank you.
Okay, we're now ready to accept your questions. Gab?
Hello, ma'am, sirs. I know that you have spoken regarding the wisdom of knowing when to start talking and when to stop. But I would just like to ask if Tuesday is really the right time to stop regarding the Article 4 of the Articles of Impeachment. Kasi parang while the hearing has been dragging, parang slow-paced, may sentiments na parang bitin yung pag-present ng mga witness sa Article 4. Do you think it's the right time to stop po?
After the testimony of Director Matibag, it will be the right time to stop. Naging matatag at malinaw ang pagpresenta ng aming ebidensya. Our witnesses, who are credible, has said that the case is airtight at sigurado silang the threat is real. And remember that this is a constitutional process. Hindi ito simpleng krimen sa ilalim ng batas. Ito ay paglabag ng saligang batas. We are trying a case for betrayal of public trust. At sa ebidensya pa lang na napakita ng prosecution sa una naming 2 testigo, na makikita ng malinaw at matatag ang kaso. Gusto ko lang sabihin na pagdating ng testimony ni Director Matibag ay matatali na din kung ano pang pwedeng maidagdag para mas lalo nating mapakita sa taong bayan na kompleto at malinaw lalo ang ebidensya namin for betrayal of public trust and high crimes.
Any addition to that po? Okay na po. Clarify ko lang din po regarding kay Attorney Matibag kasi may request po siya na mas mapaaga po siyang mapresenta. Pero ngayon po, Tuesday po siya ipepresenta. Paano po yun? Nakausap po ba ng prosecution si Attorney Matibag?
Well, the reason why it will be on Tuesday instead of Monday is because as pronounced by the presiding officer, there will be, the senator judges will be given time to raise questions to both the prosecution and the defense. That is with respect to the subject matter of the oral argument, which is the validity of issuance of subpoena of documents, preterm documents, meaning prior to the respondents becoming an impeachable official. I wish to believe that Director Matibag is monitoring also the impeachment trial, but we'll make sure that he will be properly informed of the change in the schedule of his appearance in the impeachment court.
May dagdag ko lang kanina, kahit 2, 3 at 4 na oras mong i-cross-examine ang aming testigo, wala kang mapipiga sa testigong nagsasabi ng totoo at walang tinatago. That is why the prosecution is confident that we have presented our case clearly to the impeachment court as well as to all Filipinos who are watching the impeachment proceedings.
Sir, sorry to follow up lang dun sa sinabi niyo po. But wouldn't be or presenting a psychiatrist or presenting Sheriff Abe contributed greatly to the case? Hindi po ba siya makakatulong kung sakali?
We always have to balance, and like what Attorney Lorna said, you should always know when it's the right time to stop. At sa palagay namin, ito ang pinakamagandang panahon kung saan malinaw at paulit-ulit na sinasabi na ang aming aligasyon sa Articles of Impeachment ay malinaw na patunayan na ng ebidensya.
One final question po. Yung pace po kasi nung trial has been slow. O parang hindi naman siya madi-deny ng kahit na sino. Pero who benefits po ba as slow pace? Is it the defense or the prosecution?
The prosecution has greatly benefited with the pace of the trial kasi paulit-ulit na lumalabas yung aming ebidensya at paulit-ulit na nasasabi ng aming mga testigo. Bakit ito naging violasyon hindi lang sa batas as a threat, but it's a violation of the Constitution in the form of betrayal of public trust.
Pero sir, kung beneficial pala sa inyo, bakit po kayo yung nag-withdraw? Bakit prosecution yung nag-withdraw?
Dahil sa ngayon, kompleto na at hindi na namin kailangan dagdagan pa. It's unnecessary, it's redundant, at ayaw din naming sabihin ng mga taong paulit-ulit na lang. Mahirap na magsawa ang mga tao at mawalan ng kanilang atensyon kung nakuha na natin ang lahat nating dapat makuha.
Can I just add to your question, Iho?
May I just give emphasis dun sa dahilan na na-point out ni Attorney Kapunan kahapon, no? 3 mahahalagang salita ang binitawan niya kahapon sa kanyang manifestation. Surplusage, kalabisan, redundancy, paulit-ulit, lack of necessity, hindi na kailangan. And this represents the reason why we withdrew some of the names or 5 names from the list of prosecution witnesses. And I reiterated that in my manifestation because indeed, kapag nakita mo na hindi na kailangan, kalabisan na at paulit-ulit na, like what she said, we should know when to stop.
Yes, idadagdag ko lang, no. Why no longer meron tayong kasabihan na the thing speaks for itself. When Senator Pia said that I was giving my opinion on the video about Attorney Lopez crying and complaining, that was not an opinion. Because the video really, it was a statement of fact. The video showed, our video, which was used by the defense as its own witness, showed Attorney Sulaika crying. That was not my opinion. It's a factual statement. It also showed her complaining about her alleged violation of human rights. So just to correct with due respect, what were inaccurate statements, they were not opinions. They were just statement of fact from the video presented. Secondly, why not the psychiatrist? Because again, the video of all, the many videos, even the 7 timestamps which were shown to show the emotional tirade, kung paano mag-respond ang isang vice president, her emotional outbursts, her tendency to use expletives, no, to use very well, you know what your word she used, no? They by themselves do not require any expert witness to testify. When a person says or reacts that way, do you need a psychiatrist or psychologist to interpret when what you see is by itself self-explanatory? Hence, there's no need to get a psychiatrist or a psychologist to explain what all of you saw, what the whole nation saw. Yesterday and even before yesterday. The sheriff, why the sheriff? Because the sheriff, as Chairman Jinky, the sheriff would have been presented to show the violent tendencies. And you saw the violence, maybe not in actions, but in intention and in the way she expressed herself. When she said, "Pupgutan ng ulo," she said this. Now, do you need, and that's exactly what the sheriff would have attested to, the violent tendencies of the Vice President, which again, as also our chairman, our Kong Noy said, were adequately shown by our earlier witnesses. So, I think it is not fair to the prosecution to surmise that we are overly, parang umaatras na kami, that we are too much limiting. We are limiting the number of witnesses, but understand that limiting the number of witnesses has its own purpose. Because when you have so many witnesses and you open the door to cross-examination, lengthy, useless cross-examinations, you will confuse the public. So you will see eventually why, the reasons why we had did this. As I said yesterday, we submit. We have to appreciate the wisdom of our public prosecutors. And there. Yun lang po. The testimony of what you've seen, just to summarize, why is it complete? Kasi the first witness, you will recall, was technical. Went into authenticity, went into provenance, but could not testify on content of the video. The second witness, Attorney Lotok, testified as head of the Cybercrime Division on the content. Now, the third witness, in response to why only 3 witnesses, would have completed the whole cycle. Maraming tanong kay Attorney Lotok, ano nang nangyari? And he would say, dahil meron pang ibang division ng NBI na nagtuloy ng investigation. So, panoorin niyo na lang sa Tuesday, and I'm sure you will conclude, as we have, that with the presentation of Attorney Matibag, the whole picture, the whole narrative will be clear not only to the prosecution, but to you in media and to our people, na kumpleto na ang narrative with the presentation of our last witness.
Tama na ang timpla. kung dadagdagan mo pa ang Ricardo, baka mag-iba pa yung lasa. So titigil na kami.
Good afternoon po, Haji, Brigada News FM. Just to follow up lang po at very specific lang, paano po ninyo sasalagin yung mga po pwedeng gumamit po dito at po pwedeng, kumbaga, maglabas ng narrative na, baka kaya tatapusin na nila yung Article 4, lilipat na sila ng another article kasi baka palagay nila mahina, mas malakas tong Article 1. Paano po ninyo sasalagin yon yung mga ganong klase ng narratives po?
Baligtad po yun. Reason why we will be proceeding to the presentation of evidence for Article 1 on confidential fund is because we believe that we have established already our case in Article 4, that is threat. May sinabi si Noy kanina, dagdagan ko yon. Lahat ng labis ay masama. Sakto lang.
Mga kababaihan, reminder ha na
May asawa kami, ha?
Huwag kayong mag-asawa. Too much love. Too much love is also destructive. Baka sa haba ng interview, yun ang take away nyo, sabi ni Attorney Kapunan, do not love too much.
Okay.
And that is why it was really our intention to communicate to the people the reasons for the withdrawal of the names of the witnesses, no? Gusto kong ulitin yung sinabi ko kanina before the impeachment court. This is a constitutional process. This is sui generis. Liberal interpretation must be considered, no? Dahil itong prosesong ito ay para sa tao. And reason why we are stating our position about the withdrawal is because we want the people to understand. Dapat maunawaan ng taong bayan ang dahilan. Bakit namin winidraw yung psychiatrist? Bakit namin winidraw yung sheriff? Bakit namin winidraw yung PNP Firearm and Explosive Office Representative? Bakit namin winidraw yung family member, di ba? Because ultimately, this process concerns the interest of the Filipino people. Let us not forget, ang interest po na kinakatawan both of public and private prosecutors is the interest of the Filipino people, and they have the right to know what is happening in the prosecution, including the withdrawal of the names of the witnesses. But let me reiterate, the reason for the withdrawal ay dahil malakas na ang kaso. Kompleto na ang ebidensya. At ang sabi nga, lahat ng labis ay masama, so let us proceed to the next article.
Okay. Yes po.
Just, our spokesman, Attorney Jay is here. And I'd just like to emphasize and for you to think about statement of one of the senator judges who said, don't say it here. Kung meron kayong gustong sabihin, yung mga opinion nyo, yung mga conclusions nyo, yung mga manifestations nyo, don't say it in the impeachment court. Say it outside. Say it through your spokesperson. Say it. My personal view here, and what I say, please do not blame management. Please do not blame the public prosecutors. But I would like to say that when we talk about balance and when we talk about impartiality, I guess that same standard should apply not only to the prosecutors, not only to the defense, but to the senator judges. This is not to say that we are saying that they are biased. We are saying that we have to have a balance also, because when the senator judges make a manifestation, wala po kaming karapatan mag-object. Until, if the other side, for instance, if the other side, the defense, where prosecutors makes an objection or makes a statement, pwede naming sabihin misleading, Your Honors. Pwede naming sabihin vague, pwede naming sabihin confusing, pwede naming sabihin objection, etc. No? Sadly, we cannot say the same we do not have the same right to say that when it is the senator judges who make their own manifestations, who make their own opinions, who make their own conclusions of law and of fact as well. So, speaking for myself, if there is a call for balance, we're throwing back that call as well. Because I think hindi tama yung we will keep quiet in court and then sa labas na lang kami magsasalita. No, it is the right to information that we are here talking about. And as Chairman Jinky has said, this is a constitutional process. This is not the rules of court where technical rules are applicable. And hindi naman tama na it is outside court that will make manifestations through our spokesperson. Our very able Attorney Jay, I think, will have something to say about that.
Just very quickly, as pointed out by Chair Jinky, number one primary reason why there was a need for us to explain, the people deserve it, diba? They have to know, they have to hear from us why we made this decision. But secondly, this is actually out of respect for the impeachment court itself. You have to remember, these witnesses were listed in our pre-trial brief. So there's already expectation on the part of the impeachment court that we will be presenting them. So out of respect, of course, we could assume they already started to study and prepare for the possible testimonies of these witnesses. So it's also important, paliwanag namin mabuti sa kanila why we're now deciding not to present them anymore. To make it clear that this decision was not reached haphazardly or arbitrarily, but there's a good reason for it. So it's actually out of respect also to the impeachment court that we found the need to explain the decision.
Okay. Last na lang po. Sa palagay po ninyo, paano po kaya makaka-apekto yung naging issue kay NBI Director Matibag kanina? Kasi di ba may mga issues po na ni-raise si Senator Judge Alan Peter Cayetano and of course si Senator Pia, may mga nasabi din po sa kanyang pagharap as a witness sa darating pong Tuesday. Thank you po.
Well, I wish to believe that the issue raised earlier by the senator judges should be different from the subject matter of his testimony. I hope that they will be able to distinguish between the issue raised earlier and the fact of Attorney Melvin Matibag testifying on Tuesday. These are two different concerns. Director Matibag will be testifying on the allegations of threat against the respondent, while the question that was raised kanina is with respect to his pronouncement on the upcoming investigation on some infrastructure program concerning SEA Games, And kanina ko rin lang nalaman, it was Senator Judge Alan Cayetano pala who was the chairman of that committee during that time, Nevertheless, I wish to believe na the senator judges will be able to separate these two different concerns.
All right, go ahead.
Good afternoon, prosecutors. Earl Tobias po, IBC News. Prosecs and counsel, apart from knowing when to start, is this also knowing when to move forward? As we understand, the next article is the heaviest in terms of documentary evidence. Hinug na po ba ang panahon para yung mga dokumento naman na hindi nagsisinungaling ang dapat isalang at makita ng taong bayan? Thank you po.
I believe there are two significant reasons why we are moving towards the next article, for the purpose of presentation of evidence. First, ay yung sinasabi namin kanina, kompleto na, tapos na, na-establish na ang mga ebidensya in support of threat. With the exception, of course, of our last witness in the person of Director Matibag, who will be testifying this coming Tuesday, But after the conclusion of the testimony of the NBI Director, it is really our position that we have established already, completely, thoroughly, the case of threat or the allegation of threat, D-stab, and having contracted an assassin as constituting impeachable offenses under the ground of culpable violation of the Constitution, high crime, and betrayal of public trust. The second reason is, dahil kompleto na tapos na yung nauna, we should not waste the time of the impeachment court. We have to proceed immediately to the next article in accordance with the order which we submitted to the impeachment court. And the next is confidential fund. Similar to the first article which we presented, we are equally confident. We have strong evidence, and that is why we feel ready to proceed to the presentation of evidence in support of the misuse, misappropriation, and irregular disbursement of confidential fund of both the OVP and the DepEd.
Yaneska? Kindly pass the mic to Yaneska.
Good afternoon po. On ano lang po, yung request niyo for subpoena for bank accounts and tax records. Kong Shell Jokno cited nung Corona trial, the Senate Impeachment Court issued subpoena sa bank officials and at least, I think, 2 peso accounts of then CJ Corona. Given this precedent na sinight niya, meron po bang elbow room ang Senate Court to deny your request given na may ganitong precedent?
That is actually a prerogative exclusive to the senator judges on how they will be voting on this issue, whether in favor of the validity of issuance of subpoena or legality of issuance of subpoena or otherwise. That is an exclusive prerogative that belongs to the senator judges. But let me share with you, there is a concrete basis dun sa sinabi ni Kong Chel Jokno because it is actually in the Senate rules itself. If I am not mistaken, that is Rule 50, Section 136. If there is no rule applicable to a specific case, legislative precedent must be applied. At yung ini-invoke niya kanina, during the Corona impeachment, the impeachment court allowed extensive discussion about preterm documents.
Sorry, ma'am. What do you mean by preterm? Sorry.
This pertains to acts or omissions which happened prior to becoming an impeachable official. By illustration, 22 naging impeachable official. It means that documents pertaining before 2022, our position, they are still relevant.
Can I add something? Ang impeachment ay isang constitutional process. At ang konstitusyon, ang pinakamataas na batas sa ating bansa. Walang regulasyon, walang pangkaraniwang batas ang makakaangat sa ating konstitusyon. The constitutional process of impeachment being the highest form of inquisition in the country, dapat hindi tayo nalilimitahan at dapat nagkakaroon ng kapangyarihan ang ating Senate Impeachment Court na mabuksan ang kahit anumang dokumento, mabigyan ng access sa lahat ng pwedeng impormasyon kasi hahatulan nila ng pangtanggal ang ikalawa sa pinakamataas na opisyal na hinalal sa ating bansa. The access to information is the most important thing so they can say that there will be an impartial judgment. Magiging patas lang at balanse ang kanilang pagdesisyon kung magkakaroon sila ng pagkakataong makita ang lahat ng ebidensya at dokumento at walang regulasyon o kahit anumang batas ang dapat humarang dito. At sana maanyaya natin ang mga senator judges na huwag nilang sanaying malimitahan ng isang simpleng batas ang kapangyarihan na ibinigay sa kanila ng ating saligang batas.
Yeah, just quickly. Aside from the fact that there was ruling already made on this matter in the previous impeachment proceedings, dun sa Corona kung saan pinayagan buksan ito, as pointed out by Kong Shell a while ago, this is also, the exception is based on the law itself, on the bank secrecy law, no, na pinapayagan talaga yan sa impeachment proceedings. And even the foreign currency deposits, meron din maliwanag na Supreme Court jurisprudence yan na sinasabing that is not absolute. If it causes injustice, pwede pa rin niyang buksan.
May I just add something, no? Still in line with preterm documents, if that is really the subject matter of your question.
Yes, ma'am. Yes, ma'am.
Let us revisit Article 11, Section 2 on impeachment. Ang binabanggit dyan, who are the impeachable officials? Ang binabanggit dyan, what are the grounds for impeachment? But the Constitution never mentioned whether these acts or omissions must be committed before or during the incumbency. May sinasabi sa rules on statutory construction. If the provision does not provide, we should not provide. So our reasonable interpretation to that is whether it is committed before or during the incumbency, that is still covered by the provision on impeachment.
One short statement then, ano. I think the Vice President has recently been said, the prosecution is all ingay lang, no? Wala naman talagang ebidensya. She has said in interviews that the prosecution has no evidence. And yet, now that we are presenting evidence, who is blocking the evidence? Who is blocking the presentation of the bank records? Who is blocking the presentation of the BIR records? Who is blocking all relevant evidence? So we are saying, now that we are talking about evidence, why are they blocking our evidence? When they have said earlier in the hearing on the House Committee on Justice that they will present their evidence here. So really, this is a court. This is the impeachment court. This is the time to present evidence. How the prosecution wants to prove its case is up to the prosecution. How the defense wants to prove this case, their own case, we will leave it to them. And if they say that they will not present evidence, that is their prerogative. But we, in the prosecution, believe that the manner of presenting and what testimony or pieces of documents to present is entirely the prerogative of the prosecution, representing the people and preserving or safeguarding the right to information of the people. And lastly, if you are innocent, bakit ka aatras?
Okay na po. Nasagot na yung... I was supposed to follow up on yung preterm. Okay na po. Thank you.
Yes, good afternoon. Good evening na pala. Ma'am, so nabawasan na po yung mga number of witnesses dito sa Article 4. So definitely hindi po abutin ng Pasko itong impeachment trial. Ano po yung pagtaya ng prosecution kung kailan matatapos?
Well, we are in the process of re-evaluating, no, the list of our witnesses for the 3 succeeding articles, no? But of course, you have to consider also that there are times when it is the exigency of the trial that demands for the withdrawal of some of the witnesses. And that is exactly what happened in Threat, Article 4. Upon realizing the comprehensiveness, the completeness of the testimony of Agent Calilong and Attorney Lotok, we came into a conclusion. Sapat na, kompleto na, including the would-be testimony of NBI director, no? And we came to realize of that only after the conclusion of the testimony of Attorney Lotok. Indeed, it is only after you've heard entirely the testimony of these witnesses when you will be able to evaluate, sapat na ba, kulang ba, kailangan bang dagdagan? And that is why in our pre-trial brief, we made a reservation there. Kung hindi man pag we withdraw, pwede rin magkaroon ng additional if the exigency of the trial demands.
Ang cross-examination lang naman ng defense ang nagpatagal sa trial. Kung 2 o 3 oras ulit ang kanilang pag-cross-examine sa mga susunod naming testigo, sigurado akong Valentine's Day tayo matatapos.
At mapapalitan na yung national bird natin.
Ako, I am personally aiming to finish before Christmas para masaya ang Pasko nating lahat.
Yes, ma'am. Kunin ko lang po yung as the lead prosecutor, your assessment dun sa performance, of course, dito sa under Article 4, Congressman Lawrence Defensor, and kanina sa plenary, Congressman Shell Jokno. Your assessment.
10 of 10, 100 over 100, no? And of course, we give the credit to our head prosecutor in the person of Congressman Lawrence Defensor, who really worked painstakingly to make sure that we will be able to present all the necessary evidence thoroughly, completely in Article 4 that is read. Again, I'm giving the credit to our head prosecutor, Representative Lawrence Defensor.
Ay, ma'am, good evening po. Ann Soberano po of Bombo Radio Philippines. Ma'am, before the Senate impeachment trial nagsimula, palagi po sa press ko nababanggit na may mga pasabog-pasabog. So, si Director Matibag po ng NBI ang magiging last witness nyo for Tuesday. Ibig sabihin na sa kanya po yung pasabog for Tuesday. Thank you.
Let's wait and see kung meron nga ba siyang pasabog, no? We'll never know until we hear his testimony, no? Gusto ko rin lang i-congratulate ang prosecution, most especially Congressman Shell Jokno, for an outstanding performance, really, and a very enlightening oral argument that he did in behalf of the prosecution kanina, no? And that is why my scorecard for the prosecution is 6 all in 6 days.
Ma'am, another follow-up. Na-explain nyo na po yung paliwanag nyo na bakit po nag-withdraw kayo ng inyong mga witnesses. Pero ma'am, may mga critics pa rin ang nagsasabi na yung withdrawal ng mga inyong testigo ay reflects a weakness in the prosecution's case. Ano po yung reaction nyo dito?
Well, you cannot please everybody, no? Lalo na kayo sa media, alam niyo na yung kilala niyo na ang isa't isa. So, we are open. We are open to comments from everybody, especially the media, and we take them all in a positive note. Everything is positive here. If they say that kulang, you know, I'll end up with the difference nga. The difference between, ito na romantic advice na naman to. The difference between love and hate. Hate is not the opposite of love. Love is not the opposite of hate. It is indifference. Pag hindi kami pinapansin, kayo sa media, pag wala kayong opinion about us, you don't love us, you don't hate us, you're indifferent, yun ang nakaka-nervyos. You either love us or you hate us, but the moment you're indifferent, that means taong bayan. I'm talking about national issues. When people become cynical, when people become indifferent, when ang kababayan natin sabi nila, Pagod na kami sa impeachment na yan. Slow pace, boring na yan. Huwag na tayong manood dyan. Same yan. That is the indifference that we are fighting against. Dapat we are concerned. You have to be concerned about this impeachment case. Love us or hate us, but please, be concerned. Be informed so that you can come out with your opinion after. Ang ayaw po namin dinidedman nyo kami. Hate us. We're okay with you hate us because I can assure you that at the end, you will love us.
All right. Any other questions? And I think that shows that the love and the attention that you have been sharing our prosecutors. Again, thank you for our public prosecutors and the counsel for the prosecution panel. Do you have any parting words? Or I think, all right. Any parting words for what we can expect next week?
Sa atin pong mga kababayan, especially yung mga nanonood, kami po'y inyong samahan sa pagpapatuloy ng impeachment trial na ito sapagkat kagaya po ng paulit-ulit kong sinasabi, hindi po ito tungkol sa amin. Tungkol po ito sa ating lahat. And like what Attorney Kapunan said, be informed, be involved, be aware, be part of this impeachment trial. Because at the end of the day, this concerns the interest of the Filipino people, including our next generations. No? Maraming salamat po.
We're conditioned and our disposition is that each and every lawyer in the defense team should be able to argue and to cross-examine and to stand for the defense on any given day and for any given witness.
Sa horizon ba na papatawag din sa Article 1 si Attorney Zuleika Lopez?
Sa ngayon, wala pa po kaming na pag-uusapan na ganyan dahil nga yung depensa po kasi matagal pa eh. Nandun pa kami sa dulo, no? Speak for them. But only for the defense, napag-usapan na nga kanina at na-clarify na nga, nauunahin munang matapos yung presentation for all articles ng prosecution, tsaka magiging panahon naman ng defense para mag-present ang aming tinatawag na evidence in chief.
So, may interview kanina si dating NBI Director Jimmy Santiago.
No po.
Sinasabi niya na tungkol dun sa assassin, ang findings nila sa kanilang investigation, may kakayahan dahil may pera at may resources ang Vice President to hire an assassin. In reaction po?
Well, that's his opinion, but that has to be proven. That has to be proven actually in this impeachment proceeding. So, sir, pasensya na po kayo. I really, it's very difficult for us counsels also. We want to answer your questions because we have our opinions and we have our comments, but we just can't do so because of the sub judice rule.
By legal sir, can you expound more on the due process argument earlier? Limited lang po. Why would, pagsasabina po ng bank records would violate the due process?
Okay, because unang-una sa lahat, balik ko lang sa nabanggit ko kanina sa oral arguments. No? Pagdating sa pag-issue ng subpoena, you have to look at two things. No? You have to, first is definiteness. Ibig sabihin nun, kailangan particularly describe kung ano yung gusto mong i-subpoena. Pangalawa, it has to be relevant. Ibig sabihin, may kaugnayan o direktang kaugnayan dito sa isinasagawang paglilitis. Ngayon, pagdating naman sa due process, kailangan natin malaman, pwede ba yung mga bagay na sinasabina o hindi under our laws? And kung ibabaliwala na lang natin yung mga batas natin, kailangan lang natin mag-issue ng subpoena, then nawawalan ng due process because the respondent has protections under the law. At again, hindi lang po yan sa respondent, it goes for each and every one of us Filipinos. No? At basic naman po yan at sinabi rin po sa Supreme Court decision na aking kinote kanina that the due process requirement applies in every stage of the proceeding. Ibig sabihin nun, magmula sa pag-file ng impeachment complaint sa House, hanggang dumating ng Committee on Justice, hanggang dumating dito sa paglilitis sa Senado, dapat nirerespeto and now observe yung due process, no? Para naman sa kapakanan ng respondent.
On your part sa PESA, may mangyayari sa pagbabawa dun sa pag-counter ninyo sa mga testigo nila.
Too early to say, sir. Kasi mahaba pa to. Sa dulo pa lang kami. Actually, di ba, mauuna muna ang prosecution. So right now, I don't want to give any definite statement because it's really, really too early to say. No, it's too early.
First comment lang po doon sa possession ng prosecution na in the Corona case kasi piniyagan yung mga documents that predates his term as Chief Justice, and one of your key arguments in the case also on the aspect of predating yung position ni Vice President before siya ma-elected president. Comment na po.
I guess, again, I don't want to get into the merits. I'll just say what I stated. No, I'll refer you to my part of the oral arguments. The Corona impeachment trial was done way before the decision of the Supreme Court in Duterte versus HOR. And anong presumption dyan? That when the Supreme Court decided the decision penned by none other than Senior Associate Justice Marvic Leonin, they were cognizant and they were fully aware of what happened in the Corona trial. And that's why, there are guidelines that are enumerated under the Supreme Court decision. And again, I will refer you to that. You can go ahead and read the decision and you will see the guidelines there.
Ang constitution goes keep on saying, ito naman ay political, hindi ito masyadong technical and legal, kaya dapat maluwag tayo sa anumang hihilingin nila para maibigay po yung side naman na gusto nilang ipaabot sa taong bayan.
Ang kaluwagan po ba, ibig sabihin po niyan, ay hindi babaliwala na natin lahat ng batas ng Pilipinas? Hindi naman po siguro tama yan.
For additional comment na, ang reply ulit ng House kasi doon sa House of Representatives, Duterte versus House of Representatives case, I overtake.
I've already said my piece on that. No? So I think you should refer to it because obviously we disagree that it is obiter. Definitely, in fact, dalawang beses pa nga ni-reiterate yung guidelines Started from if you read the decision, the first 2 pages decision na may summation doon ng guidelines, and then doon sa last portion, inulit-ulit yung guidelines. So, I think that is something for the court to consider na, no? But obviously, as I said, I respect Congressman Diokno. I have the utmost respect for him, to be honest, no? So, he has his position, I have my position, meaning the prosecution has their position, the defense has its position, so it's up to the court.
Sir, wala kang binabasa doon sa oral arguments?
Opo.
Impromptu ka? Ano ba yan? Kabisado mo ba sa...
I think it's personal preference. Nahihirapan po kasi ako pag nagbabasa ako because it's distracting for me. So, talaga naman pong kahit noon ganun po talaga ako. No? Hindi ako nagbabasa. At sa regular courts, hindi rin po talaga ako nagbabasa. But sorry. I just have to kasi baka ma-misconstrue, no? It's really a personal preference. It doesn't mean that it's better na wala kang binabasa. No, I'm not saying I'm good kasi may binabasa. No. Wala akong binabasa or may binabasa ako. It's just personal preference. Each lawyer has his or her own style. As you can see, some lawyers kahit may binabasa, ang ganda naman ng delivery and very coherent. So, it's really irrelevant kung may binabasa o walang binabasa. It's just a matter of preference for each lawyer. Go ahead. Well, right now, as I said, we're just shifting gears because I think after Director Matibag, we will proceed with Article 1. So now, of course, we're focusing on Article 1. Although we're prepared for it, syempre, as the trial goes, parating naman may fine-tuning yan here and there. So that's what we'll be focusing on. Siyempre po, kung ano man yung naging posisyon natin, sana we were able to justify it. We were able to show that, the issue on relevance, we discussed the issue on relevance, we discussed the issues on the various laws that prohibit certain disclosures. But whatever happens, we'll take it as it is, and we always submit ourselves to the wisdom of the court. And then also, kung hindi man natin magustuhan, there are always going to be legal remedies available. Well, sir, it's too early to say. Wala pang decision. I don't want a clickbait soundbite, So I'm not saying anything right now. Those are all on the table, but there's nothing has been discussed. It's too premature, and plus, all of these things will have to be discussed with our client. I think so. Pag motions. No, I believe so. Again, sir, I've already mentioned. I don't want a clickbait. I'm sure everyone's asking for a soundbite, and I'm not going to give you that soundbite. Thank you.
What is the pleasure of Senator Judge Padilla? Yes, sir.
Magandang tanghali po sa ating tagapamahalang hukom.
Magandang hapon din po.
At sa atin pong Ginoong Pangulo. Nais ko lamang po magbigay ng isang maiksing manifesto.
The gentleman has 2 minutes.
Maraming salamat po. A'udhu billahi minasyaitanir rajim. Bismillahirrahmanirrahim. Mga mahal kong kasama, nais ko lamang pong idulog sa inyo ang aking nararamdaman, ang isang damdaming masasabi ko pong nagtatanong sapagkat ang mga nangyayari po sa ating hukuman sa mga oras na ito, hindi ko po alam kung ito ba ay eksakto lang na nangyayari o ito po ba ay sinasadya. Katulad po ng pagkakakulong ng ating dalawang senator judge na si Senator Jinggoy Estrada at si Senator Rodante Marcoleta. At ang kagiyat pong pagdating ng aming mga masasabing galing sa ombudsman, sa akin, at kay Senator Alan Peter Cayetano. At kahapon, pagkatapos pong ng isang araw na mabanggit ang patungkol sa pagpunta ng ating mahal na NBI Director sa Bangkok, at ito po ay kinwestiyon ni Senator Alan Peter Cayetano, kahapon po ay biglang lumabas ang isang pahayag na iniimbestigahan daw po yung patungkol sa pangyayari noong Southeast Asian Games. Ito po ba ay eksakto lang o ito po ba ay merong dapat tayong pangambahan? Sapagkat alam niyo po, ako din po ay dapat ay pupunta ng Iran. Sapagkat isinagawa po ang pagbibigay-pugay sa namatay na kanilang leader, spiritual leader. Pero hindi po ako tumuloy dahil may impeachment po tayo. Tanong ko lamang po sa ating mga kasama, dapat po ba tayong mangamba? Dapat po ba kaming manggamba? At tayo po ay parang eksakto naman lahat ito? Hindi ba po tayo ay malayang korte? Tayo po ay may karapatan na binibigay ng konstitusyon na magsagawa po ng pagdinig na ito. Yun lamang po. Maraming salamat po, Ginoong tagapamahalang hukom.
The manifestation of Senator Judge Padilla is noted. What is the pleasure of Senator Judge Cayetano?
Mr. Presiding
Alan?
Officer, Rule 6 of the impeachment proceedings is that the rules of the Senate is suppletory, and if there is anything that affects the honor, integrity, or the functions of us individually or as a Senate here as an impeachment court, someone can rise on a question of personal or collective privilege. I won't do that, but may I just respond to what Senator Padilla said, since my name was mentioned and since the investigation announced by the NBI yesterday seems to be pertaining to this person as chairman of the 2019 Organizing Committee of the Southeast Asian Games. May I, maybe in the form muna of manifestation, unless the presiding officer or Senate President thinks that I should elaborate on by asking for time on a personal collective privilege, but I don't want to start that
Senator
precedent.
Judge Cayetano may make his manifestation. For the record, sir.
So, first and foremost, sa sinabi po ni Senator Padilla, I won't ask na ipa-play na yung video, but quite exhaustive yung sinabi ni NBI Director about the Southeast Asian Games. So, if the intention was to have a chilling effect, we already have that chilling effect. May 11, hinabol dito sa session hall na to ng mga ahente ng NBI si Senator Bato. May 13, nagkaroon ng enkwentro, putukan, pinipilit ng NBI na hindi sa loob ng Senado, but we have all the evidence that it was inside the Senate. Other incidents, I do not want to evoke a reaction or debate because I want to respect my fellow senators. Much of this has been vented in the media, is in court. Director Matibag has promised us that he will give us a warrant issued by the ICC, has promised us that he will hold his agents na nanggulpe ng isang OSAA. He will be the one to implement the contempt order and hold them in his office, but wala ditong natupad. So when I mentioned his name, his position the other day that it was bad taste, walang personal yun. I mean, regardless kung sinong, even if it was a secretary, an alter ego of the president who wrote the prosecution team or the defense team to say, pwede bang next week kasi may seminar, I would have said the same thing, di ba? Na, look at the gallery. Kompleto parati dyan from Congressman Ace Barbers to many Congressman Ridon. I won't name all of you, but you're busy people. But you think this is important, so you take time out and you are here. Di ba? Of course, the prosecution team, you have to be, you are here. We are here, despite of many, many other important things. Not only investigations, not only the flood control, not only the BIR, not only, we're also talking about the nation being prone to volcanic eruption, to yung bagyo, buti, nasalanta pa rin tayo ng bagyong Inday. Ibang Inday ang pinag-uusapan natin dito sa impeachment. But still, we are here. So it was in good faith that I said, as an example, mukha namang masama kapag kayong isang bureau head. NBI director is a very important position, but it is a bureau. So if a bureau head, and tignan yung invitation, nakalagay sa invitation, or your representative, and we resolved it. So aksidente ba na yesterday, suddenly after I mentioned it, and after during the weekend, many have been talking about na dapat ata hindi 16. So 21 na lang kami ngayon eh. So 2/3 of 21 is 7. Pag nabawasan pa kami ng 3, 13 na lang yon. Pero some will argue, mabawasan lang kami ng 1 o 2, baka 13 na rin yon kasi wala naman half person o 3/4 person. So all of these issues are valid. Question, the chilling effect is there, but am I intimidated? Wala na akong choice. Ilalabang ko na to, gagawin ko yun ang dapat kong gawin. Bumaliktad man yung sitwasyon, si President Marcos ang ini-impeach and I felt a certain way, ilalabang ko rin. Chief Justice man ang i-impeach, ilalabang ko rin. But for the record, Mr. President, go ahead and investigate. First of all, that's been investigated many, many times. COA, I'm not sure. I think the Office of the Ombudsman, ang nag-file pa ata, Chief of Staff mo eh. Senator Rob, I'm not sure, but parang may kaso na nun. Senator Drilon quizzed us here. I was Speaker of the House, but I chose to appear before the Senate to be able to answer all of those questions directly. The SEA Games, paulit-ulit yan. Biktima na ng speakership ng 2019 yan. Nahuli namin yung PR na sinabi, kikiam, pinakain daw mga Muslim ng baboy, when it was chicken longganisa na pinakain. Pero nasiraan na tayo sa Malaysia, Indonesia. The SEA Games gave us so much honor. So far, it is still the biggest SEA Games in history. Many of our athletes launched their career, even going to gold medals in the Olympics. Our athletic and our yung aquatic natin center in Clark is one of the best in the world. Ang nagsabi nito yung Israeli coach ng isang foreign team doon. But go ahead if you want to investigate. But I just want to put on record, mukhang misfire. Bakit? Yung sinasabi niyang infrastructure na walang bidding, first of all, the procurement law has many modes of procurement. So don't make it appear sa public na just because walang bidding, may anomalya na to. Okay. Secondly, bakit ko sinabing misfire? Hindi po sa I'm referring to Director ng NBI Matibag. I had nothing to do with the infrastructure. The chairman of the committee. In fact, I had to resign from the DFA because I was running for congressman during that time. So dun sa sinasabi ni Director Matibag na may congressional insertion to fund it, it's definitely not me because how could a non-member of the Senate or non-member of the House insert anything? Okay. Dun sa sinasabi niyang infrastructure, it was done by the BCDA. The chairman of the BCDA is one of the closest advisors of the president now. The president of the BCDA is one of the closest advisors and is a secretary now. And he said, medyo kaduda tong kumpanya na nanalo walang bidding. If I'm not mistaken, it's the same company who's making the City Hall of Pasig. Ha? So, I mean, if they want to investigate, go ahead. But by mentioning the organizing committee of the SEA Games, ako po chairman nun. At paninindigan ko po na napakaganda nung nangyari doon. At kung may anomalya, ako unang magagalit. So, go ahead. But my point, Mr. Chairman, honorable members of the court, sa prosecution, to be fair sa prosecution at marami akong kaibigan, I've never felt any intimidation from any of you. I mean, you've continued to be either friends or for those who are former friends but friends. I mean, I don't know if nagkamali lang ako, but on the first day, I nodded ng konti kay Senator De Lima. Gumanon din siya, hindi ko alam kung na-acknowledge because we were friends once upon a time and this is a court. We owe it to each other to be professional, di ba? So wag tayong pumayag na someone like Director Matibag would do that. My point, Mr. President, Mr. Presiding Officer, he could have not announced it and investigated. Imbestigahan mo, tingin mo may mali, imbestigahan mo. But it is unfair to me and unfair to the court that kung kailan siya patatawag siya sa Monday, intimidate mo ako, hindi kita tatanungin sa Monday dahil mag-a-announce ka na iimbestigahan mo. Tapos sasabihin mo may insertion, tapos sasabihin mo hindi liquidated po lahat yun. So, let me talk of unfairness. Hindi ba unfair? Kung ako, babaliktarin ko, sasabihin ko, inimbestigahan ko na rin kahapon eh. Ang sabi sa akin, mainit ang ulo ni Director Matibag kasi may contractor na daw yung binigay na lupa para sa NBI at gusto niya sarili niyang contractor. Or would that be fair to him? No. It would be a marites accusation. So that's the same thing he announced yesterday. A marites accusation towards me that affects this court because I am now a senator judge. So I hope this is the last time that I'm going to have to speak about this. But definitely, we've been speaking about this, binabawasan talaga kami. Iniisa-isa. Even yung mga vlogger na malapit sa administrasyon, sabi, 2 down, 3 down, may kasunod na. Di ba? So, Mr. President, I want this impeachment to be a test that the 1987 Constitution works and that despite political differences, the prosecution and defense, I saw them after the first or second day, nagkakamayang kayo, nagkakamustahan. After the first or second day nung mainit na baliktaktakan dyan sa pre-trial, nagbabatian, di ba? Even in court. So we can't help but be emotional. We can't help but get mad at what we think is disgusting or sometimes crossing the line. But is there any question that for this verdict, whether it's for conviction or acquittal, to be accepted by the Filipino people, we have to make sure that the integrity of the court is intact. I will admit to you, nahirapan po ako. Wala si Senator Marcoleta eh. Iilan lang po kaming abogado dito. Si Senator Pangilinan, Senator Cheese, si Aimee is a law graduate, di ba?
Pia.
Senator Pia, Bam is a second-year law student and I'm encouraging him na tapusin niya. Total review na yung nangyayari ngayon. But it's not easy. 24 lang kami, nabawasan na ng 3. So I hope this issue of the integrity of the court becomes an issue for all of us. No, I'll repeat what I said when I was Senate President. Director, hindi mo kami natibag. So wag mo try itibagin tong representation na to o itong impeachment court because what you're doing is not helping. You investigate whatever you want to investigate. You want to investigate ba't ako nagpatubo ng balbas? Investigate mo, no problem with me. Pero wag mo nang i-announce kasi nga naaapektuhan yung integrity ng court. Thank you for the leeway, Presiding Officer.
Thank you, Senator Judge Alan Cayetano. Yes, what is the pleasure of Senator Judge Pia Cayetano?
Mr. President, Presiding Officer, I assume most of my colleagues, like me, were busy studying the lengthy memorandum filed by each of the parties. For the record, 30-plus pages, more or less double space yung sa prosecution. Kaya by the time I got to the defense, para na ako maduduling kasi mahaba na nga yung 30 pages na double space. Napunta pa ako sa single space. Okay lang yun, kasama sa trabaho yun. Pero that's how lengthy the documents were. And I slept at 2 a.m. Hindi kasama to sa explanation ko. Di ako nagyayabang or anything. It's our job. And I'm a night person, so normal sa akin yun. And then in the morning, tuloy ulit. Sent my staff questions, asked for more details, and then we worked together throughout the morning until it was time to come here. So I don't know anything about this statement of Director Matibag. But it bothers me to hear this. I now remember that I saw a message pop up in my phone which hindi ko nga pinansin kasi nga ito yung important issue ko na pag-aralan ko tong memorandum ng mga parties na inabala nga naman nilang very lengthily and exhaustively na nila dinidiscuss in a written document. But I recall now na may nag-pop up na message from a coach telling me na gustong pa-imbestigahan yung SEA Games. And di ko talaga pinansin. And now Alan brings it up and I am bothered. There is no jurisdiction in the world that allows a judge to be pressured and intimidated. And I ask each one of you, my dear colleagues, payag ba tayo sa ganito? Ganito na ba tayo dito ngayon? Don't we want a better country for our children? Why would you allow a director who's just called to be a witness next week brag that he's going to investigate? And again, I don't know. So I respectfully request that it be played. Because I want to understand. If I don't have reason to be upset, then thank you, I can focus. I can go back to the business on hand. But right now, I am upset to hear this. And I will stand up for each one of you. I don't care what side you're on. I will stand up for you if somebody tries to intimidate you. So with all due respect, Mr. Presiding Officer, I ask that we play it. I want to see what this witness is doing.
Presiding Officer declares a brief recess. Trial is... Trial is resumed. Chair grants the motion of Senator Pia in order for us to be able to move on with the matter on hand for today, which is the oral arguments of the parties. Chair therefore instructs the tech to kindly play the 1-minute video for Senator Judge Pangilinan is recognized.
Thank you, Mr. Presiding Officer. We share, we support the position taken by the presiding officer, but we'd like to place on record that the good NBI director will be here on Monday. So my initial view is that we should be able to do this on Monday, but I will yield to the ruling of the chair, Mr. President.
We thank the understanding and magnanimity of Senator Judge Pangilinan. The tech is instructed to play the more or less 1-minute video alluded to and requested by Senator Judge Pia Cayetano.
Meron kaming mga kaso na pumasok na bago na dapat namin tingnan. Kung maalala nyo, pumunta kami ng Clark because we were given 70 hectares for the NBI Academy. So magkaroon kami ng relationship sa Clark. Nakita namin dun yung parang sports complex na ginamit ng SEA Games, yung sa Philippine SEA Games Organizing Committee. Well, nakarating sa amin, may titingnan kami rito, may kailangan kami imbestigahan dahil nakarating kami rito, bilyon-bilyon pala yung pumasok dito na pera na unliquidated. At merong private company rito na na-involve na binayaran ng 10 billion at ang pagbabayad insertion sa GAA na hindi binayad. So ito, imbestigahan namin to. Malaking kaso rin ito.
Yung may parang podro?
Ay, iba pa yun. Yung sa Caldero na kaso, I think it's ongoing, pero sisilipin na rin namin. Ito yung tungkol doon sa, it's a Malaysian company na sila yung nag-build ditong sport area na to. Walang bidding, tapos nabayaran ng mabilisan na 10 billion yung halaga, congressional insertion. So, sisilipin namin to. Katunayan, meron kaming mga kaso na pumasok na bago na dapat namin tingnan. Kung maalala nyo, pumunta kami ng Clark because we were given 70 hectares for
Senator Judge Pia Cayetano is recognized.
Rest assured, Mr. Presiding Officer and dear colleagues and parties, I will not belabor this point. I will not stay long. But clearly, from the statements of Director Matibag, malaki daw kaso to. Naimbestigahan na niya? Alam niya ng malaking kaso? Paano niya nalaman? So sa akin lang, Mr. Presiding Officer, simple lang eh. What was the intention here? To distract the minority floor leader, who is one of only 2 lawyers right now, because our other lawyer was already carted off somewhere. So dalawa lang kami. So you wanna distract him. So ako na lang ang tatayo dito. Hindi na siya makakapag-aral. Yung ba intention? Because it is clearly the intention. The fact that he has to stand up, the fact that I have to stand up, the fact that Senator Robin has to stand up, he is distracting us from our job. As Senator Alan said, he could do it quietly. Go ahead. Anong purpose niya? Nagyayabang siya? What's the purpose? Is he trying to intimidate us not to ask him tough questions when he is our resource person next week? I do not know. But those statements, those actions are not acceptable, possibly contemptible. So I ask the presiding officer and you, my dear colleagues, let's think about this clearly. I will stop now. As Senator Pangilinan said, we can take this up on Monday. Salamat na pinagbigyan niyo ako na mapanood natin at pag-isipan natin. Na gano'n na lang, pag may pinatawag tayo sa witness stand, abangan natin na magpe-press na kung ano-ano pagsasabi tungkol sa atin. I didn't have enough time to research. But clearly, I know that there's jurisprudence that does not allow a judge to be intimidated. And if hindi pa nanakot yun, then I don't know what is. Kung hindi pa ninindak yun, then I don't know what is. Hindi tayo sensitive. Sanay tayo dito. Pero alam din natin kung pinapatamaan tayo, di ba? Alam natin yun. Hindi tayo tanga. O so paano? Sabihin ko ngayon sa kanya, manda ka sa akin ngayon. Pagdating mo, ganun ba? Gaganti na lang ako. Hindi ako ganun. Kilala niyo ako. For how many years ako tumayo dito? Hindi ako nanggaganti. Hindi ako mababaw. Pero I'm asking you, dear colleagues, wag tayong papayag. The Filipino people deserve better. We deserve better. Thank you.
Thank you, Senator Judge Villa. What is the pleasure of Senator Judge Alan Cayetano?
Yes, I didn't know we were going to play it, but just for the record, there's no issue with the Qualdron because it was paid by the private sector. There was no public money used, and it was designed by the firm of a national artist. So much so that that same firm, I don't know when we started to hire them, whether it was the time of Senator Lacson as the Committee of Accounts for the new Senate building or the time of Senator Nancy. But until now, there's engagement. So it's so easy to find out. No? But can I shift to the topic at hand? Just one manifestation for the whole Senate regarding the oral arguments.
We have not yet called the journal and called the court.
Yes. So at the
case.
proper time, I just want to...
Yes, you may do so at the proper time. Proceeding now, if there are no objections, the presiding officer will dispense with the reading of the July 14, 2026 Journal of the Senate, setting as an impeachment court, and shall consider the same as approved. Clerk of Court will please call the matter before the impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances for the parties.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor.
Appearances for the respondent.
Good afternoon, Your Honors. I'm Michael Poa. Same appearances for the defense and for the respondent accused, Your Honor.
Before recognizing the counsel for the prosecution for their 15 minutes for their presentation and oral argument in relation to their motions for the issuance of subpoena for banks, AMLC, and the BIR, Chair would like to recognize Senator Judge Alan Cayetano for his manifestation earlier. Alan? The Senator Judge intimated earlier that he had a manifestation before we proceeded.
Yes, this is really to be fair to the prosecution and of course to the defense. One of us. So yesterday I asked whether or not mag-oral arguments today, and then I'd like to thank the Senate President and of course the presiding officer and all our colleagues. No, Senator Soto, although magkatabi kami, hindi kami magkatabi, but I saw him agreeing that we should have a caucus and discuss this. Hinimay ko lang very preliminarily, if we're going to look at issues, for example, relevancy lang, you have about the banks, you have AMLA, AMLC, you have BIR. Then for each one of them, so for example, for the banks and AMLC, you have peso accounts and dollar accounts. Then for each one of them, you have the account of Vice President Sara, but also of the spouse, and then possibly of the companies, same sa BIR. So, although I do believe that we have exclusive jurisdiction, sometimes the Supreme Court have defined certain parameters that we either have crossed or not. So if we're going to vote, one vote, whether or not to allow these subpoenas, it would be unfair to everyone. For example, me, I cannot vote unless I see na walang problema sa lahat, then no problem, let's vote, pwede. Pero kung sabihin kong walang problema sa banks at AMLA, may problema sa BIR. Walang problema sa BIR, pero sa spouse, meron. So, we're gonna have a caucus, and I'm sure we're gonna have a good discussion on that. But just two things. Number one, can we give, of course, we'll follow the time today, but if any of the two, the prosecution or for example, in the rebuttal, after the rebuttal ng defense, makikita na ng prosecution saan talaga nag-object yung defense, hindi lang sa lahat. If we can give them a little bit more time, kasi nga, mahabang discussion to. Having said that, I'm more than okay if we have to have an extra day next week, whether to discuss among ourselves or I'm not preempting our caucus. I'm just saying, Mr. President, that I commit to you, I will not delay, I will not overtalk on these issues, and I don't think controversial each and every one of this yung request for subpoena dito, but there may be one or two, and I don't think it would be good for us to lump it in one issue if there are different legal issues. The law, there are similarities in the law, but there's a different law governing AMLA, there's a different law for the bank secrecy, there's a different law for BIR. So, thank you, Mr.
Chair notes the observation of Senator Judge Alan Cayetano. However, subject, of course, to any agreements that will be arrived at in caucus, we are constrained by the motions filed by the parties. There are only two pending motions that this court should act upon. Number one, a motion for the issuance of a subpoena with respect to bank and AMLC records on the one hand, and number two, a motion for the issuance of subpoena for BIR records. Understandably, there are sub-issues underneath each, but we cannot put a vote each and every sub-issue under each motion. So we will most likely, the chair would suggest, put it to a vote by the motions that have been filed by the parties, whether or not to grant it or to deny the motion filed by the prosecutors rather in this case. Again, subject, of course, any agreements we might arrive at in caucus, Senator Judge Alan, and the chair will submit to that. Now, as earlier agreed in yesterday's proceedings, the prosecution will be given 15 minutes for their chief arguments. Likewise, the respondent will be given 15 minutes, and then thereafter, the prosecutor will be given 10 minutes by way of rebuttal, and the respondent will be given 10 minutes by way of rebuttal. May I ask who among the prosecutors or counsel for prosecutors will argue the motion for the issuance of the subpoenas for the banks, AMLC, and BIR?
Your Honors, the prosecution will be represented by the Honorable Representative Chel Jokno for the purpose of this oral argument. Nonetheless, Your Honor, we have some manifestation to make for the prosecution.
The lead prosecutor may proceed. This is pertaining to the matter on hand.
This pertains, Your Honor, to the remaining witnesses for Article 4 threat.
Can we discuss that later before we adjourn, lead prosecutor?
We submit, Your Honor.
Thank you. On the part of the respondent,
The part of
who
the
will argue?
respondent, Your Honor, I will be the one arguing today.
For the record, kindly state your full name, Attorney Poa.
My name is Michael Wesley T. Poa, Your Honor. Thank you.
Your Honor, we're requesting that Congressman Chel Jokno be recognized.
For the prosecutors, the Honorable Representative from the party list Tacbayan, Chel Jokno, is recognized for his oral arguments on the motions, twin motions that they filed. You are recognized, sir, and you may proceed when you're ready. You have 15 minutes.
Thank you, Your Honor. Good afternoon, everyone, to the members of this honorable court. May it please the court. Simple lang po ang isyong kinakaharap natin ngayong hapon na ito. Pero napakabigat. Bubuksan ba natin ang pinto ng katotohanan o haharangin ito? Ang hiling ng prosecution ay mailabas ang buong katotohanan so that this court may know the truth, the whole truth, and nothing but the truth, and make its decisions based on that. That is why we have requested the issuance of subpoena duces tecum for the bank records, tax records, and anti-money laundering council reports relating to Vice President Sara Duterte and her husband, Attorney Mans Carpio. Sa pamamagitan nito, may lalahad ang buong katotohanan tungkol sa mga alegasyon sa Article 2 ng Articles of Impeachment. Una, na pinayaman ni Vice Presidente ang kanyang sarili ng labis-labis sa kanyang legal na sahod at lehitimong kita bilang isang lingkod bayan. Pangalawa, na meron siyang mga ari-arihang hindi dineklara sa kanyang Statement of Assets, Liabilities, and Net Worth. At pangatlo, na habang siya ay nanunungkulan bilang Vice Presidente, nakibahagi siya sa negosyo, directly or indirectly, kahit ipinagbabawal ito ng ating konstitusyon. Sasabihin marahil ng depensa na walang kapangyarihan ang hukumang ito na busisiin ng mga bank records, tax records at AMLA reports ni VP Sara. With all due respect, that argument is not only legally flawed, it is an affront to the authority of this honorable court. Kung tatanggapin po natin ang argumentong ito, hahayaan natin maliitin at insultuhin ang hukumang ito. The Constitution, Your Honors, please, vests this impeachment court with extraordinary powers. Tanging ang hukumang ito lamang ang may kapangyarihang magpasya kung ang mga pinakamataas na pinuno ng ating bansa ay karapat-dapat pa rin manungkulan. Because this power comes directly from the Constitution, no one, no person, no law, no administrative rule can limit or supersede it. I repeat, nothing and no one can handcuff this court's power to try and decide this impeachment case. Kahit ang bank secrecy law po ay sumusunod at tumatalima sa impeachment court. The law explicitly states, and I quote its pertinent portions, all deposits are hereby considered as of an absolutely confidential nature except in cases of impeachment. Walang kaduda-duda, may karapatan at kapangyarihan ng impeachment court na busisiin ang mga bank records ni VP Sara. Hindi rin po hadlang ang Data Privacy Act. The law itself affirms that confidentiality shall not apply, and I quote, should the personal information be needed pursuant to a subpoena duly issued. Muli, walang kaduda-duda. May karapatan at kapangyarihan ng impeachment court na ipasabpina ang mga dokumento ni VP Sara Duterte. Pero sabi po ng kampo ni Vice President, irrelevant daw ang mga bank records, AMLAC reports at BIR records. Lalo na daw yung mga transaksyon na nangyari bago siya umupo bilang pangalawang Pangulo dahil wala raw itong kinalaman sa kasong ito. The prosecution respectfully but vehemently disagrees. Ayon sa report ng Anti-Money Laundering Council na isinumite sa Committee on Justice ng House of Representatives, the financial activity of Vice President Sara C. Duterte increased significantly starting 2007 when transaction value surged to 208.15 million pesos. According to this report, which is marked as Exhibit P-2-7-8, I quote, financial movements intensified between 2009 and 2013 with consistently high totals exceeding 400 million pesos, including notable peaks in 2009, 704.93 million pesos, 2010, 648.58 million pesos, and 2011, 597.15 million pesos. Si VP Sara po ay nanungkulan bilang Vice Mayor ng Davao City mula 2007 hanggang 2010. Naglingkod naman siya bilang Mayor ng Davao City mula 2010 hanggang 2013. From 2007 to 2013, ayon sa records ng AMLAC, lumampas sa 3 billion pesos ang kanyang financial activity. May kinalaman ba ito? Ito ba ay relevant sa Article 2 ng Articles of Impeachment, which alleges, among others, that VP Sara betrayed the public trust and culpably violated the Constitution when she amassed unexplained wealth manifestly disproportionate to her lawful income? Para sa prosecution, malinaw ang sagot. The Vice President's financial activity as Vice Mayor and Mayor of Davao City relates directly to the main fact in issue in this case, her fitness or unfitness to serve as Vice President. Let me explain. The framers of the 1987 Constitution added betrayal of public trust as a ground for impeachment, and I quote, to include all acts which render the officer unfit to continue in office. For this honorable court to determine whether VP Sara Duterte is unfit to continue in office, it must have a clear picture of the respondent as a public servant. Kailangan makita ng publiko at ng mga senator judge ang tunay na kulay ng Vice Presidente at larawan ng kanyang buong pagkatao bilang isang. If she amassed staggering amounts of unexplained wealth while she was a vice mayor,
by Mr. Calilong and Lotok. On the part of Mr. Calilong, the House Prosecution Panel was able to establish again the facts surrounding the digital evidence na presenta po sa korte. Ito po yung nakita natin, nagbanta ang Vice Presidente laban kay Presidente sa unang ginang at sa former Speaker of the House of Representatives. Tinahi po ito when Attorney Lotok again, sufficiently corroborated the testimony of Mr. Calilong with prima facie evidence to proceed with the filing of the complaint for preliminary investigation with a reasonable certainty of conviction. Again, both testimonies were not refuted. So nandito na po tayo sa punto wherein we are approaching the end of Article 4. Our last witness that we will present tomorrow will be Director Matibag. Para po masagot at matahi yung mga hanging questions na tinanong po in the previous 2 weeks last week kay Mr. Lotok. So ito po yung magiging finale nitong Article 4, ang presentasyon ng House Prosecution Panel kay Director Matibag at ang pagbibigay po niya ng information, facts surrounding the preliminary investigation conducted by the NBI. So inaasahan po natin bukas ay maririnig po natin ang testimonya ni NBI Director Matibag. Jay?
Morning everyone. Thank you for joining us today. So as you would recall also, during the last hearing last week, last Wednesday, the parties engaged in oral arguments to advance their respective positions with respect to the prosecution's request for the issuance of subpoena to compel the presentation or the submission of the various financial documents of the Vice President and her husband, as well as their financial interest. This includes their BIR filings, the AMLAC records, and bank records. So, as you know, during last week's hearing, the parties, after they presented their oral arguments and their rebuttals, the impeachment court decided to continue the oral arguments today to allow the senator judges to ask questions, no, to either of the parties. With respect to this matter, no, we just want to emphasize the importance of today's proceedings. Unang-una ho, gusto namin klaruhin, ang hinihingi ho namin dito ay presentasyon pa lang ho nitong mga official records na to. Wala pa hong mangyayaring paghahatol dito, no? At hindi pa rin ho ito pagtanggap ng ebidensya. Ito pa lang ho ay para mabigyan ng pagkakataon, no, na mapresenta itong mga dokumento na to at masuri ng magkabilang panig. As we've emphasized before, these financial documents are very important, no? Particularly with respect to the Articles of Impeachment on Unexplained Wealth, no? Or the Article 2. Dahil sa pamamagitan ng mga dokumentong ito, dito ho natin makikita yung complete financial standing ng Vice Presidente. No? Again, we have to emphasize, ang hinihingi ho namin dito ay subpoena. Ano hong ibig sabihin ng subpoena? In particular, subpoena duces tecum. Ito ho ay order issued by the impeachment court, no, to compel these different government agencies as well as the banks to submit these very important financial records. Okay. Tulad ho ng nasabi namin dati, napakahalaga ho na maikumpara natin ang buong yaman na dineklara ng Vice Presidente sa kanyang SALN or the Statement of Assets, Liabilities, and Net Worth, no? At ikumpara ito dun sa kanyang mga BIR tax filings. Ano ho ito? Ito ho yung taon-taon na sinasubmit, no, ng lahat ng tao na nagtatrabaho or may lawful income para sabihin for any particular year, ito yung kabuuang kita ng taong ito. So, in other words, sa kanila ho ito nanggaling. These are sworn documents. Sila ho ang nag-submit ng mga dokumento na to. Pagkatapos ho, with respect to the AMLAC records, we would recall that these matters were actually presented already by the executive director of the AMLAC, which showed that the Vice President had financial transactions amounting to around 6.7 billion pesos. Ngayon, itatahi din ho ito dun sa mga bank records para makita naman magkano talaga ang linalaman ng mga bangko, no, ng Vice Presidente. So dyan ho, kaya ganyan ho na napakahalaga ng mga dokumento na to para maikumpara natin ano ang dineklarang yaman at ano ang totoong yaman at ano din ang legal na kita. Dahil ang posisyon ng prosecution, as stated in the Articles of Impeachment, napakalayo ho, no, ng disparity nung dineclare na yaman at ano ang totoong yaman.
Right, with that, we are ready to accept your questions. Haji?
Good morning po. May mga nag-rally po sa labas. I don't know kung nakita po ninyo. I think yung Bantay Senado po yata yun and other groups. They're calling on the senators na payagan na po yung pagpapasubpoena doon sa tax and bank records. Sabi po nila, pag hindi po nagawa yun, mawawalan daw po ng saysay yung kabuuang pagliliti. So parang ang call po nila is kalampagin yung mga senators, sulatan, mag-post sa social media, etc. But do you share the same sentiment with the groups na yun nga po, mawawalan daw po ng saysay kapag hindi po hinayaan na mabuksan yung mga records po na ito, syempre in pursuit of accountability?
Well, sa una, I think the Filipino people understand what is at stake here. Dito sa usaping na impeachment trial. Ang at stake po dito ay yung ating saligang batas talaga at yung pananagutan kung saan binigyan ng kapangyarihan ng saligang batas ang Senado, katangi-tanging kapangyarihan, exclusive power to try and decide impeachment complaints. na magiging importante or indispensable para ito po ang mag-arrive into a fair, impartial, and sound judgment based on the evidence that they have to obtain. Yung sinabi po ni Attorney Jay kanina, ito po ay pagbibigay access para po yung subpoena na po yun, makuha po itong mga material na ito na very important for the court to have a accurate basis for them or reference for them to arrive into a conclusion, a sound and impartial conclusion. Kaya nga po kami sa House Prosecution Panel, nakikita natin yung ano yung nagiging reaksyon ng taong bayan. Dahil alam nila, naintindihan nila na ito lang yung paraan kung paano ang Senado ay mabigyang yung kanilang magiging pagsusuri ay it will lead also to them not only resolving the case but also to exercise yung kanilang katangi-tanging kapangyarihan. The truth shall set us free. And I'm not mentioning this based solely on religious tone. Ito, naiintindihan po ito ng ating taong bayan. And if we go back to our experience in the past, yung nangyari po dun sa kay Estrada impeachment trial, yung taong bayan dahil it was not, the envelope was, it was not opened, the people felt betrayed because of the blocking of the opening of the second envelope. And yun po yung kanilang, yun po yung nakikita po natin na kung saan po sila, ang ating taong bayan, nanggagaling. No? So, tayo naman po, dahil ni-request naman po natin itong sa mga documents na ito, ay naiintindihan po natin ang ating taong bayan, yung clamor nila, yung demand nila for accountability, yung demand nila for the Senate acting as impeachment court to exercise that extraordinary power and not to allow the fundamental law of the land be subservient to ordinary laws. No? Kasi ang nagsasabi naman po dito ang ating saligang batas na ang kapangyarihan ng Senado. So kung ano po yung mga batas na mention po in the oral argument by the defense, these should not be reasons to curtail the right of the Senate acting as impeachment court because the basis for them to exercise this power is granted to them by the fundamental law of the land, which is the 1987 Philippine Constitution.
I may also add, naririnig namin at sumasang-ayon kami sa panawagan at paniniwala ng ating mga kababayan na napakahalaga na makita itong mga dokumento na to para makita natin ang kabuuan na yaman ng Vice Presidente at ito ang paraan para makita natin yung katotohanan, paukol sa bagay na to dito sa Unexplained Wealth. At alalahanin din natin, bukod sa napaka-importanting rason na kailangan ito para makita ang buong katotohanan, our request is based on strong legal grounds, as articulated by Kong Shell Jokno during the oral arguments. Matibay ho ang basehan namin dito. It's grounded in the Constitution, the special laws governing this specific financial documents. It's based on jurisprudence and impeachment precedent, tulad ho dun sa nangyari dun sa impeachment proceedings ng late Chief Justice Corona. At malahag ho din siguro na I have to point out, again, dun sa proceedings before the House of Representatives, pinakita itong mga AMLAC records which disclosed that the Vice President and her husband had financial transactions amounting to 6.7 billion pesos. I have to emphasize that, 6.7 billion pesos. Ano ang naging tugon nila dito? Ang naging explanation ng kampo ng Vice Presidente ay these numbers were supposedly bloated, dahil lang sinasabi nila, pwede dito, may pumasok, same na pera, lumabas ulit at pumasok na naman. Kaya naka-reflect daw siya dito sa mga AMLAC reports na to. Pwede din ho daw na interbank transfers, meaning from one bank account ng Vice Presidente, linipat lang sa kabilang bank account niya. Let's remember, in the SALN, the total net worth that was declared was only 80 million. If we're talking about 6.7 billion in financial transactions, gaano kadaming beses ho yan papalabasin at papapasok ng paulit-ulit. Now, kung ganun ho ang kanilang depensa, no? Hindi ho ba makakatulong para sa lahat at para din sa kanila na buksan itong mga bank records na to para once and for all masettle magkaano ba talagang linalaman ng mga bank accounts niya? No? Lalo na kung ang sinasabi niya ay ganyan ang paliwanag, no? Na itong same amount na to, lumabas-pasok, naging bloated itong mga figures stated, no, in the AMLAC reports. So, makakatulong ho ito sa lahat, no? Para din ho sa kanila. Kung yan ang posisyon nila, no? Para mapatunayan na talagang inosente sila sa charges na ito.
Just to follow up lang po. Nakikita niyo po ba na yung bigat na mayahalin tulad po siya doon sa envelope during the Estrada trial, yung galit po nung publiko, the same. Kumbaga, kung halimbawang hindi po, of course, hindi naman po ninyo pinapangunahan, ano, pero kung halimbawang hindi po mapagbigyan or mapasabi na yung mga tax at bank records po na ito, mayahalin tulad po ba ninyo yung bigat doon sa envelope na hindi po nabuksan nung Estrada trial?
Well, considering the gravity of what's at stake here, no, we will understand that kind of sentiment. Pero kami, we're hoping na hindi na ho tayo umabot doon. Totally, napakaliwanag naman, no, ng basehan kung bakit dapat buksan ito. No? Ito ay nakapaloob sa Constitution. No? Pati ho, itong mga special laws governing these financial transactions, pinapayagan din ho ang disclosure niyan. Jurisprudence supports it. And as I've stated, pati ho doon sa nakaraan na impeachment proceedings, pinayagan ho ito. So, nananalig ho kami na hindi na ho tayo umabot sa ganong punto. No? At our request will be granted based on those strong legal basis. Ano?
Ang gusto lang naman ng taong bayan, court, feeling nila na doble yung betrayal sa kanila. I think the people now realize that na ang deserve lang talaga nilang malaman. Not necessarily to convict the respondent, but to know the truth. No? Even if you try to analyze it on both ways, may karapatan din. Even yung mga supporters po ng respondent, Vice President Duterte, may karapatan din po sila malaman kung yung sinusuportahan ba nila ay totoo na wala siyang hinahide o tinatago na yaman. So very simple po ang ating panawagan ng ating taong bayan. Katotohanan at huwag supilin ang katotohanan.
Last na lang po talaga. Over the weekend, may mga sinasabi po no, si Senator Judge Alan Peter Cayetano with regards to NBI Director Melvin Matibag. Yung latest nga po, tinawag pa niya minion, etc. Do you expect po na pagsalang po niya bukas, hindi po ba mapepersonal na atake? I mean, hindi po ba mapepersonal si NBI Director Matibag instead of focusing on the kung ano po yung kanyang ite-testify on the grave threats? Thank you po.
What we would expect is Director Matibag to respond to the question by both panels. We would expect him to inform the court or appraise the court based on the knowledge that he has surrounding the preliminary investigation. So, yun po yung ine-expect natin. In fact, hindi lang ho ine-expect, yun po yung ipapakita natin sa taong bayan at ipipresenta sa korte. Now, kung ano man po yung mga other issues, I don't think it should that the House Prosecution Panel also should intervene in matters that are internal between and among individuals.
Yes, stated by Kong Adjong, we will leave it to the presiding officer to determine what questions that may be posed by the senator judges will be considered to be appropriate and relevant to the matter at hand. But again, insofar as we're concerned for the prosecution, we remain focused on making sure that NBI Director Matibag will be able to share all material facts with respect to the topic at hand, which is in dun sa grave threat. So he will be sharing the important investigation conducted by the NBI in relation to this matter.
Thank you po.
Hello po, Eden Santos, Net 25. Follow-up din po dun sa kay Director Matibag. Muli po kasing kumakalat ngayon sa SOCMED yung audio convo niya dun sa isang media personality na pinagmumura po niya at pinagbantaan na papatayin. Hindi po ba ito makaka-apekto dun sa kanyang pagtestigo, lalo na kung pwedeng basagin yung kanyang credibility?
Una, hindi ko po narinig itong video na to. Pangalawa, hindi po kami nagsasalita on behalf of for Attorney Matibag. Kung meron po siyang personal na dealing with any of the media personality, that is business, I'm sure Attorney Matibag, Director Matibag, has a reason, baka mayroon siyang rason kung bakit nagawa niya. Again, ang focus po namin is how to present him to the impeachment court base po sa kanyang knowledge, kaalaman doon sa preliminary investigation. Maliban lang po doon, hindi na kami magdodwell doon sa mga issues na kumbaga hinaharap po ni Director Matibag.
At the end of the day, importante ho dito, tignan natin itong mga peripheral issues na to. May kinalaman ba siya sa magiging paksa ng kanyang testimonya? Which is, ano ang investigasyon na ginawa ng NBI paukol dun sa mga pag-amin ng Vice Presidente na meron siyang naging kasunduan sa isang mamamatay tao na patay ng Presidente. Now, kung yung mga issues na yan, although we don't have personal knowledge about them, wala akong kinalaman yan, hindi namin nakikita kung paano ito makaka-apekto sa kanyang testimonya.
Kasi po yung defense posibleng maging isang way yun para basagin or tibagin yung credibility ni Director Matibag.
And that is their prerogative. They can try to do that. But at the end of the day, ang titignan natin at susuriin natin mabuti dito, ano yung ebidensya na ilalatag niya dito? All other matters are just noise if they have nothing to do with respect to the investigation that he conducted. So yun ho ang suriin natin, yung ebidensyang ilalapag niya kapag siya ay nagtestigo bukas.
Ang magiging participation lang po ni NBI Director is yung capacity niya o yung authority niya bilang the head of the NBI as an agency na sila po yung nag-imbestiga kay Vice Presidente, patungkol doon sa pagbabanta niya sa Presidente, sa unang ginang at sa dating former Speaker. Hindi ho magtatanong ang House Prosecution Panel o ipresenta si Director Matibag base po doon sa mga other na engagement niya with other individuals. Kung yun po yung gagawin, sabi nga po ni Attorney J, meron din namang strategy ang depensa. Pero ako, naniniwala ako na ang impeachment court, dahil meron silang Senate rules on impeachment, alam po ng mga nakaupong huwis kung ano yung mga paglatag ng tanong, ano yung mga relevant na tanong, ano yung mga hindi relevant na tanong. Alam naman po natin sa based on the 2 weeks na trial, merong mga katanungan na hindi relevant at sinasabi naman po ng presiding officer na hindi ito angkop doon sa pinag-uusapan sa trial, impeachment trial under sa Article 4. So kung ano po yung magiging katanungan nila, alam naman ng mga huwis na hindi naman talaga siya konektado doon sa pagte-testify doon sa investigation na nagbanta ang Vice Presidente, mukhang kami, naniniwala kami na ang impeachment court at ang presiding officer, dahil may Senate rules on impeachment, ay alam po nila kung ano i-call out ng relevant at irrelevant. Very clear po, irrelevant po kung ano man yung i-connect po nila na outside of the discussion under Article 4.
Are we expecting po na yung mga prosecutors natin, prosecutor natin ay tatayo din sa impeachment trial, or yung mga private prosecutors lang po talaga?
Actually, ilang beses na din nating nakita, no, naging aktibo sa paglilitis nito, mga public prosecutors. Magmula pa lang sa unang araw, no, magmula doon sa opening statement ni Chair Jinky Luistro, sa opening statement din for threats ni Kong Noy Defensor. Nakita din natin, nag-engage sa oral arguments si Congressman Shell Jokno. So we can see, no, that they're very active in these proceedings. At yes, sa mga susunod na linggo, bukod dyan, magpipresenta din sila ng mga testigo para sa prosecution.
Alright. Thank you, Eden. Now, Anne, your turn.
Sir, good morning. Ann Soberano po of Bombo Radio. Sir, kung mapagbigyan po ang inyong kahilingan na isubpina po itong bank records, can the Vice President still challenge the subpoenas if they are issued? Attorney Tolosa.
Well, this is a compulsory process, no, that will be issued by the impeachment court. And together with such a subpoena power, the impeachment court has also the authority and the power to enforce them. Whoever fails, no, or refuses to comply with the subpoena, well, they will have to face the consequences that come with it. No? Merong contempt power ang impeachment court para pilitin ho yan. Now, kung anumang iba pang legal remedies that she would want to try to avail of, nasa kanya ho yan. But ang importante dito, kapag inisyo ang impeachment court, kailangan ho yung sundan. No? Kahit, tulad ho ng kahit sinong tao, no? Hindi ho malagay yung personalidad, mahalaga yung proseso at ang batas. At sinasabi niyan, kailangang sundan kapag na-issuehan ho ng subpoena.
Sir, could the ruling be appealed or reconsidered?
They could ask for reconsideration of the impeachment court, no? And then that's also a matter that will be resolved by the same impeachment court. But to clarify, no, itong mga dokumento na to, they are not in the possession of the Vice President. They are in the possession of the AMLAC, of the banks, and the BIR. So, kapag ho ito ay granted, itong request for subpoena, ang susunod ho nito, hindi ang Vice Presidente. Ito hong mga institutions na ito ang magsusumite ng mga dokumento na to.
Last na po on my part.
Tatagdag ko lang, kailangan natin intindihin sa ating taong bayan na ang Vice Presidente ay hindi private individual. Ito po ay mga public records na inaasahan po bilang isang public official ay ibigay niya sa mga ahensyang nangangasiwa dito. So, kung pinag-uusapan po natin dito ay private individual, posible po, no? Ito si Attorney J, posible po din na magkaroon ng certain degree of restriction or confidentiality. Pero pinag-uusapan po natin dito yung kanyang fitness sa pagiging Vice Presidente. Kung ang kanyang nireflect doon sa SALN niya ay tugma ba doon sa kanyang binabayarang buwis kada taon, no? So again, it is imperative for the Vice President, knowing that she is the second highest official in the land and a public officer at that, occupies a public office which certainly, according to the Constitution and many other laws, should be, again, dahil pinag-usapan natin dito, impeachment trial, should be, again, resolved by the impeachment court as an institution that has the exclusive power to request for the records through a subpoena. So, yun lang po yung tatandaan natin at alam po ng taong bayan yun, na hindi po siya individual, na private individual, siya po ay isang public officer.
Thank you, sir. Thank you.
Hi, Kong Attorney. Good morning po.
Yung regarding po ulit dun sa request nating BIR and bank records, I understand magagamit po ito para sa unexplained wealth, tama po ba? Can we say that this is the strongest evidence na meron tayo for unexplained wealth? And if ever man po na hindi payagan, hihina po ba yung mga ebidensya natin?
Well, hindi naman nakabase sa iisa o dalawang ebidensya lang, no, yung ating Articles of Impeachment. No? We have other documentary and testimonial evidence. Gayon pa man, ang aim natin dito ay makita yung buong katotohanan. No? So regardless, if we have other evidence that could support the Articles of Impeachment, napakahalaga pa rin na makita natin itong mga ebidensya nito. No? In fact, regardless if you're pro or anti, the respondent, regardless of your leanings at this point, napakahalaga. Actually, dapat lahat tayo, hinihingi natin, tignan natin itong mga dokumento na to. Dahil kung naniniwala ka na walang paglabag sa batas na ginawa, all the more na dapat gusto mo ding makita to. Para once and for all, we could settle that question. Makikita natin, wala talaga itong mga tinatagong yaman na to. So, it's for the best interest of everyone involved, the impeachment court, na maghahatol dito sa impeachment na to, pati ang taong bayan, na makita natin pare-pareho itong mga napakalagang mga ebidensya na ito.
Very simple lang, no? Papayagan ba natin ang impeachment court na maghahatol basis sa hindi kompletong dokumento o ebidensya? Di ba hindi naman natin papayagan yun, ang taong bayan ayaw payagan ng ganong klaseng hatol na hindi sapat doon sa naipresenta na ebidensya. Yun lang, very simple lang po yun, no? Kailangan mabigyan ng pagkakataon ang impeachment court na masuri, makita ang lahat ng ebidensyang kinakailangan para po ang hatol nila ay kompleto. At hindi po base lang sa mga presumption. What if meron din palang ganitong klaseng dokumento na hindi natin nakita? What we do not want is to curtail the right of the impeachment court and also to probably preclude them from even arriving into a very partial, fair judgment. No? Hindi ho ito in favor of the prosecution. It can also be favor to the defense. It's not even a question of culpability. It's not even a question of conviction. It is a question whether the people really deserve to know the truth, the whole truth, and nothing but the truth. So the only way for the people to know that is for the court to also have access and obtain this document for the life in a fair, impartial judgment.
Last na lang po. If ever, we don't want to preempt yung magiging desisyon nila lamaya. If ever, whatever the decision sa Senator Judges, paano tayo magre-react? If ever man na po nila payagan, pwede po bang questionin yun? Or kung minsan po, kung pwede man payagan, baka maging limited access?
Well, of course, there are legal remedies that will be available. Pero, as you've mentioned, ayaw naming pangunahan yan dahil pa amin, we don't see any reason why the request for the issuance of subpoena will not be granted. Narinig ang mga argumento ng mga panig at nananalig ho kami na pakinggan ng impeachment court ang aming kahilingan at ang kahilingan ng ating mga kababayan is to see the truth. Sabi nga ni Kong Zia, this is not in favor of the prosecution. This is in favor of the truth. So lahat ho ng gustong makakita ng buong katotohanan paul sa bagay na to, sayan ng Vice Presidente, isa lang ho dapat ang gusto natin, which is to see these documents.
Okay. Vel Custodio po from EV. Sa tatandaan po na nung during the impeachment of Nato Corona noong 2012, yung ilang senador ay bumoto to open the financial records ni dating Chief Justice. And ilan nga po sa mga senador, sina Senator Cayetano and the rest of the senator who are also present dito. So, still expecting na their track records despite nga po nung differences in terms of both side.
Well, as pointed out by Joke during the oral arguments, in the preview impeachment proceedings concerning the Lady Corona, the leading officer, Senator Chisero, and Senator Alan Cayetano voted in favor of disclosure of this financial demands. No? And remember correctly, I heard Senano gave a comment, so I guess you already know how he will rule on the same topic. So, but siyempre hindi natin sila kung anong magiging pagpapasya nila. Ganito. But of course, we're very much hopeful that they'll remain consistent with respect to the issue, which is that they're in disclosure.
Ako nakakatulong po yung mga express natin in the past. Hindi lang po sa Senator Judge, at ang buong sambayan ng Pilipino. Nakikita nila at nakukompare nila kung ano yung naging desisyon ng Senado ng mga naunang mga impeachment trial. At inaasahan nila dahil ang pinag-uusapan po natin dito, pananagutan, katotohanan. Kasi hindi nyo po pwedeng paghiwalay yung pananagutan at katotohanan. Dapat ang pananagutan nakaakla rin sa katotohanan. So naintindihan nila at nakakatulong ito bilang isang basihan o isang reference para ang taong bayan nag-expect sila magiging tugon ng impeachment court na ito. Pero tatan natin at babalikan po na talaga. Ang pinag-uusapan po dito ay betrayal of public trust, hindi ba? So ang pinag-uusapan po natin yung opisina po, kung tanggap ba yung opisina na yon na nag-occupy ng office na yon ay hindi punong katotohanan ang kanyang ideklara sa kanyang lawful or legal income. Pan po natin dito dahil ang kanyang inopisina ay niloklok siya ng taong bayan dyan. Kanyang opisina ay pag-aaring ng taong bayan. Po may principle tayo sa Constitution. Betrayal public office is a public trust. Very clear po yung precision ng House Prosecution Panel. Meron pong betrayal of public trust dahil hindi po, para sa amin palaga, hindi po purong katahanan lang yun na-declare doon sa kanya at saka binabayaran po niya ng ITR. Po, dapat nating tandaan, itong impeachment court trial na ito, pagdating po sa isang tagong yaman, ay dapat nating maipakita sa ating taong bayan na impeachment court ay hindi lang po naiintindihan ang kanilang kailang authority, pero nararamdaman nila yung pulso ng ating taong bayan. Na alam naman po natin, meron na ho tayong sa mga naunang mga impeachment trial nung Estrada impeachment trial, ang po yung very recent yung impeachment trial na isa sa naging rason na impeach ay ang kanyang hindi pagdideklara kanyang SALN yung mga panahon na hindi pa siya mahistrado.
Hello? Okay. Can I to Rosalie? Now let's Rosalie's question.
Good morning po, sirs. Are you expecting po the Senate Impeachment Court to grant your request to subpoena the tax records of the Vice President?
Well, again, we will preempt the action to be taken impeachment court on this. That discretion falls in the impeachment court, but we're hopeful that they will grant again, since it's based on strong legal basis.
We do not speculate, but we are optimistic that the Senate will grant the request of the House Prosecution Panel, as again explained earlier, referencing to the previous Corona trial.
But if ever the Senate Impeachment Court grants your request, ano pong expectation nyo po from the President? From President Bongbong Marcos Jr., if ever the Senate Impeachment Court grants your request for subpoena of tax records of the Vice President and her spouse?
Well, again, let's wait for the impeachment court's ruling on this, because it's possible that the impeachment court will sustain the prosecution's position that there's even no need for the president's consent. Why? Because the Constitution trumps special laws. Dahil ang unang posisyon ho namin dito, no, mas supreme, no, ang Constitution natin, which grants the impeachment court the sole authority to decide and try impeachment proceedings. Kasama ho dito sa kapangyarihan nila, no, na litisin ang impeachment proceedings ay mag-issue ng subpoena. So, again, this is the highest form of accountability mechanism in the Constitution. So, ang paniniwala namin dito, mas mataas ito, no, dun sa provisions ng National Internal Revenue Code. So, para makita ang buong katotohanan, merong karapatan at kapangyarihan ang Senate sitting as an impeachment court para i-compel ang BIR na ipresenta ang mga dokumento na ito, no? So, hintayin ho natin kung anong magiging pagpapasya ng impeachment court. It's also possible na sasabihin din ng impeachment court na tulad ng nangyari doon sa nakaraang impeachment proceeding na kinakailangang i-require ng BIR commissioner na mag-request ng consent ng presidente. But again, ayaw ho nating pangunahan kung ano magiging pagpapasya ng impeachment court dito.
Pero you don't see the president disapproving, if ever, yun pong request, if ever po, ng BIR commissioner?
I think what Attorney Jay has sufficiently explained to us is that, number one, the impeachment court having to exercise a very extraordinary power. This is actually a constitutional directive to the impeachment court to exercise. We feel that it will no longer be required for the president, again, for the president to intervene in this matter, because that already sufficient for the BIR to release this ITR by virtue of a subpoena power that will be issued by the impeachment court, no? So, yun lang po yung position na we don't want to speculate on matters that what would happen or matters that are still pending, because pending na pa rin po ang aming request for subpoena. So baka, Ross, baka pagdating ng panahon, baka si Yusek Castro ang magbigay sa'yo ng kasagutan. But in the meantime, we are focused on the request of a subpoena, which is still pending, and we will expect that oral argument will continue today.
Another topic po. We know naman po, we are aware of the rising tensions between certain senator judges, for example po, Senator Alan Peter Cayetano, Senator Ping Lacson, and Senator Erwin Tulfo. Do you see these developments affecting the trial or madadivert ang attention ng public dun po sa tension na yon kesa po dito sa impeachment trial? Is that a cause for concern?
Well, again, this is not something that we would expect and we hope to see. No, to be honest with you, as a colleague of the senators, because Congress is composed of two chambers, it is not for me. Hindi ho hindi masaya na makita o nakakabigay ng saya na makita ang ating mga senador na may kanilang, and this does not reflect the position of the House Prosecution Panel. I'm speaking as a member of Congress. No, it does not give us any satisfaction to see our colleagues having this trouble within and among themselves. No, but again, when you speak about the impeachment proceedings, I think it should not also be appropriate and fair for the House Prosecution Panel to be dragged in an internal matters or internal issues between and among the sitting judges. So I hope this can be resolved. Again, I hope they can have their own way of resolving this, since this is a separate issue altogether from the impeachment trial that we are conducting and we're having right now.
Yes, and these are internal matters that we believe will be best addressed and resolved by the members of the Senate internally. No? But we also trust that the presiding officer will make sure that we will not lose sight of the matter that should be the main focus of everyone involved in this impeachment proceedings, which is to allow the process to continue, no? And allow the parties to present their respective evidence in a proper and efficient manner.
All right. Vivian, it's your turn.
Just a follow-up on that, may panawagan po ba kayo sa impeachment court, presiding officer regarding po dito sa matter na to? Kasi I understand last hearing, parang a good number of minutes na-dedicate dun sa pag-discuss ng matter. Parang hindi medyo lihis dito sa impeachment. Kung may panawagan lang po from you as a lawmaker or as a spokesperson of the prosecution.
Well, una, ako personally, ako naniniwala po ako sa at confident po ako sa pag-handle ng ating presiding officer sa mga naging takbo, no? I think ang ating the way I observe, no? And again, hindi ho ito yung official position ng House Prosecution Panel. Ako, observation ko po bilang isang Pilipino din na gusto ring matapos itong proseso na to. No, I think the presiding officer is conscious about being legal at the same time the political issue in question, that's impeachment trial. Sinasabi ho natin dito, ito hindi lang ho ang ating mga huwis, ang ating mga huwis. That kung meron pong leeway or room for not necessarily strictly implementing legal rules, the Senate with the vision that this is the way for our ordinary kababayan to understand what is discussed in the impeachment court. Aking observasyon kung the presiding officer handled the impeachment. No? Pagdating naman po doon sa mga in connection with yung katanungan po ni Ma'am Ros, again, confident din po ako dahil meron silang rules of impeachment. Alam naman po ng mga senador at ang presiding officer kung ano po yung mga issues na outside doon sa pinag-uupan na article. And I'm sure, observe the presiding officer to allow other people to understand gently what is being discussed on the Articles of Impeachment, Article 4. Ako, optimistic ako na dahil na hindi yun makakadagdag, unawa at pag-intindi ng ang bayan na mas if doon sa pinag-usapan sa court outside of it, alam ko, confident po ako na hindi ho magiging platform ang trial para sa mga hindi pagkakaunawa ng mga senador. This is my personal take on that. It can carry the position of the House Prosecution.
I think everyone meant at this point that Senator Escudero has been presiding over things in a fair, proper, judicious manner. And we trust that he will continue to, and he will make sure that we remain focused on the issues at hand, which is again the impeachment, and we will not be distracted from peripheral matters that have nothing to do with these proceedings.
So, dapat po tumutok lang doon ng articles of
dahil yun naman talagang inaang bayan, no? Kaya nga po sinasabi ko kanina, kung obserbo yung naging handling ng ating officer, hindi masyadong dahil naintindihan niya na practical and technical na aspeto court. Ito po isang political na usapan po natin dito, yung fitness ng pangalawang Pangulo, whether mag-continue ba siya as Vice President. The way he was handling it is para maihan po ng ating taong bayan. Kung ano na usapan sa impeachment court, no? Kasi hindi naman ho lahat ng taong bayan ordinaryong naintindihan mga legal jargons. So, base po doon sa nakita natin, confident po ako na kung ano man yung mapag-usapan dyan na makakatulong sa pag-intindi ng ating taong bayan sa napansin impeachment court, confident ko na hindi ho magiging paksa sa pruning sa impeachment court dahil yung Senate rules na kanila po rules on impeachment na kanila pong sinusubaybayan at pinapractice, no?
Last na lang po, paglilinaw lang parang nare-reference yung mga ruling ng ibang senator judges on a trial when it comes to disc of bank records. Pero parang Senator Tano was making a distinction between records, financial records ng mong official at yung tawa at yung mga kumpanyang nila. Covered po ba ng even yung sa financial records ng asawa po at pati po yung mga na-related sa kanila?
Well, what you have to remember is in SALN, what is there is the conjugal price of the Vice President husband. No? So, nakadeklar na around 80 million na to net worth, kasama ho dyan yung properties nila. So, ngayon, masuri natin kung accurate ba itong amount na declared sa kanyang salary. Kailangan natin makita din ang assets nila, no, as reflected in their bank records, as well as yung pareho nilang same period na to na makaman natin sa kanilang mga BIRs.
Vivian, ito yung sinasa sa inyo sa church, no? In health, in poor or in richer, till death do us part. By virtue of the union, talaga magkayo. At hindi ba sinasabi niyan pasal, no? In sin health, no? For richer or poor, do us part.
Sir, private.
I think ito si Attorney Jack, correct me kung malabal by virtue of a union, itong marriage, by virtue of that marriage and that union, legally speaking, you're treated as one entity.
Because again, what we want to see here are the total assets of the Vice President, her total funds. Para makita to, as explained by Kong Zia, dahil siya ay merong asawa, under our laws, conjugal property ho yan. Kung ano yung mga property na nasa pangalan ng iyong asawa, property mo rin ho yan. So, ang pinag-uusapan natin dito, gusto nakita sa impeachment proceedings na to, nadeklara ba ng tama ang buong yaman ng Vice Presidente sa kanyang SALN as required under the rule? Isang paraan lang para makita. Ang sagot sa katanungan na yan, kailangan natin makita ang buong yaman niya. So, kailangan natin makita anong yaman na nakapangalan sa kanya at ano din ang nakapangalan sa kanyang asawa. Dahil yan, again, as I mentioned, kasama yan sa kanyang kabuong yaman.
Hello po, Lance from Newswatch Plus. Yung mga nagrarally po sa labas, yung ilan sa mga sinasabi po nila ay yung iba daw pong senador ay views na may pinapanigan. So sa hanay po ng prosecution, do you see any actions from the senator judges na nagpakita na sila ng partiality during the proceedings? Kasi yung mga ilan sa ating mga kababayan, yun po yung nagiging puna nila, na yung ilang mga senador tila may dinedepensahan na. So do you believe in those observations as well?
Well, sa amin sa prosecution hanggang ngayon, umaasa, naniniwala at nananalig pa rin kami na tatalima ang lahat ng mga senator judges sa kanilang obligations under the rules on impeachment to observe political neutrality, which means that they should participate in these proceedings without any undue discrimination towards anyone and regardless of their political preferences and affiliations. So, umaasa pa rin kami, nananalig kami na ang mga senator judges natin maghahatol, magpapasya, base pa rin sa ebidensya na ilalatag ng magkabilang panig sa paglilitis na ito.
Pero sir,
dagdag ko lang, yung neutrality na sinasabi ni Attorney Jay, hindi lang namin yan inaasahan. Base po yan sa Senate impeachment rules. Sinasabi po talaga dyan, maging neutral po ang ating mga senator huwes. Pero I think the ultimate message that pinapakita natin sa obserbasyon natin kung bakit nagkakaroon na rin ng ganong klaseng clamor engagement ang ating publiko ay unang-una very clear po na ang messaging dito ay tama, sui generis, legal and political. Dahil ang ating mga senador, ang Senate ay political office po ito. So directly ang ating employers ay ang taong bayan. That's why sinasabi sa Constitution, public office is a public trust. So nakikita natin ho na yung ating mga taong bayan ay nagmamasid din, nag-evaluate din, at sila rin ang tumatay yung half, kumbaga, kalahati sa magiging huwis itong impeachment trial na ito. So yun lang po yung nakikita natin na obserbasyon dahil nga katotohanan ang gusto nilang malaman.
Sir, sorry, sabi niyo po umaasa kayo na the senator judges will be politically neutral at this point. Are they being politically neutral at this point?
Well, it's really hard to get inside the minds of the individual senator judges. But again, the House Prosecution Panel continues to present, evidence and testimonies of the witnesses for the senator judges to have sufficient, information or sufficient reason for them to arrive into impartial and sound judgment, no? As to how they are they care themselves in the court. Trabaho po nila yan na magtanong sa depensa at magtanong sa prosecution panel.
So it looks like you're really trying to get me cited in contempt, ano? Pero mas sabi lang namin, wag muna natin silang pangunahan. Bigyan natin pagkakataon, no, na pakita sa ating lahat na tatalima sila sa obligasyon nila to remain politically neutral at magpapasya sila, no? Magbibigay sila ng paghahatol, again, base sa ebidensya, base sa katotohanan. Dahil at the end of the day, yan ang sigurado naming hihingin ng ating mga kababayan. Ano?
Tsaka matagal pa itong impeachment trial, wag masyadong excited. So, tingnan po natin anong magiging daloy nitong impeachment trial na ito.
All right, for our last question, Joseph.
Sir, good afternoon. With regard to the subpoena, I think second day na touch on, I think you're going to you want to look into 7 banks, 2 in Green Hills, 5 in Davao, correct? How many bank accounts are we talking about here? To whom do this belong to? Are there joint accounts with the Vice President? Can we have them details?
We will have to look at the records to make sure that we'll be able to give you the specifics. No? But what is clear is that all of these bank accounts are based on the AMLAC reports that were submitted by the executive director, no, of AMLAC. So this is not a general inquiry into her bank accounts. No? Alalahanin natin, in those suspicious transaction reports and covert transaction reports, what was specified there are not just the amounts, but the specific bank accounts, no, and the branches that were involved in these financial transactions. So, specific ho yan, no? So, both belonging to the Vice President, the husband, and the financial interest as well, meaning companies where they have financial interest.
Are there any joint accounts aside from Attorney Mans?
Babalikan ko lang kasi just to remind you, I think Attorney J was referencing during the confirmation hearing of the Committee on Justice where AMLA presented these documents, again, flagged by AMLA as under suspicious transactions. We're not talking about the branch alone, the amount, but we're also talking about the in and out of withdrawal and the deposits of certain amounts over the course of months or of a course or number of months and years. So yun po yung titingnan natin. It's very specific, no? As to whether this will be, again, Jay, the question is, I said it is explained by Attorney J. It covers accounts of both the wife, the respondent, Vice President Sara Duterte, with that of her husband, Attorney Mans Carpio.
Just the two of them, no more other personalities?
I'll have to get back to you on that just to make sure that we'll be able to give you an accurate information. But what is certain is that either the Vice President or her husband or jointly, they're the ones who own these accounts. But as to whether their accounts jointly owned by the Vice President and another person, I will have to check. But what I can assure you is that they involve the Vice President.
Sir, shift lang ng konti. Sir, closing tomorrow kay Director Matibag, will he be adding anything more or will he just be repeating what Lotok and Kalilong have already testified to?
I think Jay will give, but it's as a general information that we can share to you without giving away much kasi hindi pa natin na papakinggan ang kanyang testimonya. No? I think number one is very clear that he will again corroborate the testimonies of Mr. Lot Kalilong and Attorney Lotok. He would confirm as to how the investigation is proceeding. Those are the things that probably the House Prosecution Panel will be asking Director Matibag. Doon po sa yung kung ano yung magiging anong status na just to be just to give you a general info just the status of that investigation. As to the details, Attorney J can respond to that.
Well, I'm sure you could understand why I can't give you of its testimony tomorrow. But what I tell you is that aside from corroborating testimonies given by our two witnesses, he will be giving new important information. And I can also assure you that you wouldn't want to miss his testimony tomorrow.
I'll be more direct. Because ang senators were interested last week na parang even the public probably, no? Ang issue is, okay, may threats, may assassination threats, but meron bang actual na whether it's material to the offense or not, but the question is, meron bang nakontrata talaga? Will Director Matibag be able to answer that?
Okay. First of all, let me be clear. Meron bang nakontrata? Our position here is there's no more question about it. Meron. Anong basis? Sorry. Ang admission against interest ng Vice Presidente herself. Again, under rules on evidence, this is one of the highest forms of evidence. No? It's an admission against interest. She clearly stated that she already had an agreement with an assassin to assassinate the president. And 3 days after, when she was given an opportunity to correct her statement, take it back, say it was a joke or whatever, she did not do that. She doubled down. And she tried to defend that statement by saying that revenge from the grave is not a criminal act. So first, is there already an assassin? Has that been established? The position of the prosecution is yes. Now, will Director Matibag also testify on that matter? Again, please, let's wait for his testimony tomorrow. And again, I assure you, you wouldn't want to miss his testimony tomorrow.
All right.
Gusto ko lang kasi as an ordinary person, again, let's go back to what we have been saying all along. Na this is not a criminal proceeding, no? Na kailangan wala talagang beyond reasonable doubt. I think if you ask me personally, I think it's whether or not there's really that hitman na nakontrata, it's already irrelevant. The point here is that, is it tolerable? Is it acceptable based on constitutional standard for a sitting second highest official in the land to make these grave threats against a sitting president? I think that's the most important question that we need to ask of the Vice President. Hindi ho nila na-refute yun. Totoo siyang nagbanta. Whether or not meron kayong muka, may pangalan, may tao, that to me is irrelevant. The point is, this is a trial where we actually measure the fitness of the Vice President according to the Constitution. Tama ba? Allowed ba based sa constitutional standard na magbanta ang Vice President laban kanino man?
Sir, medyo advancer lang ng konti. Assuming we do finish today with the ruling and we proceed with the Director Matibag and we finish with Matibag tomorrow, were you able, was the prosecution able to convince the senator judges that number one, the threats are real and totoo, sinasabi niyo, but do they rise to an impeachable offense? Kasi yun yung parang nandun yung mga senators na parang, okay, baka yung they maybe kind of agree with what the defense is saying, that these are ordinary crimes, RTC, MTC. But to you, were you able to, since we're closing Article 4, were you able to convince the court with your 3 witnesses that this is a impeachable offense?
Okay. Well, first, out of respect to the impeachment court, who has been granted the sole authority to decide on this matter, we will not preempt the judgment that they will reach. This is the decision that's for them to make. But what we can say is we are confident with the evidence that we have presented. Maliwanag na wala ng question dun sa video kung saan ginawa ng Vice Presidente ang pananakot at pag-amin. Kailangan kong ulit-ulitin to. Pag-amin na meron na siyang nakausap na mamatay tao na patay ng Presidente, ang First Lady at ang noong Speaker of the House, at itong tao na to ay pumayag na. At huwag nating kalimutan itong napaka-importanting detalye. Hindi siya tumigil doon. In-explain pa niya, inanunsyo niya sa lahat, anong instructions niya sa bagay na to? Be relentless in carrying it out. Huwag kang tumigil hanggat hindi mo sila napapatay. So, meron pa bang question? Kung sinabi niya itong bagay na to, hindi, wala na. Tulad ng sinabi ko din kanina, meron ding bang question? Meron na ba kaming ebidensya na nagpapakita na meron talagang tao? Tulad ho ng sinabi ni Attorney Lotok nung tinatanong siya, no, cross-examination and by the senators, napakaliwanag din ang sagot niya. Meron, bakit? It came from the admission against interest of the respondent herself. No? So now, to answer your question, no, does this show that does this rise to a level of an impeachable offense? No? Pwede ho ba natin i-consider na to na pagtataksil sa tiwala ng bayan? No? Pwede ba itong makonsider na isang malakas at hindi katanggap-tanggap na paglabag sa saligang batas? Again, kailangan ko hong balikan ano ang from the start na sinabi ni Chairman Jinky Luistro at ni Kong Noy Defensor. Sa buong history, no, kasaysayan ng Pilipinas, minsan lang, ngayon lang na nangyari na nagkaroon tayo ng Vice Presidente na merong kaugnayan sa isang mamatay tao. Vice Presidente na nagkaroon ng agreement, no? Nagkaroon ng kasunduan sa isang mamamatay tao na patay no less than the President himself. Tingin ko maliwanag ang sagot na yan, no, sa mga kababayan natin. Kung katanggap-tanggap ba na manatili sa posisyon ang pangalawang pinakamataas na lingkod bayan. So again, we will not preempt, no, the decision of the impeachment court on this, but we trust on the evidence that we've presented so far.
Joseph, dadagdagan ko lang yung sinabi ni Attorney Jay. The Vice President cannot separate her personality from the office that she occupies. An office, according to the Constitution, is an impeachable offense. So kung ano mo po yung ginawa niya, sinabi niya doon sa video na yon na grave threat. By the way, grave threat is in itself a crime. No? Kung siya po ay private individual, probably may bababa ito sa mga lower courts, like halimbawa MTC, RTC. But we're not actually dealing with her as a person. We are accounting her for the office that she represents and she occupies, which is the second highest official in the land. Number two, to me, it's really it's constituting impeachable offense because number one, you don't have to wait until somebody lies down lifeless in the street. A grave threat is a grave threat precisely because it has not been consummated yet. Kung may namatay, hindi na yun grave threat. Murder na yun ang kaso doon. No? And I hope it will not they will not be successful. Kasi ang sinabi niya, wag kang titigil, di ba? And I hope to God, and God forbid, that they will never be successful because we don't want the President and her the First Lady and former Speaker na may mangyari po sa kanilang hindi masama. I think the question that we also ask our people is this. Moving forward, looking forward, tama lang ba na yung isang opisyal ay wala siyang level of restraint, na paggalit lang ay pwede na siyang magbanta kung ano-ano lang at makipag-usap kani-kanino lang sa isang mamamatay tao para patayin ang mga para sa kanya ay perceived to be her or his enemy. Imagine if that person actually demands authority from, let's say for example, if he or she is a commander-in-chief, di ba? Na meron siyang access sa mga ganitong resources ng gobyerno, tapos pag magalit ay, God forbid, may mangyari sa mga hindi niya kasundo para sa kanya. So I think that's the ultimate question that we need to ask ourselves. Is this acceptable? Do we even expect this from our public officers, let alone a second highest official in the land? So, yun ang parati nating babalikan na tanong, tanong ng ating taong bayan. Ito ba ay katanggap-tanggap na pamamaraan kung paano i-express na isang halal publiko ang kanyang galit, na alam naman po natin na merong constitutional standard na sineset ng ating saligang batas, at meron din pong ang opisina na kanyang ino-occupy ay dinideklara na isang impeachable office. So always po natin yun binabalikan, at always po yun ang katanungan ng ating taong bayan. At yun po yung pinipresenta ng House Prosecution Panel sa impeachment court na ito.
All right. On that note, taking from Kong, we should move on. So salamat po sa ating mga kaibigan sa media at sa ating mga panauhin ngayon, si Congressman si Alonta Jiong, Attorney Benjamin J. Tolosa Jr. At sa ating mga kaibigan na sumusubaybay, patuloy po nating tutukan ang mga kaganapan ngayong hapon, sama-sama tayong sumubaybay. Magandang tanghali sa inyong lahat.
Doesn't that say a lot about her unfitness to serve as a vice president? Isn't that relevant to the question this court must resolve at the end of this trial of whether or not the vice president betrayed the trust given to her by people? From what I have gathered and read, Your Honors, please, this is not the first time this court has been confronted with this issue. Sa impeachment ni dating Chief Justice Renato Corona, tinanggap ng hukumang ito ang mga ebidensyang nakalap bago pa man siya naupo bilang punong hukom. I believe it was then Senator Judge, now presiding officer Francis Escudero, who raised the question, will the impeachment court consider only Corona's acts as Chief Justice? This after observing that some exhibits predated his appointment as Chief Justice. This matter was taken up in caucus, after which this court decided to allow such evidence. When Philippine Savings Bank President Pastor III testified before this court the same Corona trial. He refused to answer the question of then Senator Judge Franklin Drilon on the starting balance of Corona's 2 peso denominated accounts. But if I'm not mistaken, it was Senator Judge Alan Peter Cayetano who said that records of initial deposits are among the quote-unquote opening documents that should have been brought to the impeachment court. After reading the subpoena, presiding officer Senator Juan Ponce Enrile held that Senator Judge Cayetano's observation was correct. During the same hearing, the presiding officer ordered the issuance of subpoena to PS Bank Katipunan branch manager Annabel Tiongson to bring all the bank records of the Chief Justice. A few days later, the impeachment court denied the defense's motion to quash the subpoena for the peso bank accounts of CJ Corona. The presiding officer explained that the purpose of the subpoena is to find out if Corona has not included the deposits in his SALN. This court also denied the defense's motion to suppress evidence on Corona's bank accounts. Sa huli, binusisi ng hukumang ito ang bank records ni Chief Justice Corona mula sa kanyang unang balanse bago pa man siya naging punong mahistrado. The panel of prosecutors respectfully submits that the subpoenas for the production of the bank records, AMLA documents, and BIR documents of the Vice President and her husband are proper and should be issued by this honorable court. Now allow me, Your Honors, to return to my first point. There is a deeper reason why this court must resist the attempts of the respondent to exclude evidence that is obviously relevant. It has to do with curtailing the power of this court. The Constitution gives this honorable court, and I quote, the sole power to try and decide impeachment cases. Kayo lang po, Your Honors, ang may kapangyarihang magpasya kung ano ang impeachable offense at kung anong ebidensya ang maaaring tanggapin para patunayan ito. Kinilala ito mismo ng Korte Suprema. In the case of Francisco versus House of Representatives, the Supreme Court declared, and I quote, a determination of what constitutes an impeachable offense is a purely political question which the Constitution has left to the sound discretion of the legislature. Such an intent is clear from the deliberations of the Constitutional Commission. Inulit po ito ng Supreme Court sa kasong Gutierrez versus House of Representatives, where the Supreme Court declared, and I quote, Francisco instructs that this issue would require the court to make a determination of what constitutes an impeachable offense. Such a determination is purely a political question which this Constitution has left to the sound discretion of the legislature. Clearly, the issue calls upon this court to decide a non-justiciable political question which is beyond the scope of its judicial power. Since this impeachment court has the sole power to determine what constitutes an impeachable offense, no one, not the Supreme Court, much less the defense, can impose limitations on that power. No one can dictate to this court how to exercise the exclusive power to decide what constitutes an impeachable offense. In closing, Your Honors, I go back to the most fundamental provision in our Constitution on the accountability of public officers, Article 11, Section 1, which provides, and I quote, public office is a public trust. Public officers and employees must at all times be accountable to the people. Ibig sabihin po, sa proseso ng impeachment, ang pananagutan sa taong bayan ang pinakamahalaga sa lahat. Kaya naman po, ang hiling namin sa Korte, gamitin ang inyong natatanging kapangyarihan at karapatan na busisiin ang bank records, tax records at AMLA reports kaugnay ni VP Sara at ng kanyang asawa. Sa ganitong paraan, Your Honors, madedesisyonan ninyo ang kaso base sa buong katotohanan. The truth, the whole truth, and nothing but the truth para sa interes at kapakanan ng sambayanang Pilipino. Before I close, If Your Honors please, if I have whatever time I have left, may I request that it be credited to my rebuttal. Maraming salamat po.
We will try to do that, Your Honor. You have 1 minute and 39 seconds. And if at all we do so, we shall equally credit it to the rebuttal, if any, of the Counsel for Respondents.
Thank you, Your Honor.
Attorney Powa, if you're ready, you may proceed with your oral arguments on the twin motions filed by the prosecutors. You may proceed, sir, when you're ready.
Thank you, Your Honor.
You have 15 minutes.
Mr. Presiding Officer, Honorable Senator Judges, magandang hapon po sa inyong lahat. The issue before the impeachment court today is not whether you possess the power to issue a subpoena. The real issue is whether such power may be exercised in a manner that disregards due process and compels the production of documents and information beyond what is allowed by law. Your Honors, jurisprudence provides that for a subpoena to be valid, it must comply with twin requirements of 1, definiteness, and 2, relevance. Ibig sabihin po nun, dapat particularly describe po ang nasasaklaw ng subpoena at dapat may direktang kaugnayan sa ginagawang paglilitis. Your Honors, when a subpoena becomes oppressive, when it is unreasonable, and when it is merely issued for the very purpose that there is a hope that somewhere, somehow, something incriminating will come out, it ceases to be an instrument of justice. It becomes a weapon of a fishing expedition. And that is exactly what confronts this very court today. And that is why the defense has taken the position that the prosecution's requests must be denied. Allow me to explain, and let me begin with constitutional points. Our first point, Your Honors, due process. Impeachment is primarily a legal and constitutional procedure with political characteristics. It is sui generis, but it is not a purely political proceeding. Ibig sabihin po nun, the Bill of Rights, especially the due process clause, applies in all stages of the impeachment process. Your Honors, those are not my words. Those are the words of the Supreme Court in Duterte versus House of Representatives. And that is the law of the land. When we speak of due process, we offer a simple proposition that evidence must be present to support each and every accusation. Pero hindi po yon yung nangyari dito. Balikan po natin kung saan nagsimula itong proceeding na ito. I have here with me, Your Honors, copies of the Saballa and Cabrera complaints, both filed before the House of Representatives. Both accused the Vice President of allegedly amassing unexplained wealth, both with voluminous attachments, yet not one attached a document to support that accusation. Not a single financial transaction record, not even a single SALN. In fact, it was only after these complaints were filed, and more significantly, only after the respondent had filed her answer before the Committee on Justice, that committee started searching for evidence to somehow support these accusations through, again, the issuance of subpoenas. Your Honors, we objected then, and we are still objecting now, because with all due respect, the position of the defense is that is the very definition of a fishing expedition. Your Honors, in our legal system, it is not permitted to accuse now and then just look for proof later on. That is not how due process works. Hindi po dapat natin pinapayagan yan. Moving on to my second point, Your Honors. Let's talk about relevance. It is our position that the requests of the prosecution are in fact fatally overbroad. Bakit po fatally overbroad? An impeachable offense is an act or omission committed while the public official is occupying an impeachable office, not before being elected or appointed to such position. Again, Your Honors, those are not my words. Those are the words of the Supreme Court in Duterte versus the House of Representatives. That is controlling, and that is the law of the land. Yet here, Your Honor, today, the prosecution is requesting for documents spanning almost 2 decades, almost 20 years, dating as far back as 2007. Your Honors, it is a fact na noong 2007, ang respondent ay vice mayor pa lamang. Definitely not an impeachable office, Your Honors. How is that relevant? It is the position of the defense that it is not. In fact, what that is an unlimited search throughout a person's financial history. That should not be allowed. Your Honors, if a subpoena is not narrowly tailored, it is oppressive. For these reasons alone, we are of the position that the request should already be dismissed. Nonetheless, if the impeachment court were to extend its utmost liberality, which the prosecution have asked for in their memorandum, we'd like to point out, Your Honors, that Congress itself, the Senate and the House of Representatives, enacted laws that specifically prohibit the disclosure of these information that the prosecution is asking for now. Let us go through them one by one. Let's start with RA 9160 as amended by RA 11521, which is the Anti-Money Laundering Act. Your Honors, the prosecution is asking for covered transaction reports, suspicious transaction reports, financial intelligence reports, again, spanning almost 2 decades. However, it is clear under Section 8A, which we are flashing on the screen right now, na bawal po yun. Disclosure is prohibited under this provision, Your Honors. It is in black and white. Meron po bang exception? Wala po. Impeachment is not an exception. Had Congress wanted to make impeachment as an exception, madali lang naman pong ilagay yun sa batas. Pero hindi po iyon nagawa. Now, in fact, I also have here copies of the Financial Intelligence Report and another report from the AMLAC, the Information Management Analysis Group, which were already marked as exhibits, Your Honor. And it's in the records of the court. No? Exhibit D2-8-P1, where it says specifically that it should not be the information should not be used as evidence in formal proceedings, Your Honors. Clearly, Your Honors, to compel AMLAC officials to disclose such information would be to compel them to violate the law. Let's move on now to the tax records, Your Honors. Prosecution is asking for tax records, so let's look at the tax code. Section 270 of which criminalizes disclosure of taxpayers' information. Meron po bang exception sa batas na ito? Meron po, but it is limited. Kasama po bang impeachment? Hindi po. That is very clear. Again, Congress wanted to put an exception for impeachment. They could have easily done so, but they did not. Now, Your Honors, let's go to bank secrecy law. RA 1405. The state policy has always been to favor the secrecy of bank deposits, Your Honors. Dito, while we recognize that impeachment is in fact an exception, Your Honors, we submit that this exception is not automatic. Meaning, hindi porket may exception for impeachment, pwede na kaagad natin buksan ang lahat ng bank records na hinihingi ng prosecution. Why? Because, Your Honor, this exception does not dispense with constitutional safeguards. It does not abolish the right to due process. So dapat po, meron pa rin tayong basihan. If you look at the Articles of Impeachment, wala naman po doon na nagsasabing yung sinasabing unexplained wealth coming from, even if it was an illegal activity, ay pinasok sa isang specific account. In fact, Your Honors, this exception does not automatically mean that we should permit a fishing expedition. Yun nga pong mga bank account numbers na nakaspecify sa request for the issuance of a subpoena, ang aming posisyon po dyan, yan po ay nakalap doon sa illegal disclosure, with all due respect, na ginawa ng AMLAC before the Committee on Justice. And then, Your Honors, they're also asking for the bank records of the spouse. Your Honor, the spouse is not an impeachable officer. And therefore, the spouse is not covered by this exception. Again, Your Honors, we should not allow this. In closing, Your Honors, the prosecution has repeatedly invoked accountability. Your Honors, we agree with them. No one is above the law. But in the same manner, no one must fall below or be outside the protection of the law. Impeachment is indeed a powerful constitutional tool. But Your Honors, impeachment is not a magic word or a magic wand that one can just wave to transform an illegal act into a legal act, to transform unlawful access to lawful access. That is not what the Constitution contemplates. That is not what the laws enacted by Congress contemplate. And that is not something that the Honorable Impeachment Court should allow. We submit, Your Honors. Thank you very much.
The gentleman still has 2 minutes and 48 seconds, which we shall credit, similar to the request of the prosecutor, to your rebuttal should you desire to use it, counsel, for the respondent, Attorney Paul.
Thank you, Your Honor.
Counsel, the prosecutor is recognized. Attorney Chel Jokno, you have 11.38 minutes, which will round off to 12 minutes, counsel. You may proceed when you're ready for your rebuttal.
Maraming salamat po, Mr. Presiding Officer, at magandang hapon po ulit sa ating lahat. Let me address each of the points that the defense has raised in their oral argument. Sabi po nila una ay due process daw ang isang paulit-ulit na dinidiin ng defense. But there's no debate that due process applies in this proceeding, just like in any other proceeding. The real issue before this honorable court is, will the subpoenas that we are asking be issued by this court actually deprive the respondent of any form of due process? Ang aming paniwala po ay hindi. And allow me to explain why. First of all, we are not yet at the stage where any evidence is being put in the trial or offered to the honorable court. Nandito pa lang po tayo sa punto na kung maari bang ipaproduce natin itong mga dokumentong ito. The defense will have every opportunity to make objections if and when particular exhibits or documents are identified by a witness and offered in evidence. Therefore, wala pong due process violation ang pag-issue ng subpoena. Second, The defense repeatedly cites the case of Duterte versus House of Representatives as, I quote, the law of the land, as I quote, controlling daw yung decision na yan. But I must remind the defense of that particular case and why the pronouncements quoted are mere obiter dicta, o kung sa simpleng salita po ay side comment lang. The entire Duterte versus House of Representatives case revolved around a different mode of impeachment. Kung maalala po natin, yan yung at least one-third na members of the House ang nagsampa ng kaso. And the entire decision discussed how due process should apply to that mode of impeachment. Totoo, may sinabi ang Supreme Court tungkol sa mode na ginamit po ng Saballa and the Cabrera complaints. Pero hindi po yun ang issue sa kaso ni Duterte. That issue is just a side bypass or incidental declarations of the court that are not controlling and are not the law of the land. And if you look mismo at the decision of the court, they expressly said, we are speaking of due process in relation to how these proceedings reached the Senate as an impeachment court, not this kind of procedure. Second, paulit-ulit din po nilang sinasabi na ang ginagawa po ng prosecution ay fishing expedition. Actually po, meron ng desisyon ang Supreme Court that addresses squarely this point. This case involved a case of unexplained wealth, the case of Republic versus Rabusa, GR 208183, decided August 31, 2022. Just like here, the prosecution in that case requested subpoenas for the production of bank records. Just like here, the argument was raised that this is a mere fishing expedition. In fact, hanggang sa Court of Appeals, ang sabi po ng Court of Appeals ay fishing expedition lang po yan. But please allow me to read just a portion of what the Supreme Court held here. I quote, "The Court of Appeals resolved that the bank accounts of Rabusa et al. Were protected under Republic Act 1405, that is the Bank Secrecy Law. Given the arbitrary demand to disclose the contents thereof, the Court of Appeals considered the inquiry as a fishing expedition to utilize evidence against Rabusa et al. In the instant case, given that the court orders in the form of various subpoena duces tecum and ad testificandum all involved the forfeiture of unexplained wealth, the RTC was in error for not allowing petitioner to examine, inquire, and look into the subject accounts." I continue. As the present proceedings on unexplained wealth are now encompassed within the exceptions of Republic Act 1405, the court orders subject of this case clearly fall within the orders that would enable the examination of the respondent's bank accounts as contemplated in the first exception. Thus, it comes clear that this court cannot sustain the RTC's and Court of Appeals theory that there was no court order authorizing the examination of the bank accounts. On the contrary, records prove that the RTC issued several subpoena duces tecum and ad testificandum, which required certain persons to testify in open court and present documents which pertain to the existence and identity of the subject accounts and also to the accounts, the contents found therein. I just move forward. Given the existence and propriety of the subpoenas, the evidence procured through the same should have been duly considered by the lower courts. This court cannot agree with the Court of Appeals' supposition that the examination of the respondents' bank accounts was but a mere fishing expedition to pin liability on them. Next, the defense repeatedly cites a number of laws to claim that the requested information and documents that we are asking from this court for the issuance of subpoena are confidential. Sabi po nila, confidential daw ito sa ilalim ng Republic Act 1405. Sabi po nila, confidential daw ito sa ilalim ng Anti-Money Laundering Act, pati ang National Internal Revenue Code, pati ang Data Privacy Act. ay confidential din. Pero kung titingnan po natin, klaro po at malinaw po sa amin ang batas at ang utos ng saligang batas sa impeachment court na ito. You have the sole exclusive power to determine an impeachable offense, and that includes the power to find out, ferret the entire truth, and make your decision on that basis. I will not dwell on the exception to Republic Act 1405. That's very clear. There's an exception for impeachment. Pero paano naman po yung sinasabi nilang Section 8A ng Anti-Money Laundering Law? If you read that law, particularly that provision, it clearly refers to prohibiting leaks by members of the Anti-Money Laundering Council. It never was intended to short-circuit the impeachment process or limit the powers of this honorable court to find out the truth. Ganon din po ang nakalagay sa ating National Internal Revenue Code. Sabi po ng defense, there's nothing that allows these documents to be made public. I cite Section 71, NIRC. After the assessment shall have been made, I'll just move forward. The returns, together with any corrections, shall be filed in the office of the Commissioner, and I quote, and shall constitute public records and be open to inspection as such upon the order of the President. And in fact, during the Corona impeachment trial, the President at that time did order, and that is why this court admitted the BIR documents. Your Honors, madaling sabihin na confidential ang ilang impormasyon at dokumento. Madaling magturo ng batas. Pero ang hinahanap po ng impeachment court ngayon at sa mga susunod na araw, linggo at buwan ay ang katotohanan. At ang layunin ay makamit ang pananagutan. Confidentiality, Your Honor, should not be the prevailing principle in this proceeding. Hindi po confidential ang katotohanan. Maraming salamat po.
Thank you, Representative, the Honorable Chel Jokno. Attorney Poa, counsel for respondent, is recognized for his rebuttal. Sir, you have 13 minutes.
Thank you, sir. I will not take up the entire time to expedite matters. Your Honors, I respect, of course, the arguments put forth by the distinguished opposing counsel. But when it comes to due process, Your Honors, I think it's beyond debate, no, that due process must be observed in every stage of the proceedings. And aside from that, due process requires, Your Honor, that we also respect the protections afforded by law on the respondent. Your Honors, ang sabi po ng ating distinguished opposing counsels, obiter lang daw po yung sinabi ng Supreme Court. But Your Honors, nung sinabi ng Supreme Court sa Duterte versus House of Representatives na ang impeachable offense is an act or omission that is committed by a public officer while occupying an impeachable office, hindi naman po siguro pwede doon lang sa yung one-third mode gamitin yung ganong definition, pero pagdating po sa ibang mode ay hindi na po applicable yung ganong definition. Your Honors, in fact, in that decision, which I failed to mention earlier, sinabi rin po that the acts or omissions must be done in relation to the office. Kasi yun nga po ang purpose ng impeachment. Next, Your Honors, yung sinasabi na dapat kahit na may mga prohibition sa batas, pwede pa rin nating masapina para ma-examine. Your Honors, it is the wisdom of Congress kaya po may ganung mga prohibitions against disclosure under the law. Kung papayagan po natin that a court process, even an impeachment court, can issue a subpoena to thwart those provisions, it's as if, Your Honor, we are doing judicial legislation here because a judicial issuance can easily repeal for the time being that provision, or at least suspend, Your Honor. Maybe not repeal. Properly, the proper word might be suspend that provision of law. I've never heard about that, Your Honors. And then, lastly, Your Honors, parati nating sinasabi rin, no? Two points. Yung nabanggit na Section 71. I agree po under the tax code that Section 71 provides that if the President orders, then nawawala na po yung confidentiality. However, Your Honors, even given that there's an order from the President, I think we should still think about the relevance. Para saan ba ine-examine yung mga dokumento? Hindi ba para sa impeachment proceeding? Hindi po namin sinasabi na kung sakaling nagkamali man ang Vice Presidente, kung sakaling may paglabag man sa batas ang Vice Presidente noon, ay hindi na pwedeng maparusahan. Marami naman pong paraan. You can file cases against the Vice President for those infractions, preterm infractions. Pero pag impeachment po ang pinag-uusapan, we are limited to what impeachable offenses are. And again, the Supreme Court is clear about that. Your Honors, there's also a repeated citation of the Corona case. But we would just like to point out that the Corona case was tried, decided upon, way before Duterte versus HOR. And Your Honors, since it was decided before Duterte versus HOR, the Supreme Court was fully cognizant of what happened in the Corona trial. And yet, Your Honors, they impose these guidelines. In fact, the line itself in the Duterte versus HOR is we clarify, I quote, we clarify the constitutional requirements of impeachment. At kasama doon yung nabanggit namin kanina on what constitutes an impeachable offense. And that is very clear. Marahil, sinasabi natin na yon ay isang obiter. Pero, Your Honors, paano po magiging obiter yon? Kung yun mismo ang itinakbo ng desisyon. The fact that the one-year bar was triggered was only the effect of not abiding by the due process clause of the Constitution. And lastly, again, Your Honors, we do not disagree with the prosecution in terms of accountability. Again, no one is above the law, but no one should also be deprived of the protection given by law, Your Honors. Thank you.
Bago mag-recess ang mga senator judges para mag-usap sa caucus, nais kong sambitin sa record na binabati ko ang magkabilang panig, partikular si Congressman the Honorable Chol Jokno, gayon din si Attorney Poa, sa isang mahinahon, malumanay, maginoo at magalang na diskurso at debate kaugnay sa may tuturing nating kontrobersyal na isyong ito. At inaasahan ko, yan din ang magaganap sa caucus at sa aming pagbabalik matapos nito. Senator Judge Alan Cayetano is recognized.
Thank you, Presiding Officer. Very eloquently said. Before we go to our favorite subject, recess, the prosecutor was going to say something about Monday witness. Can we hear that? Because if, I don't want to preempt, but can we hear that? Because if they're not going to have witnesses on Monday, I have a proposal.
I'm sure they will. They were, in fact, on the verge of announcing it.
No, because, Mr. President, this is what I wanted to say. We do need a caucus, but after hearing both sides, I really have many questions, and I think we should really, dapat mahimay. But after hearing them, I think there's a couple of issues we will agree on, but I'd rather ask my questions on Monday. So if everyone agrees, then we can caucus but allow them to adjourn, no? Unless someone wants to ask after our caucus.
We will hear the lead prosecutor. However, Senator Judge Cayetano, it is the predisposition of the presiding officer, given that we don't have any witnesses today to settle this matter and this issue today.
That's
It's the only matter for us to discuss anyway.
That's my point, Senator Judge. No, I'm reviewing the rules. Hindi naman tayo tatagal pag per legal issue kasi nakalagay naman not more than 2 minutes eh. So, meaning for example, for me issuing the subpoena is not one issue. Whether the subpoena is to the VP or to her husband is two separate issue. Peso account or dollar account is a separate issue. Whether or not the company's accounts, etc., should be subpoena is a different issue. But for me to decide, I want to ask the prosecution and the defense about that. So medyo mahaba-haba talaga.
To answer the Senator Judge, we have a precedent that I think, if I remember correctly, it involves the good gentleman himself. When then Senate President Enrile made a ruling with respect to the request for the issuance of a subpoena against the former Chief Justice Corona and his family, the gentleman agreed with respect to not issuing the subpoena against the Chief Justice, but disagreed with respect to not issuing with the family.
No,
And
I
the ruling of the
was
chair-
correct there. That was the first, the rules of court says pwede pagka son-in-law. But I was overruled by Senator
Exactly.
Enrile. I appealed. The body agreed with him. So even if I was correct, I was overruled. But my point is, Mr. Presiding Officer, that was one simple issue. That's why I didn't argue. I'm saying this seems to be like 2 subpoenas, but there are several subject matters, AMLA, etc. And remember, this is Article 2. What's our assumption? August or September pa to iti-take up eh. So I'm just saying, so for example, no, we all agree on the ruling. It benefits one side. We should tell them why we ruled that way so that if they file a motion for reconsideration or they go to the Supreme Court, malinaw din yung ruling natin doon. There are substantive issues here. There are some issues, as eloquently said by Congressman Shel Jokno. Alangan namang bago ako ng stand kung pare-pareho yung issue about, let's say, bank account. So, you know my vote on that, di ba? But my vote on Chief Justice Corona doesn't mean it's the same vote if it was on his spouse and the companies that are under his name. I can tell you honestly right now, I don't know what to vote for, what my vote will be. But I do know that these are 2 important issues. Even the definition of definiteness and the definition of fishing expedition, I want to pursue that with them.
With the permission
Your
of
Honor,
Senator
sir.
Judge Allen, can we discuss that in caucus?
Yes,
instead
yes.
of-
So I'm just saying, if we're going to discuss it and maraming magtatanong, do you want them to go home and we can extend till Thursday next week or whatever?
No, not at this time.
Okay.
We can advise
Yeah, I
them
submit
properly
to the presiding
at the
officer.
appropriate time. Senator Judge Pangilinan.
No, just to reiterate the earlier manifestation of the presiding officer, we agreed to go on caucus after the presentation,
Yes.
after the oral argument. So let us stick to the agreement, Mr. President, Mr. Presiding Officer. Thank you.
Umaasa pa rin ako na magiging mahinahon yung caucus.
So we move to...
Chair declares a recess. We will advise the parties as to what time we will most likely finish once we know that we are in the process of winding up. In the meantime, kindly relax and study the next witnesses you will be presenting. Trial is on recess. The trial is resumed. For the information of the parties as well as the viewing public, in caucus, the senator judges agreed to study the matter more, given that not everyone has actually completed reading the memoranda given by the parties and submitted by the parties, and given that they want more time to look into the complicated issues involved in these 2 motions for the issuance of subpoena. The senator judges agreed in caucus to decide on the matter on Monday, and that on Monday, senator judges who wish to ask the parties questions will be afforded the time to ask these questions again on both sides. Following our rules, it shall be 10 minutes per senator, not exceeding 1 hour for each side. At this juncture, may now recognize the lead prosecutor, the Honorable Luistro. As I understand, she intended earlier to make a manifestation with respect to their intended witnesses on Monday. Kindly already exclude Monday, Honorable Luistro.
Yes, Your Honor. First of all, we would like to acknowledge the positive response of the Honorable Impeachment Court to our previous manifestation. Accordingly, we would like to reiterate that the prosecution will no longer be presenting Attorney Zuleika Lopez as well as Captain Belinda Bello. Reiterating, however, the same concern on redundancy, surplusage, and lack of necessity, the prosecution further manifests that we will not be presenting as well the following witnesses for Article 4, that is threat. Number 1, Your Honor, is the Philippine National Police Firearms and Explosives Office representative. The witness intended to testify that the respondent owns firearms, including the high-powered ones, which demonstrate the capacity and capability to execute the threat. On the other hand, Your Honor, it has been shown already that the government took seriously the threat. As a matter of fact, it prompted the full-scale investigation, including the recommendation to file a criminal complaint. Number 2, Your Honor, is Michael Flores and Bons Magsambol. They belong to the press who were present during the November 23 video conference. They will be testifying that they were among the reporters or media persons who were present during the video conferencing, and to the fact that they heard the respondent utter the threat against the President, the First Lady, and the former Speaker. On the other hand, Your Honor, the testimony of Agent Calilong already established that the video is authentic, plus considering, Your Honor, the defense's subsequent admission that the same are authentic videos, Your Honor. Number 3, Your Honor, is Sheriff Abe Andres. The witness intended to testify on the 2011 incident pertaining to the violence allegedly committed by the respondent on the sheriff. On the other hand, Your Honor, during the past proceedings, it has been acknowledged by both parties. Particularly, it was acknowledged already that the occurrence of this incident of 2011. So we deem it unnecessary as well to present this particular witness. Number 4, Your Honor, is the family member of a victim of threats. The witness intended to testify on the effect, the gravity, and the seriousness of the threat allegedly committed by the respondent. On the other hand, Your Honor, Attorney Loto already testified that threat is a private crime and its prosecution does not depend on the complaint, participation, and even the subjective feeling of the victim, including his families. Finally, Your Honor, the psychiatrist. The witness intended to testify on the respondent's state of mind, the nature of the violence in the statement made, as well as the capacity and capability to actually execute the threat. On the other hand, Your Honor, both parties have sufficiently established already the circumstances surrounding the statements made by the respondent in the authenticated video. The same is true with respect to the respondent's own subsequent confirmation of those statements, as well as the testimonies already presented. Your Honor, considering that these 5 witnesses are included in our pre-trial order, Your Honor, we respectfully withdraw their names among the prosecution's witnesses for Article 4 threat. This withdrawal, Your Honor, renders Attorney Melvin Matibag, the NBI Director, as our last witness for threat, who will be testifying this coming Monday. Tuesday, Your Honor. Likewise, Your Honor, the prosecution acknowledges the 5-day notice rule. However, considering that the decision to forgo the testimony of Attorney Zuleika Lopez, as well as that of Captain Belinda Bello, came only after the conclusion of the testimony of Attorney Lotok, plus considering, Your Honor, the earlier manifestation, which will render Attorney Matibag the last witness for threat, we would like to beg the kind indulgence of the Honorable Impeachment Court to note our next witnesses. This will be in support of Article 1, Confidential Fund. And if we will be presenting Attorney Melvin Matibag on Tuesday, then this means that the first witness for confidential fund will be presented on July 22, that is Wednesday.
Yes.
Nevertheless, Your Honor, we are requesting that we be allowed to request for the issuance of subpoena for our first 3 witnesses for confidential fund. That includes Marivic Pareha of the Legislative Archives Museum Management Service of the House of Representatives, and also, Your Honor, 2 land bank employees, including Violeta Constantino, former branch manager of Land Bank Show Boulevard Branch, and Ninita Camposano, former branch manager, Land Bank DepEd Branch.
To clarify, Honorable Wistro, this is for the issuance of subpoena ad testificandum only?
Your Honor, the request is for the issuance of both subpoena ad testificandum and subpoena duces tecum.
Kindly submit in writing the motion in order to be able to specify the documents you want to be the subject matter of the subpoena duces tecum. We will await it within the afternoon, even after adjournment, so that we can sign the subpoena by today or tomorrow at the latest.
May I inform the Honorable Impeachment Court that the list or the request for subpoena ad testificandum and duces tecum, the written ones, have been submitted already to the Honorable Impeachment Court, Your Honor.
I stand corrected. Yes, I have it with me now.
Your Honor, may I just enter some correction with respect to the testimony of Attorney Lotok to the act of threat or grave threat. The same is a public crime which does not need a private complainant, and its prosecution does not depend on the complaint participation.
Counsel, before going there, let the presiding officer act on these requests for issuance of subpoena first. The presiding officer hereby grants the request for the issuance of subpoena ad testificandum to Ms. Marivic Pareha to appear on July 21 and 22, to Ms. Violeta Constantino and Anita Camposano, also a subpoena ad testificandum to appear on July 21 and 22, and subpoena duces tecum to Ms. Lynette Ortiz, correct? Of the Land Bank of the Philippines to appear on July 21 and 22. The aforestated request for subpoena are hereby granted. Clerk of Court is directed to prepare the corresponding subpoena ad testificandum duces tecum as the case may be, and for the Sergeant at Arms to be instructed to serve the aforestated subpoenas. As you were saying, Honorable Wistro.
May I just manifest, Your Honor, that with respect to the testimony of Attorney Lotok to threat, the same is a public crime, and therefore its prosecution does not depend on the complaint, participation, and even the subjective feeling of the victim, including that of his family.
What is this about? I think, if I remember correctly, Representative Luistro, the presiding officer stated that also yesterday, that there are only certain private crimes that require the complaint of the victim. And these mostly are private and sexual crimes such as concubinage, adultery, seduction, abduction, rape, and acts of lasciviousness.
We
These are the
understand,
only
Your Honor.
private crimes that require the signature or complaint of the private complainant.
We understand that, Your Honor, and we in fact submit to the position of the Honorable Impeachment Court, except that this representation misstated the supposed public crime into a private crime, Your Honor.
Noted.
Your Honor.
Before recognizing the counsel for respondent, Senator Judge Aquino is
Just a
recognized.
point of order, Mr. Presiding Officer. With the presentation of the articles and the witnesses, we're tackling all of the articles from the prosecution and then all of the articles from the defense? Or initially, maybe I was mistaken. I thought we would tackle the per article, prosecution, then defense, prosecution, then defense. Is it all articles, then all articles, Mr. Presiding Officer?
Not a point of order, but perhaps a clarification.
Yes.
But the answer is yes. We will first finish the presentation of the prosecution for all articles before listening and allowing the respondent to present their evidence in chief for all the articles as well. Thereafter, we shall decide by article. After the formal offer of evidence by both parties shall have been made and the final arguments shall have been made of record as well.
All right. Salamat, Mr. Presiding Officer.
Counsel for the respondent is recognized. What is your pleasure, ma'am?
Good afternoon, Your Honors.
Good afternoon, ma'am.
I just have a few, before I express some statement with respect to the discourse that we just heard from the lead prosecutor, may I just clarify, because I don't know if I'm mistaken, but she did mention that they are now withdrawing 5 witnesses under Article 4, namely the Philippine National Police Firearms and Explosives Office Representative, Mr. Flores, Mr. Magsambol, the sheriff, and the psychiatrist.
And one more, the relative of the family of a victim. That would make it 6.
Then that's clarified, Your Honor, because I also heard the lead prosecutor say that Attorney Melvin Matibag will be their final witness for Article 4, and I had neglected to consider the family member listed as one of the reserve witnesses. Thank you for the clarification, Your Honor. But on another matter, this is not an objection, just a statement or a manifestation with the kind indulgence of this honorable
Counsel
court
may proceed.
and senators, judges. Yesterday, at the conclusion of the hearing, we have heard a manifestation from the good lady, Attorney Kapunan, with some suggestion on how to speedily proceed with the rest of the presentation of the prosecution for Article 4. And I think towards the end of her speech, which was quite lengthy, was really just essentially informing this court about the fact that they will no longer present Attorney Lopez, whom they had requested subpoena for, as well as Ms. Belinda Bello. But my point is, I'm not objecting to the good counsel's manifestation or even the manner by which she delivered it yesterday or the lead prosecutor's manifestations today. Only that my concern is those manifestations are almost always accompanied with lengthy discourse containing conclusions of law and facts that in reality only this impeachment court can really determine. Now, why is this a concern for the defense? Because this affects the fairness and balance of this impeachment court and the way it would perceive whatever manifestations or expressions of sentiments or discourses that counsel for both parties will deliver before this court and before the public. Naririnig po tayo ng taong bayan at man ang sabihin ng ating mga kagalang-galang na mga miyembro, no, officers of or members of the bar who also are officers of the court, and we all know that we are before the impeachment court, and therefore we should try evidence and not advocate for the conclusions or the positions that we may have already made even before we went to this trial. And so I'm just expressing a concern on behalf of the defense and just for the guidance of both parties. If the only message that and this goes for both parties, if the only intent really is just to withdraw witnesses, then perhaps it would better serve the purpose of aiding the speedy disposition of this case if that fact alone will, be the only thing that will be mentioned without factual assertions or conclusions of facts or even interpretations of the law. I think that would be more fair for everyone and for the guidance of the public and this court. That's all, Your Honor. Thank you for your indulgence.
May I comment, Your Honor?
No need, Counsel. Let the chair react to the statements made by lead counsel for the respondent. The presiding officer took it as the statements as akin to a tender offer of excluded evidence, very similar to that. Although we are not yet at that stage, although evidence has not yet been excluded, the presiding officer took it as that. Therefore, what is your pleasure? I will give it to the counsel for respondent. Should you decide not to call witnesses in your witness list, do you want the same privilege of being able to make a tender, meaning an explanation of why you won't be calling these witnesses? If not, given the fact that it was given already to the counsel to the prosecutors, or we will simply remind both parties to cease from doing so henceforth. I give you the equal opportunity, counsel.
Thank you, Your Honor.
What is your pleasure?
Let me just clarify, Your Honor. With respect to the presiding officer's statement on it, the chair taking the prosecution's manifestations, a tender of excluded evidence, we respectfully disagree, because if this is a tender of excluded evidence, as the presiding officer had said, there was, number one, there's no excluded evidence, because number two, they never offered it in the first place, and number three, they didn't, in fact, withdrew the presentation of these 5, 6, or 7 remaining witnesses that they listed in their pre-trial brief. Number two, Your Honor, I'm not actually asking for any special treatment or privilege or even the same amount of time that were given to the lengthy manifestations and discourses by members of the prosecution. All I'm asking is if the parties may be guided and from making conclusions of law that in fact really just advocate the position, because I think we all agree that at no point during this trial that the prosecution and defense will probably say, I agree with you on this point of evidence or on this point of law. I think mahalaga nating maintindihan yun, because the prosecution clearly has taken side, defense taken side, and we are advocating for totally divergent views and opinions. All I'm asking, Your Honor, is that if the intent truly is to aid this court in speedy disposition of this case in a fair and balanced manner, just so also with the considering that we are being watched by the people, no? Yung ating mga mamamayan na sa tingin ko gusto rin nilang matuto mula dito sa paglilitis na ito, sapagkat sila interesado rin sa kung paano ba pinapagana ang batas sa bayang ito at kung paano pinatutupad yung mga karapatan, no, ng mga tao at kung paano binibigyan ng pantay na halaga yung prosekusyon at depensa. All I'm asking is, if the intent is just to say, we're withdrawing, then that's it. Just state the intent, and then without any conclusions, Your Honor, because conclusions really are just for the courts to make and not for either of the parties. Thank you, Your Honor.
So noted, as the court said, it is akin to and not exactly a tender offer. Therefore, the court will now remind both parties to kindly limit any such manifestations on the withdrawal or change on the withdrawal of their witnesses to kindly limit it to the withdrawal of such witnesses, and it applies to both sides,
Thank you,
both the
Your Honor.
prosecution and the respondent side, should that time come on the part of the respondent. So ordered. Any other matters to be taken up?
Thank you, Your Honor. None from the defense, Your Honor.
So,
Quick manifestation, Your Honor.
I'm sorry?
Quick manifestation, Your Honor.
Yes.
Just to respond to the manifestation of the defense.
Yes, the Honorable Luis.
Nice ko lamang pong ipaalala sa ating mga kababayan, this is a constitutional process. This is of paramount of importance, and therefore, providing the reasons for the withdrawal of these witnesses need to be communicated as well to the viewing public, Your Honor. Kailangan pong maintindihan ng ating mga kababayan ang naging hakbang ng prosekusyon kung bakit wini-withdraw ang mga pangalan ng ibang testigo para sa Artikulo 4, and that is the threat. That is for the record only, Your Honor.
Noted. Court already made a ruling. Senator Judge Cayetano.
Mr. Senate President, Mr. Presiding Officer, I agree with you both, and there's a solution to that. Let me start by I agree with the defense. Actually, I was going to stand up yesterday, but with all due respect to a good lawyer, Attorney Kapunan, and to the fact that my seatmate, Senator Miggs, was very proud of her, saying that she's his ninang, I did not stand up anymore. The problem with explaining why you're withdrawing is actually you are feeding to the court something they did not testify to, and then something the defense cannot object to. So, and if it is a proffer or a tender, it is clear to everyone, in-exclude yon. Kaya ko nga lang nilalagay. But tama naman si Presiding Officer, it's akin, it's not the same. But dun kasi sa tender, nag-ruling eh. So it's very clear to us it's unacceptable, di ba? So after the very eloquent manifestation of Attorney Kapunan yesterday, if I was a layman, I would think what you said, whether it was the agent, John Mark, whether it was the second witness sa NBI, was true. Kasi parang may summation. The same thing with you, the very able lead prosecutor and chairperson of the House Committee on Justice, di ba? Having said that, I agree with you, this is an impeachment court. People have to know why. But I think we've been very lenient. No one except the spokesperson has spoken about the sub judice rule. So you can actually explain it in the press con afterwards, if I may, no? Because nga, I was also observing yesterday and I was saying, kung ako yung defense, dadagdagan ko na yung witness ngayon at every time i-withdraw, may chance akong i-explain bakit wini-withdraw, then reinforce kung ano yung sinabi nung before. So I understand you completely, ma'am. People have to understand why it's not a sign of weakness. In fact, in your it's a sign that you've achieved your position. But we can do that in the press cons and other forums. But if you do it kasi here, walang chance yung prosecution to rebut that. Or if they do, it's one rebutting the other rather than the witness standing. So if I may offer that solution, Mr. Presiding Officer.
As ruled by the presiding officer, henceforth, that will no longer be allowed. Senator Judge Pangilinan, before Senator Judge Pia Cayetano.
Yes, just a very quick manifestation. I was actually listening to the ruling of the presiding officer, and initially I thought he would rule that the defense would likewise be given the opportunity to speak up, and at some point when they likewise have the opportunity to withdraw witnesses. I would like to think, Mr. Presiding Officer, that would have been the better approach, because this is an impeachment court. This is not. We are not bound by technical rules, unlike court proceedings where lawyers are familiar and would really want, to make it as orderly and as technical as possible. But again, I will yield to the ruling of the chair, but just a reminder to everyone that technical rules of evidence does not apply strictly in impeachment court proceedings. Precisely because nakikinig ang taong bayan, pagka-technical masyado, na sa halip na lumalabas ang bawat punto. Hindi ko sinasabing hindi dapat magsalita ang defense. In fact, yun ang original o initial na suggestion at minumungkahi ng ating presiding officer na kung gusto magsalita ng defense din para tapatan yung nabanggit ng prosecution, mas maganda sana. But I will yield. I just wanted that manifested, and I will yield to the ruling of the chair.
We thank the good gentleman for his understanding and magnanimity. Given that counsel for respondent did not want the same benefit, it also saves on the court time, and as pointed out by Senator Judge Allen, these words can be best expressed outside this court, so that we can manage the court's time better, given that they have both parties have their respective spokespersons to discuss these matters. Counsel for respondent, you
Yes,
wanted
sir.
to be recognized?
Yes, Your Honor.
Yes, ma'am.
May I just very briefly, so that I won't take any more time of precious time of the court and our everyone who's here. With just a brief response to the lead prosecutor's counter manifestation that this is because this is a constitutional procedure. We understand that. When we came here, mulat ang aming mga mata na pumunta rito at alam namin na ito ay isang constitutional mekanismo. Kaya nga, yung sinasabi ko kanina at ang aking kahilingan lamang ay nakasandig doon sa prinsipyo na yun, na dahil ito ay isang constitutional mechanism, kailangan siguraduhin natin na balanse at patas yung lahat ng magaganap. At hindi ko, I find it difficult to understand how manifestations containing assertions that are laden with conclusions and personal advocacy, and obviously one-sided advocacy of either parties, would help the court arrive at the proper determination of whether the respondent is guilty or not guilty of the charges contained in the Articles of Impeachment. Hindi rin po ito in response po to our just good Senator Pangilinan, hindi po technical na or rules, no, yung aking ini-invoke dito, kundi yung actually it's substantive dahil ito ay nakasandig sa ating saligang batas. Salamat po.
Noted. Senator Judge Pia Cayetano is recognized. What is your pleasure, ma'am?
I would just like to support the ruling of the presiding officer, cautioning the both prosecution and defense. I too noticed the esteemed Attorney Lorna Copunan's lengthy explanation on the withdrawal of the witnesses, but because she is Lorna Copunan, nakikinig ako in the same way na even if I don't know some of your names, makikinig ako sa inyo. Rest assured. I think it's her first time to also stand up. So I was being very patient in listening to her. But I did take note of some statements that sabi ko parang conclusions na to or excessive explanation of her observations which I didn't think were proper. So, okay na yun, tapos na yun, pero moving forward nga, Mr. Presiding Officer, I agree with you. And I just need to put this on record kasi nga, sinasabing wag tayo masyadong technical. Pero, to a certain extent, kailangan naman ho natin tingnan naman yung rules natin kasi, maayos ho tayo, di ba? So, I want to read into the record. This might be a paraphrase na nung sinabi niya ha, kasi sinasummarize namin ng team ko yung statements. And anyway, di ko na mahanap sa phone ko dahil kahapon pa yon. But I recall, no, and feel free to correct me, but this is a minor thing naman. Parang dinescribe niya kung bakit bakit hindi na daw papupuntahin si Attorney Lopez kasi naman daw napakita na daw ng defense yung video kung saan siya ay crying and complaining. So observations na po yun ni Attorney Kapunan. Hindi po siya ang witness. Hindi po siya ang dapat nagsasabi sa judges na crying and complaining yung isang testigo. Trabaho po yun ng abogado na i-elicit yun dun sa witness na mapepresenta doon. So yun po yung reason kung bakit hindi ho pwede yun. We're not being technical, but neither of the lawyers here are allowed to stand up and be the one to explain what you are experiencing. That is for the witness to do. Your job is to ask the witness questions. Yun. So to be clear, it's not being technical, but it's making sure that magawa niyo yung trabaho niyo na maayos at magtanong tayo ng maayos sa witnesses. Kung di na pala siya papupuntahin, no need na to say kung ano yung na-observe. Kasi nga, hindi na ho sa inyo yon as lawyers. Yun lang naman po. Again, my utmost respect for Attorney Kapunan and to all of you. You're all doing a great job. Like I said, once in a while, we will be called out. Even I tell the presiding officer, call me out pag sumobra ako, pag medyo nag-exceed tayo ng authority natin, because we're all just trying to do our jobs here. So thank you again, everyone, for your time and patience. Thank you, presiding officer.
Chair, in humility, accepts the presiding officer's lapses in this regard, as twice pointed out by Senator Judge Pia Cayetano already. The chair will be more mindful in the future, but I also ask the parties to also be equally mindful in case the chair forgets or is not unable to point it out on the part of either party should this happen again. Any
Quick
other points?
manifestation, Your Honor.
Hindi tayo titigil niyan, Jervil, sinasabi ko sa'yo. Yes,
I just want to
one
put
last
on record, Your
manifestation
Honor.
from the Honorable Luistra without prejudice to another manifestation from Counsel for Respondent.
Thank you.
I just want to manifest, Your Honor, that the Honorable Impeachment Court has been very much fair in as far as this issue is concerned. As a matter of fact, the presiding officer even asked the lead defense counsel if she would like to avail of the same opportunity to explain the reason for the withdrawal in the event the defense would be withdrawing likewise their witnesses. Also, Your Honor, may I just add, and with all due respect to Honorable Senator Pia Cayetano, the intention of the prosecution is never to abuse the time of the impeachment court. It is never to influence the senator judges, neither is it to influence the viewing public. The explanation was a statement of the position of the prosecution, and of course it is anticipated that the same is adverse to the other party because it is apparent that we are in the prosecution side while the opposing counsel is on the defense side. But nonetheless, let me reiterate and put on record, Your Honor, the purpose is not to influence the senator judges, neither is it to influence the viewing public. It is only a statement of position of the prosecution for withdrawing the names of the prosecution's witnesses, Your Honor.
Noted, and the ruling of the court stands on the matter.
Just a
Counsel for Respondent.
brief counter manifestation, Your Honor. I thank the lead prosecutor for mentioning that the same courtesy was earlier offered to the defense with respect to providing lengthy discourses or manifestations before this court. But I think the point essentially that I'm trying to make is that we're not asking the court for any advantage. What we're merely asking is fairness. That's all, Your Honor. Thank you.
Same answer, noted, and the court stands by its ruling. Any other matters to be taken up from the senator judges? There being none, no other business to be taken up. The trial is hereby adjourned until 2 p.m. of Monday, July 20, 2026.
Thank you.
Zimmerman Duterte is hereby called to order. We shall be led in prayer by Senator Judge Risa Hontiveros.
Sa ngalan ng Ama, ng Anak, ng Espiritu Santo. Amen.
Magandang araw mga kasangbahay. Ngayon ay araw ng Lunes, July 20, 2026. At ngayong araw na ito ang ikapitong araw ng impeachment trial kay Vice President Sara Duterte. Wala tayong aasahang testigo na ipepresenta ng House Prosecution Team laban kay Vice President Sara Duterte. Kundi bagkos ngayong araw ay pagpapatuloy ng Senate Impeachment Court yung oral arguments kaugnay ng request ng prosecution team na isabina ang ilang financial records ni Vice President Sara Duterte, partikular na yung tax at bank records niya at ng asawang si Attorney Manasseh Carpio. Inaasahan natin na ngayong araw ay magdedesisyon na ang Senate Impeachment Court kung pagbibigyan ba yung request ng House Prosecution Team na isapina ang tax at bank records ni Vice President Duterte. At ang mga ebidensyang ito ay gagamitin ng prosekusyon para sa article na Unexplained Wealth o hindi maipaliwanag na yaman ng pangalawang Pangulo. Noong nakalipas na linggo, ipresenta ng prosecution at defense teams yung kanilang oral argument sa request na isapina ang financial records ni VP Duterte at asawa nito. Kabilang na nga yung tax at bank records. Ang hiling ng prosekusyon, mailabas ang buong katotohanan so that this court may know the truth, the whole truth, and nothing but the truth, and make its decisions based on that. Samantalang ang giit ng depensa, when a subpoena becomes oppressive, when it becomes unreasonable, it becomes a weapon for a fishing expedition. Kaya abangan natin kung ano ang magiging desisyon ng Senate Impeachment Court kung pagbibigyan ba yung hiling ng prosekusyon na ipasapina ang tax at bank records ng pangalawang Pangulo. Panoorin natin ang pagpapatuloy ng impeachment trial.
The Clerk of Court will now call the roll.
Roll call of members. The Honorable Senator Judge Aquino, Senator Judge Cayetano Alan, Senator Judge Cayetano Pia, Senator Judge De La Rosa, Senator Judge Ejercito, Senator Judge Estrada, Senator Judge Go, Senator Judge Ontiveros, Senator Judge Lacson, Senator Judge Lapid, Senator Judge Legarda, Senator Judge Marcoleta, Senator Judge Marcos, Senator Judge Padilla, Senator Judge Pangilinan, Senator Judge Soto III, Senator Judge Tulfo Erwin, Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the presiding officer, Senator Judge Escudero, Senate President Gatchalian.
With 20 senators present, the chair declares the presence of a quorum. In accordance with the rules of procedure on impeachment trials, the chair now recognizes the duly elected presiding officer to preside over the proceedings of the impeachment court.
Thank you, Mr. Senate President. Before recognizing Senator Judge Padilla, Chair would first like to dispense with the journal. If there are no objections, we dispense with the reading of the journal of July 15, 2026 of the Senate sitting as an impeachment court and shall consider the same as approved. The clerk of court will please call the matter before the impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Zimmerman Duterte.
Appearances for the parties. Appearances for the prosecution.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor.
Appearances for the respondent.
Good afternoon, Your Honors. Same appearance for the respondent accused. Thank you, Your Honor.
Noted. Senator Judge Padilla, sir, what is your pleasure?
Maraming salamat po sa ating tagapamahalang hukom at sa ating pong ginoong Pangulo. Nais ko lamang pong basahin ng napakaigsing manifestasyon po.
The gentleman may proceed with his manifestation.
Maraming salamat po. A'udhu billahi minash shaitanir rajim. Bismillahirrahmanirrahim. Alhamdulillah rabbil alamin. Aming mga kasama Ako po'y humihingi ng paumanhin sapagkat dito pong nakaraang linggo, lumabas po sa mga balita na may aligasyon na ako daw po ay hindi sumusunod sa batas. Ito po ay nakalulungkot para sa isang senador, sa isang senator judge, ang masabihan na hindi sumusunod sa batas. Samantalang nung tayo po ay merong mahal na saksi dito, pinaalala po natin sa kanya na harapin ang batas. Noong nakaraang linggo, ang atin pong kaibigan na ombudsman, ang sinabi po ng mahal na ombudsman na ako daw po ay hindi sumunod sa kanilang pasabi na mag-file ng aking counter affidavit. Nakakalungkot po ito sapagkat hindi po ito totoo. Inaamin ko po sa inyo kung ICC lang, hindi po talaga ako susunod. Hindi ako magpapasakop sa ICC. Pero dahil ginagalang ko po ang ombudsman, dahil siya po ay aking kaibigan na itinuturing, dahil nagkaroon na po kami ng napakahabang kwentuhan sa aking opisina nung siya po ay kalihim ng hustisya, nag-file po kami. Ito po, hawak ko po ang original. Dahil sa akin po, importante ang original. Ito po ang original, nakalagay po dito. Nag-file ako. Nakalulungkot po na pati ang media ay nakikisama sa ganitong klaseng propaganda na ang isang senador ay hindi sumusunod sa batas. Isang senator judge. Ito po, maaari ko po kayong bigyan ng kopya, mga mahal kong kasama, para mapatunayan na hindi ko po kayo ilalagay sa kahihiyan. Ako po ay nag-submit ng aking counter affidavit. At ganun din po, humihiling din po ako sa aking mga kasama, lalong-lalo na po sa aking kaibigan, Ginoong Pangulo, na sa mga ganitong pagkakataon, hinihingi ko po na tulungan din po ninyo kami. Na maipaliwanag din po namin sa media na meron din po kaming mga pagkakataon na ipagtanggol din ang aming sarili at kami wag husgahan kaagad na kami hindi sumusunod sa batas. Yun lamang po, Ginoong Pangulo at tagapangulong hukom. Maraming salamat.
Senators Erwin Tulfo, Senator Judge Alan Cayetano, thereafter Senator Judge Tito Soto are recognized. What is your pleasure, Senator Judge Erwin Tulfo?
Mr. Presiding Officer, Senate President, ladies and gentlemen, this impeachment court was established to try the Vice President of the Republic. Ang punto ko po rito, kasi napapansin ko po ilang araw na nagagamit po natin ang impeachment court, ang oras po ng impeachment court sa pagpapaliwanag. Naintindihan ko po ang posisyon ng aking kaibigan, si Senador Robin Padilla. Yung kanya pong frustrations. Pero gusto ko lang po sana ipaalala sa ating presiding officer, sa ating pong Senate President, at matanong ano po ba ang ating ginagamit na rules ngayon? Pwede po ba yung mga problema po labas sa impeachment court na ito o labas sa kaso ng Vice President ay dadalhin natin dito? Di po ba ang korte na ito na itatag para po sana kay Vice President at kay Vice President lamang? Mga ebidensya, mga testimonya, mga pahayag patungkol lamang po sana sa impeachment ng Vice President. Kasi dito pong mga nagdaang araw, Mr. Presiding Officer, Senate President, mga kasama, napansin ko po na nagagamit ang oras po ng impeachment court sa pagtatanggol po ng mga nakaraang araw ng sarili ng ilan sa mga kasamahan natin sa mga akusasyon. This is not the right forum and the right venue
and not the right time to explain your situation. Kung gusto po ninyong mag-eksplika ng inyong mga saloobin, problema, maaari naman po ninyong gawin yan sa labas po ng oras ng impeachment court. Maaari pong sa press conference, nandyan naman po ang Senate media. Anytime po, nandoon sila sa Senate briefing room, press briefing room. Maaari din po sa Facebook o sa YouTube magpaliwanag. Huwag po nating gamitin ang oras ng impeachment court sa pagpapaliwanag o sa pagtatanggol ng ating mga sarili simula pa po noong nakaraang linggo. Because the time we waste here to defend ourselves, defend what we believe or what have you, is an injustice to the Vice President. Yung oras po na ito dapat ilaan natin sa pakikinig sa depensa ng Vice Presidente, sa mga akusasyon laban sa Vice Presidente, hindi po pagdidepensa sa mga sarili natin kung tayo inaakusahan ng kung anong mga ahensya, kung tayo po ay may mga kaso, may mga investigasyon. This is not the right forum, Mr. Presiding Officer, Mr. President, Senate President. This is not the right place. This court was established, was created, the impeachment court, for the Vice President and Vice President only. This should be her time. This should be her forum, not our forum here na ilabas natin ang saloobin natin, mga sagot natin sa mga akusasyon, mga kaso laban sa atin. And this is not also the time, Mr. President, Mr. Presiding Officer, na hanapin yung mga kasama nating nawawala, nakakulong, dapat po doon sa Senado natin, sa sesyon natin, and not here in this court, Mr. Presiding Officer, Mr. Senate President. Kaya pakiusap ko lamang po sana sa ating mahal na Presiding Officer and Senate President, let us follow the rules. May rules ho tayo. Kung hindi naman ho patungkol sa Vice President na sasabihin natin, hindi naman po patungkol sa depensa o prosekusyon ng Vice Presidente natin, then wag na ho natin payagan na magsalita pa po dito because nasasayang. Because every minute, every hour that we waste away from the defense or from the prosecution of the case of the Vice President, it is injustice. It is called injustice to the Vice President, to her family, yung anguish, yung kanyang sama ng loob, yung oras na nakabinbin ang kaso na ito. Let us do this impeachment trial as quickly as possible. If we have to clear the Vice President, then let's clear her. If we have to prosecute, then prosecute her with the evidence kung meron. Not waste our time kung ano-anong sinasabi natin dito to protect ourselves, to defend ourselves. This is not the right forum, Mr. Presiding Officer.
Kindly wind up,
Mr. Senate
Senator
President.
Judge Erwin Tulfo.
This is not the right forum for us to defend ourselves. Bring it somewhere else. Bring it to the press. Bring it to the social media, but not here. Thank you, Mr. President.
The remarks of the gentleman are noted. Earlier, Senator Judge Alan asked to be recognized. Are you yielding in favor of Senator Judge Padilla? And thereafter, Senator Judge Soto. Thereafter, Senator Judge
Thank you,
Padilla
Mr.
before the
Presiding
chair
Officer.
makes a ruling on the matter. Yes, Senator Judge Alan Cayetano is recognized.
Thank you. I'm happy.
You may proceed, sir.
I'm happy I finally heard Senator Judge Erwin Tulfo is concerned about the justice or injustice to Vice President Sara. That's good news. Regarding the waste of time here, sabi ni Senator Joker Arroyo, it is useless to argue a legal point with a non-lawyer. When Senator Marcoleta brought that up here, nagkaroon ng commotion. Senator Miriam stood up here many times and said, kaya ka nga nagpo 4 years na law school at nagbabar. So let me give my own interpretation. The impeachment court is formed with lawyers and non-lawyers. And we interact, and it's for everyone, and we're equal. But if there's an engineer here or a doctor, and they talk about medical principles, I have to either study and argue on medical principles. Hindi ko pwedeng sabihin, hindi, ganito lang yan, logic lang yan, etc. Di ba? So, ang legal principle natin today is simple, integrity ng court. So, allow me to mention that to the people and help educate my colleague here. The integrity of the court and the justices or judges is always relevant. So if the Supreme Court or COMELEC, Court of Tax Appeals, Sandigan Bayan is being heard and the judges are being threatened, you give them time. So we cannot take the impeachment out of context. May nangyayaring flood control scandal, may nangyayaring gulo sa Team Unity na hindi na united ngayon. We consider Senator Marcoleta and Senator Jinggoy political prisoners, weaponized yung Blue Ribbon Committee at weaponized yung ano. So Mr. President, hindi tama na sabihin na I wasn't, after we brought up the problem with NBI, they doubled down, naggumawa pa ng task force. I mentioned 2 colleagues sa SALN, I didn't accuse them. Sabi ko lang, just like Vice President Sara, just because tumaas ang SALN, can we already ask for the BIR, for the AMLA and the bank accounts? So sabi ko, yan ang i-discuss namin sa Monday. Nag-react na, nag-accuse. I did not take up your accusations here today. Si Secretary Vince Dizon, 3 beses na nag-verify sa Taguig. Sinabi na 3 beses na walang ghost. Ngayon, i-verify ulit. I wasn't going to bring that up, but then i-question ninyo si Senator Padilla. It was all over the news na hindi niya inintindi or he snubbed the ombudsman. I was going to stand up before Senator Erwin stood up just to say, may registered mail. So nung una pa lang, 5 minutes si Senator Tulfo. So I'll take the 5 minutes also if you don't mind.
The gentleman may proceed
Yes.
and kindly be mindful of the time.
Yes, I will now. So I'm just saying, Senator Padilla just stood up to say, sumusunod siya sa batas. Tapos, kaya humaba to dahil nga hindi importante ata dito yung integrity ng judge. Lastly, kaya sinabi kong it's useless to argue a legal point. Ilang beses ko na narinig dito. It's our job to clear or prosecute the Vice President. Hindi po. It's our job to try and to decide. It's the prosecution's job to try to prosecute, and it's the defense job to convince us na wala. Our job is to try and to decide. And when you decide, you acquit or you convict. Why is that important? These are legal terms. Hindi pwedeng yung nanonood na law student ngayon sasabihin, trabaho pala ng judge to clear or to prosecute. Thank you, Mr. Presiding Officer, Mr. Senate President.
Thank you, Senator Judge Alan Cayetano. His remarks are noted. Senator Judge Soto thereafter, Senator Judge Padilla thereafter. The presiding officer shall make a ruling. You may proceed, sir. You have 2 minutes.
Yeah, thank you, Mr. President, the presiding officer. I do not have 4 years of law, but I have 29 years of lawmaking. And I move that the manifestations of that we have heard be referred to the Senate proper.
We will act on it at the proper time, Your Honor. Thank you. Your remarks are noted. Senator Judge Padilla is recognized. You may proceed, sir. You have 2 minutes.
Maraming salamat po, aming tagapamahalang hukom. Ito pong kasuotan natin sa mga oras na ito, hindi lamang po ito nire-represent ang impeachment ng ating pangalawang Pangulo. Ang nire-represent po nito ay ating karapatan bilang mga Pilipino at unang-una na ang due process. Ito po yun ang ibig sabihin. Kaya ikaw ay pangalawang Pangulo, ikaw ang Pangulo, ikaw ay Senator Judge, ikaw ay magsasaka, ikaw ay mangingisda, kailangan may due process. Yung pong nangyari sa akin, na ako po ay nahusgahan na kaagad bilang Senator Judge, ang pinaglalaban po natin, integridad ng korte na ito at ng mga Senator Judge. Kaya sana po wag nating kalimutan na ang bawat Pilipino ay may karapatan, lalong-lalo na sa usapin na ikaw, ako, sa oras na ito, ay Senator Judge. Yun lamang po, napakaiksi lang. Due process, mga mahal kong kaibigan, mga mahal kong kababayan, maging prosecution, maging defense, sa ating lahat, huwag nating kalimutan, pantay-pantay tayo sa batas. Maraming salamat po.
Senator Judge Pangilinan, what is your pleasure, sir?
Yes, just a very quick manifestation, Mr. Presiding Officer. Earlier, former Senate President Soto moved that these matters be referred to the Senate. This is precedent, actually. During the Estrada impeachment trial, the father of Senator Cayetano Alan, Senator Rene Cayetano, made a manifestation regarding a case that was supposedly being prepared, a criminal case to be filed against him. It was raised in the impeachment court, but ultimately the impeachment court agreed that the manifestation was referred to the Senate as a legislative body. So there is precedent for this. Yes, the court allowed then Senator Rene Cayetano to make his manifestation, but eventually it was resolved that the matter be referred to the Senate as a legislative body. So we move for the previous. Yes, we call for the previous question, Mr. President.
Senator Judge Cayetano?
I think the presiding officer ruled that we will take it up later on, but if Senator Judge Pangilinan will insist, then I have to object on a point of order. Rule 6 says, the last part, the provisions of the rules of the Senate and the revised rules of court shall apply suppletory whenever applicable. And in the rules of the Senate, whenever the senator feels threatened or anything happens, whether pinatayan ng aircon, whether may nakatutok na barel or sinaran ng pinto, he can rise on a point of personal and collective privilege. We didn't do that para umikli. Now, if we're going to argue today rather than ask them about due process with a simple manifestation from Senator Padilla na hindi totoong binabastos o binabaliwala ang ombudsman, registered mail lang kaya hindi pa nadagdag. So, hindi kami ang nagwe-waste ng time. We can have a caucus, we can talk about it. You want to debate that now?
With the permission of Senator Judge Pangilinan, to abbreviate the proceedings.
May I just, Mr. President, because I was alluded to, Mr. President. May I just very quickly, Mr. President, Rule 6 on...
you may proceed, sir.
Thank you, Mr. President. Rule 6 of our impeachment rules, Mr. President, which was quoted by Senator Cayetano as being suppletory. Mr. President, that refers to evidence, rulings on evidence in the impeachment trial. It does not refer to privileged speeches. Therefore, the suppletory nature of the rules of court, as well as the Senate rules, refer to matters pertaining to evidence and no other, Mr. President. But in the spirit of liberality, we will allow that. That's precisely why we did not object when he spoke last week. But let us not abuse the liberality of this court, Mr. President.
With the permission of Senator Judge Tulfo Erwin, the chair will make a ruling because I believe it is also his position not to prolong this matter in discussing collateral matters not pertaining to the articles of impeachment that we are hearing and trying before the impeachment court. The chair rules that the manifestation of Senator Judge Padilla shall remain in the records. We cite as a precedent to the precedent mentioned by Senator Judge Pangilinan, where the speech of the late former Senator Rene Cayetano was not expunged from the record, but referred to the Senate as a legislative body where it may be taken up. I ask the indulgence of the parties to this case. Wala po kasi kaming sesyon. Ito lang po ang pagkakataong nakakapagsalita at nagkikita-kita kami habang recess kami. Pero umaasa ako, within hearing distance of my colleagues, na kapag nag-resume na po ang Senado sa susunod na linggo matapos ang sona ng Pangulo, may pagkakataon na po ang bawat miyembro ng Senado bilang senador, hindi bilang senator judge, na mailabas yung mga hinaing o anumang nais nilang sabihin kaugnay sa anumang nagaganap o nangyayaring hindi tama sa kanila o ginagawa laban sa kanila. And that, I think, is the proper forum for us to ventilate, discuss, look into, and if necessary, investigate the allegations and or accusations against senator judges in their capacity likewise as senators. So ordered. What is the pleasure of Senator Judge?
I will just
Cayetano?
manifest, I correct myself, it was stamped, not registered mail. And since I agree with the ruling, I will not anymore argue the
Thank you,
other
sir.
rule that correlates with Rule 6. Thank you.
Thank you, sir. Noted that it was stamped. The Senate President, thereafter, Senator Judge Erwin Tulfo.
Thank you, Mr. Presiding Officer.
Hopefully we can move on after the manifestations of the gentlemen.
Let me appreciate and thank the ruling of the presiding officer to refer the manifestations as well as the comments of our colleagues to the Senate acting as a legislative body. 8 days na lang po ay magko-convene na ang Senate at doon rin ho natin pag-uusapan itong mga mahalagang bagay na pag-usapan ho natin ngayon. At kanina po ay narinig ko po yung komento ng ating kasamaan si Senator Romy Padilla. At ito po yung mga bagay na dapat rin po nating talakayin pag nagbukas na po ang Senado in 1 week's time. So with the indulgence of our colleagues, importante ho yung oras ng trial sa mga darating na panahon. Nasabi ko nga nung mga ilang araw na mahaba pa yung ating dadaanan. Ito ay 7th day pa lang out of the 102 days na dadaanan ho natin. Kaya bawat oras, bawat segundo ay napakalaga. At nagpapasalamat po ako sa ating mga kasamahan dahil po sa kanilang masusing pag-participate ho dito sa ating impeachment. Pero dadating rin po tayo doon sa pagtatalakay nitong mahalagang issue pagbukas po ng Senado. Maraming salamat, Mr. Presiding Officer.
Senator Judge Erwin Tulfo, briefly, sir, so that we can proceed to the matter on hand.
Very quickly, Mr. Presiding Officer, can we start now, sir?
I was about to, sir.
Thank you, sir. We wasted 26 minutes for nothing. Thank you po.
Proceeding now to the matter on hand. The presiding officer already made the ruling, referring it to the Senate as a legislative body, Senator Judge Soto. Without expunging it from the records, let it remain there. We will now proceed on the matter at hand. We now resume consideration of the prosecution's requests for the issuance of subpoenas duces tecum number 1 for the banks and the Anti-Money Laundering Council on one hand, and to the Bureau of Internal Revenue on the other. And as previously agreed and discussed not only in caucus but also directly by the presiding officer with some members, Chair will now recognize, as I understand, Senator Judge... Ikaw ba una? Senator Judge Alan or Senator Judge Villanueva? Or Senator Judge Pia? Who would want... No one's raising their hand, that's why I don't know who... Senator Judge Villanueva is recognized. You may proceed, sir. Thereafter, Senator Judge Pia Cayetano. Thereafter, Senator Judge Alan Cayetano. You may proceed, sir.
Thank you, Mr. President. Thank you, Mr. Presiding Officer. As much as I am more than willing to give way to our dear colleagues. But Mr. President, before I make I inquire and pose some questions to the prosecution and the defense, may I also raise something, Mr. Presiding Officer? Gusto ko lang pong malinawan tungkol po dun sa procedural aspect, Ginoong Pangulo, dun sa motion na ito. Kasi sa regular courts, hindi naman po unusual na ang isa pong motion ay i-grant in part at i-deny in part. Depende po sa legal and factual basis ng bawat relief na hinihingi po, Ginoong Pangulo. So, pwede ko po bang malinawan lang, Mr. Presiding Officer, tama po bang sabihin ganun din yung kapangyarihan ng ating impeachment court? Maaari po ba na suriin ang bawat hinihinging sabpina ng magkahiwalay at magpasya po batay sa legal at factual basis ng bawat isa sa halip po na tratuhin ang buong motion bilang isang all or nothing proposition.
Tatratuhin ng hukumang ito bilang nag-iisang motion ang tag-isang motion na inihain ng prosecution. They only filed 2 motions, Senator Judge Villanueva, and the court will act on these 2 motions separately, regardless of the number of issues or sub-issues underneath each motion. The reason is simple. Because the court should be a passive body. By amending the motion into several parts and voting on it separately, we are essentially acting as if we were one of the parties. In voting for or against the grant of the motion, we should take into consideration all of the factors that may be raised for or against it. And it may be cited by the Senator Judge in explaining his vote or voting for or against it. Pangalawa po, bilang mga hukom, hindi tayo pwedeng masyadong aktibong makilahok sa paraan ng mga motion which is essentially a relief being asked for by a party sa pamamagitan ng paghahati ng mga motion na yan para pagbotohan ng hiwa-hiwalay. And there is precedent insofar as this position taken by the presiding officer is concerned. In the impeachment of the late former Chief Justice Corona, where then Senate President, presiding officer Enrile, ruled that the ruling of the chair on motions are indivisible and may only be appealed in toto and not in part.
Thank you, Mr. Presiding Officer. And it's clear to me now, despite the fact, Mr. Presiding Officer, Your Honors, that if there would come a time na, for example, sa isang sabina, may sinasabina na sa asawa o sa korporasyon o korporasyon na hindi naman relevant at material doon sa kaso, yun lang po, Ginoong Pangulo, ang ating nagiging reservation tungkol po dito. Ngunit naging malinaw po sa akin na magiging isang desisyon lamang doon sa dalawang motion na inihain.
Tag-isang desisyon kada motion, pero pwede, gaya ng nasabi ng kagagalang-galang na hukom, na senador, na pwedeng hindi ibigay yung lahat ng korteng ito. Pwedeng iba lamang, parte lamang, at hindi eksakto ng hiningi niya. Pero yun ang pagpapasyan bilang isang nag-iisang motion.
Marami pong salamat. Naging mas malinaw po sa kinatawan na ito ang ruling ng ating presiding officer. May I start raising some questions, Mr. President, Mr. Presiding Officer, to the two parties, Mr. Presiding Officer, just for the guidance of the court, and I think it's important that we distinguish between 2 separate procedural questions. Una, kung dapat po bang i-produce ang hinihinging records, at pangalawa, kung ang mga records na iyon ay magiging admissible at kung anong evidentiary weight ang dapat ibigay sa kanila. So, let me start by asking our lead prosecutor, Congressman, to our dear Congressman, would it be correct, sir, to say that the issuance of a subpoena merely compels the production of records and does not by itself amount to a ruling that those records are admissible, relevant, or entitled to evidentiary weight, Your Honor?
Before the member of the panel for prosecutors answers, he's not the lead prosecutor. The question is addressed to the Honorable Representative Chel Jokno, who is a member of who is part of the panel of prosecutors who will be answering your questions. And for the record too, on the part of the respondent, I think it's Attorney Poa who will be answering.
That's correct.
Thank you,
So that
Sir
we don't need to
Presiding
identify each one each time anymore for the record.
Thank you.
The Honorable Jokno may respond to the question of Senator Judge Villanueva. You may proceed, sir, when you're ready.
Thank you, Your Honor. Good afternoon to all the members of this honorable court. Naisagot na po ata yan ni dating presiding Judge Juan Ponce Enrile doon po sa Corona impeachment case. And if I may quote just a brief portion from what he said, I would like to explain that the resolution of this court was simply to authorize the issuance of a subpoena. And whether those evidence subpoenaed are admissible evidence, given the fact that they apparently appeared in violation of existing laws, is a question that must be resolved in due course. So ang ibig po sabihin, ang hiling lang po ng prosecution ay may labas ang ebidensya, pero wala pa po tayo dun sa punto kung tatanggapin ba nitong hukuman ang evidence na yun, kung siya po ay admissible o hindi.
Maraming salamat po sa inyong tugon, Representative Jokno. Kaya po, nilahad ko po yan nang sa ganoon, maitanong po natin ang defense panel if that distinction is correct. Would the defense still maintain that the mere issuance of a subpoena is by itself already prejudicial to the respondent even before the court has ruled on admissibility or weight?
Yes, Your Honor. Good afternoon, Honorable Senator Judges. Yes, while we agree with the position of the prosecution na hindi pa naman pinag-uusapan ang admissibility sa puntong ito, what we are questioning is really yung subpoena mismo po. Dahil sa ating pananaw, ang isang subpoena, at hindi lang sa ating pananaw, but even under jurisprudence, meron pong requirements bago tayo makapag-issue ng subpoena para maging valid yung subpoena na yun. At yun po yung napag-usapan natin nung nakarang linggo na definiteness and relevance. Ngayon, yung twin requirements na yun, para po sa pananaw ng depensa, ay lacking in this case. And that is why we maintain our position as regards opposing itong request ng prosecution sa pag-issue ng subpoena.
Well, at least malinaw po, ang pag-issue ng subpoena, not necessarily opening of records, una. Pangalawa, to be presented in court. At pangatlo, to be admitted as evidence by this court. Before I go dun sa requirements, let me ask the panel of prosecutors, si Representative Jokno, dun po sa pananaw ng depensa on alleged fishing expedition, just for the guidance of Senator Judges, this representation would like to clarify one procedural matter. We understand that the concern raised by the defense that the subpoena may be overly broad. And at the same time, we also recognize that the court has a duty naman to determine whether the records being sought are sufficiently relevant and material to the issues before us. So, Representative Jok, maaari po ba ninyong ipaliwanag kung paano ninyo tiniyak na ang hinihinging mga records ay hindi po simpleng paghahanap lamang ng posibleng ebidensya o tinatawag na fishing expedition, kundi ito po ay mga partikular na dokumento na sa tingin po ninyo ay meron pong malinaw at direktang kaugnayan dito po sa mga Articles of Impeachment.
Thank you, Your Honor. Ang hinihiling po namin sa mga subpoena ay kaugnay sa Article 2, which involves charges of unexplained wealth. Kung titingnan po natin yung mga jurisprudence pagdating sa unexplained wealth, klarong-klaro po na sinabi mismo ng Korte Suprema na kailangan makita yung buong larawan, hindi lamang po ng mga SALN na final ng isang lingkod bayan, kung hindi lahat ng kanyang kinita, both what we would call lawful and, if there is, illegitimate income. Ang SALN po kasi ay parang snapshot lang po yan, year-end, kung ano yung mga assets, liabilities, and net worth ng isang government official. Ang ITR din po ay parang short video lang po yan ng mga transaksyon ng isang taxpayer sa kabuuan ng taon na yon. Makikita lang po natin yung buong larawan pag nailabas natin ang mga bank records. Kasi doon po yung day-to-day na lumabas at pumasok sa isang account ay mabubuo po natin. And in fact, in the case of DOF Rips versus Merencilia, ito lang pong portion ang babasahin ko. Sabing ganun ng Supreme Court, the failure of the complainant to take into consideration respondent Rafael's net worth from the time he entered government service and the failure to take into consideration all of his possible sources of income in relation to his real and personal properties do not support the conclusion that he has unexplained wealth, considering that his true net worth was not determined. Ito po ay sabi ng Supreme Court, Ombudsman, hindi nyo nagawa yung inyong trabaho. Kaya ayaw po namin tumulad sa nangyari kay Ombudsman dito sa kasong ito. We want to see the entire picture. Kaya po namin hinihingi yung BIR records, pati yung mga bank records, and even the Anti-Money Laundering Council records para makita po natin yung buong story as far as both the assets, liabilities, and net worth are concerned, and the lawful, and if there is unlawful income acquired by the respondent.
Last question no, sa prosecution. No? Sir, binanggit po kanina nung defense panel yung requirements which should be relevant and specific, and kinikilala po natin dito sa korte na yung subpoena is an important tool na available po dito sa impeachment court in the search for truth. Pero kinikilala din po natin na ang mga records na ating hinihingi ay may tinatawag na statutory protection under our laws. Now in this regard, Your Honor, bago po ninyo hiniling ang compulsory production ng mga confidential records na ito, may we know what led the prosecution to conclude that the issuance of subpoena is the least intrusive and most appropriate means of obtaining the information sought? In other words, Your Honor, paano po ninyo masasabi na itong subpoena is not only relevant but also necessary and proportionate under these circumstances?
Ang subpoena po ang tanging paraan para makuha ng nitong hukuman ang mga kinakailangan po natin na datos at impormasyon at dokumento. At hindi naman po siya intrusive dahil tulad na nabanggit ko po kanina, ay hindi pa naman ito question ng admissibility. Ang kailangan lang ay ma-produce sa korte yung mga dokumentong hinihingi. The issue of admissibility will come later, and the defense will have sufficient opportunity to object and to oppose. Ngayon po, as far as the particular records that we are requesting are concerned, ito ay nakabatay nga sa nabanggit ko pong desisyon ng Supreme Court na pag tinitingnan natin ang issue ng unexplained wealth, hindi lang po pwedeng snapshot ang titingnan natin. Kailangan mula sa unang araw ng paglingkod ng isang lingkod bayan, yung kanyang final na SALN, lahat ng mga kinita niya, ay makita natin. And that will be shown both by the bank records that we are requesting to be produced, as well as the BIR and tax records that we are requesting.
Thank you. Thank you very much. Sa depensa po, binanggit niyo ho kanina yung relevance, and if I recall it right, last week, the good gentleman, Attorney Powa, made mention about the questions on confidentiality, sir, no? And this representation would like to better understand the legal basis of the defense position on confidentiality. We recognize that the law places a premium on protecting confidential information. At the same time, we are also dealing with a request made in the course of a constitutional proceeding before this impeachment court. At bilang mga senator judges, it's our constitutional duty to try and decide on impeachment cases. Mr. Defense Counsel, yung Section 8-A of the Anti-Money Laundering Act, binanggit niyo po ito last time, which prohibits the disclosure of confidential information. How should this apply to records sought through a subpoena issued by the impeachment court? Because as I read, Your Honor, Section 8-A, it imposes confidentiality, but it does not expressly create an absolute privilege against the subpoena. There is a distinction between unauthorized disclosure and production pursuant to a lawful order of a constitutional body. So, again, my question, Your Honor, where exactly in Section 8A does it say that AMLC may refuse a lawful subpoena from this court, Your Honor?
Thank you for that question, Your Honor. Unang-una, sagutin ko lang po yung pretense ng inyong tanong. No? Sabi nyo, this is a constitutional body, hindi po ba? And as we all know, there is an old legal maxim that the spring cannot rise over the source. No? Ibig sabihin po nun, while the impeachment court is a constitutional creation, it cannot go over and above the Constitution itself. And when we talk about the impeachment court under Article 11, we cannot read that in isolation. We have to also give due regard for all other provisions of the Constitution, specifically the Bill of Rights, kung saan due process ay isang bagay na nakatatak po doon at pinapakita doon, ano bang ibig sabihin ng due process? Due process is, kasama po sa kalakip ng due process, ay ang bawat na nasasakdal ay meron ding pribilehiyo na maging maprotect o maproteksyonan ng mga batas na isinagawa ng mismong Kongreso. So now let's go on to Section 8A. No? As you can see, Your Honor, that is at least for our position, it's an absolute prohibition. Unlike other laws where they created, for example, in the bank secrecy law, meron nakasulat doon, aaminin natin, in cases of impeachment is an exception. Pagdating po dyan, wala po ni isang exception. It could have been easy, especially since this is a 2021 amendment. No? It could have been easy for Congress to have cited impeachment as an exception if it did actually wish to do so. But it did not, Your Honor. And it is our position that if we were to compel and issue a subpoena against these AMLAC records, we're actually compelling the officials to violate this very section of the law. And that is why we are saying na pagdating sa 8A, absolute po yan. It does not say that there's any exception if any court processes are actually issued to compel the production of these documents. Precisely because ang nasa loob po kasi ng mga records ng AMLAC are intelligence. And that's why it's confidential. And once AMLAC determines that they find out that certain transactions are subject to money laundering or should be actually filed in court, the end result is the complaint itself and not the raw data. And that is why, Your Honors, as to the raw data or the information that they receive, yan po ay strictly confidential under 8A.
Thank you for that. Again, I would like to put on record that I was trying to look at that particular section 8A, and I don't see anything that says this court would not have any prerogative as to whether or not we can subpoena bank records. But let me move forward. Perhaps this could be my last question, Your Honor, Mr. Presiding Officer. The Constitution recognizes two equally important principles: confidentiality on one hand, and the freedom of information. It promotes transparency and public accountability on the other. So, Attorney Powa, gusto ko lang pong malinawan for the benefit of this representation and our dear colleagues here, being senator judges, may legal distinction po ba between disclosure of information to the general public and the limited production of records solely to this impeachment court in the exercise of its constitutional function? Because we understand that the principle of freedom of information is rooted in transparency and public accountability, especially po when the conduct of a public officer is under constitutional scrutiny. Now, if confidentiality is the concern, would you agree, Attorney Powa, that this impeachment court can impose safeguards on the use and disclosure of the records. Kung maaari lamang po na, kung maaari naman po na magpatupad ang impeachment court ng sapat po na safeguards upang mapanatili ang confidentiality ng mga records, bakit po dapat maging hadlang ang confidentiality sa isang impeachment court upang suriin ang mga impormasyon na maaari nga pong may kinalaman sa mga isyung nararapat nitong resolbahin bilang isang impeachment court?
Para sa atin po, no, kung ano man pong hakbang ang pwede o hindi pwedeng gawin ng isang impeachment court tulad ng nasa harap natin na ngayon, it must be confined to the limits imposed by the Constitution and the laws. No? So kahit sabihin po natin, we are not against transparency. I just want to make that clear, Your Honors. We are not against accountability. But again, as I've mentioned last week, hindi naman porket po that we are all looking for accountability ay transparency, ay isasantabi na lang po natin kung ano ang mga karapatan, hindi lang para sa impeachable officer, pero para kahit sinong Pilipino na nakasaad sa batas, including absolute confidentiality in terms of AMLAC reports, which we are pointing to. So para po sa atin, nakikita ko yung punto po ng ating hukom, no, na paano kung mag-impose na lang tayo ng certain conditions. However, Your Honors, those certain conditions may be allowed for other records, pero pagdating sa AMLAC po, absolute po kasi yung prohibition. And if we were to amend or at least suspend the provision of 8A, then it is as if this honorable court is actually doing some sort of judicial legislation, no? Because we are technically suspending this law for a specific person na hindi natin pwedeng gawin sa iba. That is why, ang sa akin lang po, ang sa amin, sa punto ng depensa, is paano po yun? Meron po bang instances na papayagan na lang natin, isantabi natin yung batas? At merong instances na hindi. I think, Your Honors, we feel, the defense feels, Your Honors, that in the search for truth, transparency, accountability, we must still work within a framework, which means that we must work within the limits imposed by the Constitution, the laws, and the rules of the land. Yun lang po, Your Honors.
Salamat po, Attorney. Mr. Presiding Officer, just a few seconds, just to put on record, ang Senado po ay nasa plenaryo na po yung proposed Bright Act natin na maraming sumuportang mga kasamahan natin. And ito kasama po dito yung amendments to AMLA to put in black and white the circumstances under which bank records, financial transactions may be lawfully accessed by competent authorities. Subject always, of course, Mr. President, to appropriate safeguards and due process. So gusto ko lang pong banggitin that indeed, confidentiality is an important legal protection, pero hindi din po ito dapat maging dahilan naman para manatiling mailap po ang pananagutan. Ang mabuting batas ay kayang pangalagaan ang privacy nang hindi po nasasakripisyo ang accountability. Our laws must be able to protect both, Mr. President, Mr. Presiding Officer. Maraming salamat po, Ginoong Pangulo. Maraming salamat po, our councils. Thank you.
Thank you, Senator Judge Villanueva. Your remarks and responses thereto are duly noted and entered into the records. Senator Judge Pia Cayetano is next, I believe. You may proceed, ma'am, when you're ready.
I'm ready to proceed, Mr. Presiding Officer. I'd like to start this discussion with a question that hopefully will allow our kababayans who are watching, listening, to understand the situation. Of course, I pose it also to the parties. If the government had in mind that there's a business and of course a particular businessman or businesswoman who is violating a lot of laws pertaining to the operation of their business, be it customs law, BIR, regulations, can they just proceed and Pwede ba silang basta na lang mag-request ng dokumento o mag-file ng kaso na requiring the businessman and the corporation to produce those documents? Pwede ba? So yun ang pag-isipan natin, no? Kasi yun ang tanong eh. Similarly, ginagawan ko lang ng ibang analogy para maintindihan ng mga kababayan natin. So this is the essence, dear colleagues, parties, of the principle of due process. This is ingrained in our Constitution. Totoo po na may karapatan ang gobyerno at obligasyon ng gobyernong patakbuhin ng maayos ang gobyerno, but it is always with due respect to the rights of every individual Filipino. That is the right to life, liberty, and property. So bago mo sagasaan yung right to life, liberty, and property, siguraduhin mo lang na may basihan ka. Yun lang naman ang sabi. So of course, ako, gusto ko talaga na maayos ang patakbo ng gobyerno para if somebody's life is also in danger, then government has to step up and prevent somebody's liberty. Kasi nga, sinasagasaan niya yung life and liberty ng ibang tao. So it's a balance, no? I think we can all agree it's a balance. So I want to go straight into a landmark case and I will ask both parties for their legal opinions on it kasi it is a legal proceeding. Pero gawin nyo lang simple para hindi masyado complicated para sa mga nakikinig sa atin. So in the landmark case of Stonehill versus Diokno, 1967 pa po to, karamihan ng mga lawyers hindi pa pinapanganak. The importance of due process was highlighted and the Supreme Court discussed 2 points. General warrants are void. Sabi ng Supreme Court, a warrant must be issued on probable cause for one specific offense and must particularly describe the thing being seized. So kailangan particular ang description dun sa warrant. Warrants that leave it to the discretion of the officers serving them to decide what to seize or general warrants are outlawed by the Constitution because they place the sanctity of the home and privacy at the mercy of prosecutors. So sinabi dito na kailangan specific. Take note warrant ito ha. Supina naman ang pinag-uusapan natin. Alam ko po yun. Pero I'm pointing it out kasi ang magiging tanong ko later on is kung relevant ito sa kaso. Okay? The other principle that was established in Stonehill versus Diokno was the exclusionary rule. Evidence obtained through an unconstitutional search is inadmissible for any purpose in any proceeding. Ito po yung tinatawag na the fruit of the poison tree. Pag nakuha mo yung information dun sa bawal na paraan, kung ano yung information mo, bawal ipakita yon. And this is where I need to get guidance from the presiding officer. If I had in caucus, para lang mabanggit ko na ito yung mga provisions of law na napag-usapan. Am I allowed to do that? Would you like me to approach you? Please let me know, because I will abide. Basically, because ang nangyari is we had our own discussion and I want to mention the provisions of law that we discussed. I don't have to mention names.
The lady may proceed.
Okay, thank you. So, tungkol dito sa exclusionary rule, ulitin ko, fruits of the poison tree, dun nga sa aming very open discussion, and I thank many of our colleagues who were I think we engaged in a fruitful discussion for some, not for all. I think yung iba talagang gustong makipag-debate at di-debate kasi gusto ko rin matuto, no? I think all of you will attest na I also wanted to learn from all of you kung anong perceptions nyo sa batas, kung ano din yung sinasabi ng mga abogado nyo. So dun sa fruits of the poison tree, sabi ko, kung yung pinanggalingan ng mga dokumento bawal na kunin ng basta-basta, then paano mo gagamitin? And meron kasing observation na lumabas na kasi yung documents na yon sa House. So nakita na ng publiko sa House. So sabi ko, pero if I will look at, and this is where I will pose the question to all of you, no? Medyo layered so pasensya na sa medyo complicated. Yung isang concern ng defense na nabasa ko is that hindi nag-allege ng ultimate facts. Hindi klaro kung ano yung naging kasalanan at hindi na-identify ng maayos itong facts na to that lead to a conclusion of law. So wala daw yun. Later on, I will ask both parties again to also clarify that. But the point is, kung walang basihan yung paglabas ng ebidensya na yon, it is the fruit of the poison tree, then you cannot use it. So yun yung importante dito kasi I'm sure nakita nyo no sa korte, kahit sabihin nyo pong sa mga legal drama na na-throw out, the case is thrown out because na-violate ang due process. So that's the discussion I want to have. I want to hear both ha. Wala akong kinikilingan dito. I'm just explaining na yun yung argument ng defense na walang due process, kulang, at why prosecution would you say na nasusunod yung due process. And before I give the floor to the parties, yung sinabi kong kaso na Stonehill versus Diokno, very interestingly, involves the esteemed father of our colleague, Congressman Prosecutor Chel Diokno. In the case of Stonehill versus Diokno, the father of Congressman Diokno was the Secretary of Justice. And in this case, the government, through the Secretary and other prosecutors, suspected that Harry Stonehill and his associates and several corporations that they controlled were violating central bank laws, tariff and customs laws, Internal Revenue Code, and the Revised Penal Code. So nag-request sila ng issuance of search warrant. At ang gusto nilang tingnan is books of accounts, financial records, vouchers, receipts, ledgers, etc., and other documents showing all the business transactions. Stonehill and the other petitioners filed a petition before the Supreme Court arguing that the search warrants were general warrants because they did not particularly describe the things to be seized. So, general pa pala yun. Books of accounts, financial records, receipts. General pa pala yun. And the Supreme Court ruled that indeed, general warrants are void. Warrants must be based on probable cause. Nasabi ko na yun, ano? And then the case also adopted the exclusionary rule, holding that evidence seized under an unconstitutional warrant is inadmissible. So, I now pose my questions. Applicable po ba ang kaso na ito, Stonehill versus Diokno, as far as the prosecution is concerned, and then also for the defense, applicable? Take note, I've read most of the pleadings, well, all of the pleadings, mahahaba sila. I kinda know your answer, but sa dami, I like to hear it again, and I think, of course, karamihan ng kababayan natin did not read it. So explain natin sa kanila, because this is a landmark case. Kung ikaw ay law student na magbabar, ito yung mga kasong titingnan mo. So malay mo, matanong yan sa bar. So nakatulong man lang tayo dun sa mga bar students na maliwanagan sila. Baka mamaya trick question to. Is it applicable or not? That is my question. I will sit down, and then I will come back for my next. Thank you.
Thank you, Your Honor. If I may be recognized.
The member of the panel of prosecutors may proceed to give his answer. Thereafter, the counsel for respondent may do so as well.
Iba po ang konteksto ng search warrant na naging main issue sa Stonehill versus Diokno. Sa konteksto po natin na subpoena ang pinag-uusapan. Ang search warrant po, ang governing law po dyan ay nasa Bill of Rights natin, Article 3, Section 3. At kaya siya nandun dahil very invasive po ang search warrant. Pag ang isang judge ay nag-issue ng search warrant, pwedeng pasukin yung opisina o yung bahay ng person involved, pwedeng halongkatin yung lahat ng mga gamit niya doon sa kanyang opisina o sa kanyang bahay. Kaya po naglagay ng maraming limitasyon ang ating konstitusyon dahil marami ng pang-aabuso, marami ng mga halimbawa ng pang-aabuso na nangyari kahit noon pa. Iba po ang pinag-uusapan natin ngayon. Ang pinag-uusapan natin ngayon ay subpoena. Hindi po ito license to enter an office or to search any place. Ito po ay mismong humihiling lang ng mga dokumentong nakasulat sa loob ng subpoena. Therefore, the contexts are very different. When we speak of a search warrant, I do agree there should be very specific limitations on how that warrant can be enforced. Pagdating naman po sa subpoena, meron din po yan, but that is not governed by the Constitution. It's governed by Rule 21 of the Rules of Civil Procedure, which basically provide that for a subpoena to be valid, it must be relevant and it must be definite. Ibig po sa relevance ay may kinalaman o may kaugnayan yan sa mga kailangan patunayan ng mga facts. At pagdating naman sa definiteness ay klaro kung anong mga iba't ibang dokumento ang hinihingi. In our case, we respectfully submit, Your Honors, that we have met both the standards of relevance and materiality. The BIR records, the bank records, and the records of the Anti-Money Laundering Council are relevant to the facts in issue pertaining to the charges of unexplained wealth. Hindi po natin malalaman kung talagang merong unexplained wealth ang Vice President kung hindi natin mabubuksan yung kanyang mga bank records, kung hindi rin natin makikita at mailalatag ang anti-money laundering at PIR records po nila. And insofar as definiteness is concerned, we have specified the particular documents that we are requesting, and we have included as well an explanation of why those are important. Kaya sa aming pananaw po ay we have satisfied the requirements for a subpoena duces tecum. Thank you.
Mr. Presiding Officer, before we recognize the defense, just a quick follow-up question.
Hindi ko may lapit eh.
Bigyan ko ng time na bulungan muna siya ng kasama
I'm
niya.
sorry.
Okay na kayo? No, it's okay. It's okay.
Senator Judge Pia, would you like the counsel for respondent to answer?
Not yet, Mr.
Not yet.
Yeah, my
Okay.
request was if
Okay.
I'll just ask a follow-up question.
You may proceed,
Thank
ma'am.
you. Thank you for that. I appreciate his Honor's response. May I simply point out, and again, please give me your explanation. Tama ho yung pagkambanggit nyo na yung nature ng search warrant very invasionary, di ba? Because it requires that pasukin yung bahay, halugugin yung gamit. Pero hindi kaya invasive din yung paghalughog ng records? Is that not extremely parallel? I mean, is it not very similar in the sense that what is being questioned now are the very essence of somebody's savings, earnings. So, which we have to agree. I think there's no doubt that that is protected. But in fact, His Honor is saying that it would fall under the police power. So, imbis na papasukin mo sa bahay na nandun yung mga dokumento, you will do the same by asking these agencies, whether it is the BIR, the banks, or AMLA, to now reveal these documents. So that's my question. Is it in the prosecution's, is it the point of view of the prosecution na iba yun? Hindi ba invasive yun? Kayo gumamit ng word na invasionary, no, but I'll use invasive, I think. Yeah. Anyway, please answer, and then we'll give the floor to the defense, Mr. Presiding Officer.
Counsel for the panel for prosecutors may
Thank you, Your
answer as he pleases.
Yung pong search warrant, kung ano man ang makuhang ebidensya doon, ay direktang binibigay po yun sa court, and that is now considered as evidence by the court that issued the search warrant. Iba po ang subpoena, dahil pag naglabas ang isang hukuman ng subpoena, itong mga records ay hindi po siya considered yet as evidence. Yan po ay ipoproduce lang, dadalhin lang po sa korte, and now it is up to the parties, and I refer to both parties, to decide which of those documents may be relevant in terms of the evidence that they are need to present. Yung pong nakikita po natin sa subpoena, it is not in any way invasive because, as I mentioned earlier, and as pointed out by Senator Enrile when he was the presiding officer in the Corona trial, we are simply having those documents produced. The admissibility of those documents will only be determined after, if offered by the parties. Kaya po sa aming mga pananaw ay malaking-malaki ang pagkaiba ng search warrant sa subpoena.
Your Honor, may I be
With
recognized?
the permission of the lady Senator Judge, counsel for respondent may now give his answer to her query. You may proceed, sir.
Thank you, Your Honors. Your Honors, ang posisyon po ng depensa dito ay subpoena and a search warrant are very much similar in that both are compulsory processes. No? So, yes, hindi tayo papasok sa bahay ng isang tao o ng nasasakdal, but it will be intrusive because we will be opening up all the financial transactions for, sabi nga dito, almost 20 years of the respondent. Kaya po, katulad ng isang search warrant, the things that we are asking for through a subpoena must be particularly described. Kanina po, nabanggit po ng aking kagalang-galang na opposing counsel na particularly described na po yung kanilang naisulat. However, the defense does not agree with that proposition because if we look at it, tama naman po, nakasulat po dito ng hinihingi nila ay account opening and maintenance records, KYC documents, information files, signature cards, all account and transaction records, ledgers, journals. Basically, Your Honors, this is everything. Ibig sabihin, ni-specify lang nila ang nilalaman ng lahat ng bank records ng respondent. So in our view, Your Honors, while they took pains to specify each and every document, the truth of the matter is they're asking for everything. Ngayon, pagdating sa subpoena, and even in the case they cited, yung Rocco versus Contreras, no? Nakasulat po doon that for a subpoena to be validly issued, when we talk about particularly describing yung kung ano yung hinihingi, it has to be evidence that is both relevant and material. So ang tanong namin, saan ba dito yung relevant or material? Kasi lahat na po ng records hiningi eh. So, and this bolsters our theory, of course with all due respect to the opposing side, na kaya namin tinatawag o kaya namin natawag na fishing expedition ito. Kasi lahat na ng records hiningi, pero hindi naman matukoy which would actually be relevant, which would actually be evidentiary to the accusations they have made under the Articles of Impeachment. So, pero dito, hinihingi natin 20 years worth of records. And then, paano po yun? Hihimayin natin, maghahanap tayo ngayon kung may relevant o wala. Which brings me back to yung BIR records. Nakaseal po yung box. So I would say, both parties, hindi natin alam kung anong nasa loob nun. Yet, we're hoping na somehow, pag nabuksan yung box na yon, meron po tayong makikitang ebidensya. And that's why, again, with all due respect, we called it a fishing expedition. Kasi hindi naman na-identify kung ano mismo doon yung pwedeng ebidensya laban sa sinasabing unexplained wealth umano ng Vice Presidente. So, with the question, for us, yes, the Stonehill case, Stonehill versus Diokno, directly applies to the current proceedings. Kasi nga po doon, sinasabi talaga na dapat specified yung hiningi, particularly described and relevant. But as of this point, they're asking, Your Honors, for all of these things. And again, while they specified each and every document, kung babasahin niyo po ng mabuti ito, they're actually asking for all bank records without, in fact, telling us which transaction is relevant to their accusation, which transaction will actually support their accusation. Yun po yung aming pananaw dito sa tanong ng ating kagalang-galang na hukom. Thank you po.
If Your Honor, please, may be allowed to respond.
Hold on, counsel for the panel of prosecutors. Senator Judge Pia is the one asking the questions. Unless it's not a debate between the two counsels. You're merely responding to answers from questions by senator judges.
I actually prefer not, pero alam mo na, baka sabihin naman na may bias tayo pag di ko naman pinayagan. Di payagan.
No,
I defer to...
Senator Judge Pia, you asked the question, they answered. It is not for the opposing counsel to answer points raised. They had that chance when they did their oral arguments, rebuttal and surrebuttal. You may proceed with your question, Senator Pia.
Sige, my question is, what is your question? Or what is your comment? Go ahead. But keep it brief. Keep it brief.
Thank you so much, Your Honor. I just wanted to point out that this is the first time actually an impeachment court is faced with the challenge of determining whether the charges of unexplained wealth are valid or not. And yung previous Corona case, hindi po pinayagan ng impeachment court yung Article 2.4 ng Article 2. At kung ang magiging batayan po natin ay yung naging mga desisyon ng ating Korte Suprema, sinabi mismo ng Supreme Court in several cases na pag ang usapin ay unexplained wealth, kailangan makita yung kabuuan ng kinita ng isang lingkod bayan at yung mga dineclare niya sa SALN. Just to quote just a very short portion, sabi ng Supreme Court from the same case I cited earlier, the Ombudsman's failure to account for all lawful sources of income, including proceeds from business ventures and government benefits, further weakens the allegation that Rafael's wealth was unexplained. The incomplete assessment disregarded his accumulated assets over decades of public service, making it impossible to determine whether his property acquisitions exceed his legitimate financial capacity, end quote. Hindi lang naman po dito sa harapan nitong hukom na ginagawa yung pagtingin sa kabuuan ng isang lingkod bayan. The Supreme Court has done it in this case where they looked at decades of the financial records of the person charged with unexplained wealth, and it has also happened in the cases of Rabusa and Ligot, which were decided recently by the Honorable Court. Thank you.
Your Honor, may I at least be given just 1 minute to respond to that, Your Honors? But of course, I will submit to the pleasure of the Honor.
Of course, I yield. Of course, I
Give you
yield.
the same opportunity, I'm assuming.
Yes, Your Honors. Again, hindi ko po tinutuligsa o ino-oppose yung mga na-mention na case ng aking distinguished opposing counsel. However, those cases do not involve impeachment. And why is that relevant? Because in impeachment, as we have said, merong allegation ng unexplained wealth pero wala naman pong nakasuporta na mga documents para makita natin ano ba yung basis na naging aligasyon. Pangalawa po, again in impeachment, according to the case of Duterte versus House of Representatives, meron po tayong tinitingnan kung ano ba talagang impeachable offense. At yun po ay again, offenses or acts or omissions committed while the public officer is occupying the impeachable office and in relation to such office. That enough, Your Honors, is very clear under the decision. That is all, Your Honors.
Thank you, Counsel for Respondent. Senator Judge Pia, may proceed.
Mr. President, Mr. Presiding Officer, I'll go to my next point, but it will kind of overlap with this point as well, so bear with me. My next point, Mr. Presiding Officer and parties, is still on due process. This is the requirement that every pleading must allege ultimate facts and must not contain conclusions of law. So again, I'll start with an example. If, for example, if there's a case filed, no, and sabi, si Juan robbed the house of Mario. So para maintindihan ng mga kababayan natin, Juan robbed the house of Mario. That is a conclusion of fact. Nangyari na daw yun. And if there's another allegation that says, therefore Juan is guilty of robbery, that is a conclusion of law. So, again, I try my best not to be technical. It's in my, I would have wanted to be a teacher if not a lawyer, so I do like to be able to explain things well. So, ang hinahanap dito is, bakit mo, gusto mong patunayan yung facts mo? Yun yung kailangan sa ultimate facts. Kailangan mo patunayan, bakit mo sinasabing Juan robbed the house of Mario. Di sasabi mo, ang ultimate fact dyan example is si Juan ay nakita dun sa vicinity ng bahay ni Mario. Tapos ito si Mario, narinig na nagsisigaw na ninanakawan kami, whatever. Tapos yun, meron siyang testimonya na ano yung nawala sa kanila. Tapos may nakakita na kamukha ni Juan yung nandun. Tapos namukhaan nila, na-describe nila na 5 feet 10, medyo mapayat, ganon. So yun yung mga ultimate facts na later on sa evidence, patutunayan. That's just very general, no? And then later on, parang mapatunayan yung robbery, i-allege ngayon yung elements of the crime that constitute robbery. So,
Nung di pa ako abogado, di ko naman alam ang difference ng robbery and theft. Yung robbery kasi qualified yan eh. So pumasok siya sa bahay using violence. That's what makes it robbery. So kailangan na i-allege yun. Sorry to be a bit technical. Alam kong yan ang phrase of the day. Let's not be technical. Phrase of the week, phrase of the month. But we have to be able to explain these things in a way that people understand without forgetting that these are rights of the defense and rights of the person who is being tried here, and kailangan maliwanag yung ating mga accusations. So, my question now goes to both the prosecution and the defense. I know that the defense, in their answer, questions the failure of the complaint or the articles to allege ultimate facts, and therefore I think they filed the case before the Supreme Court. I'll give you your time to answer because I don't really recall that I heard it mentioned in the oral argument. So again, with the permission of the presiding officer, papasadahan ko lang naman na nabanggit ko yun na nandyan yan sa nandun sa memorandum, pero hindi ko naalalang, I'm just speaking naman for myself kung ano yung mga sinabi ko dun sa aming meeting na hindi ko naalalang nabanggit. Baka naman nasabi, hindi ko lang naalalang na-emphasize kasi nga limited yung time. But I do recall that it's in the complaint, it's in the answer, and then it's also in the memorandum. So, pinupursue nyo pa ba ito? Kasi me as a judge, importante to kasi paano ba didepensa ng maayos kung hindi nga nag-a-allege ng ultimate facts that go into the case. And then, for the prosecution naman, may I ask you kung saan because bawal ho na tanungin ko for you to state your case. I cannot do that, no? But what I'm asking is if you can point out sa inyong articles kung saan doon yung allegations of ultimate facts. Kasi public document naman yan eh. Para lang maaral ko, naasan dyan yung allegations nyo of ultimate facts. And this is where, before I pass on the floor to the parties to answer, I want to go into the principle of fishing expedition. Nagkataon na I came across the trial that we had for former Chief Justice Corona, and lumabas yung issue na yon. Nasabi ko, eksakto ito yung pinag-aaralan natin for today. Yung fishing expedition, and no less than the defense had to explain it in Filipino kasi sabi, baka hindi alam yung ibig sabihin ng fishing expedition, pangingisda ba daw yun? Parang hindi naman daw yun yung translation, no? Pero ito yung naghahagilap ka ng ebidensya kasi wala kang ebidensya. So, I'll go back to a case and sama nyo to sa response nyo. Doon po sa kasong Afologencia versus Metrobank in 2014, humingi dito ang petitioner ng motion for issuance of subpoena ducis tecum ad testificandum at sinabing padala daw ng documents relative to their loan to Metrobank, as well as those covering extrajudicial foreclosure. Sabi ng Supreme Court, this is tantamount to building their whole case from the evidence of their opponent. Bawal daw yun. Hindi daw pwede na yung kaso mo, nakabase lang dun sa, sasabihin mo dun sa kabila, labas mo nga lahat ng meron ka dyan. No, your case has to be built. Yung evidence mo has to be there. So I will also ask both parties, is that jurisprudence relevant to this case for the prosecution and then also for the defense? And then let us also include a discussion on why this is or is not a fishing expedition. Yun nga, napaka-importante po kasi ito dahil it is ingrained in a complaint na yung allegations mo ng ultimate facts, mapoprove mo ngayon yun with the evidence. Hindi pwede na wala kang ebidensya, hihingin mo lang ng hihingin by way of subpoena. Clear po yun sa batas. Kaya nga gusto kong ipaliwanag nyo sa akin, educate me why this applies, why this is not a fishing expedition, why the case I cited does not apply, because I assume that's the position of the prosecution. And then for the defense, ano naman po yung position nyo? Salamat.
The counsel for respondent will give his answer first with respect to the question of Senator Judge Pia on ultimate facts as well as on fishing expedition. Thereafter, counsel for the panel of prosecutors. You may proceed, sir, when you're ready.
Thank you, Your Honor. Pagdating po doon sa sinasabi namin na lack of ultimate facts, no? Ito po yung nagsimula pa lang doon sa Committee on Justice when the impeachment complaints were filed. Because the allegation, and I'll stick just with this, I believe, Article 2. No? Pagdating po kasi doon, there was an allegation of unexplained wealth. Pero wala pong nakasulat kung saan nila nakuha, ano yung basehan ng unexplained wealth na yon. Ano yung act na ginawa ng Vice Presidente, kailan yon ginawa, at so sa amin, para masabi nilang nagkaroon ng unexplained wealth. Ang basic, if I may remember, was really just the fact na yung SALN niya ay lumaki from 2007 to 2025. Which sa aming palagay, does not show any factual allegation whatsoever, except for the fact that it grew bigger over a span of 20 years. Pangalawa, wala rin pong naka-attach, which I mentioned in the oral arguments last week, na kahit anong ebidensya or kahit supporting document man lang, wag na nating tawaging ebidensya, supporting document that will support any allegation whatsoever of unexplained wealth. And that is why, nabanggit ko rin, na after the allegations were made, and this is even more significant, after the respondent had filed her answer, na tinawag pa nga nilang non-answer, doon lang po naghanap ng mga ebidensya na sakaling makasuporta doon sa aligasyon na iyon. That's very important for us because we had already filed our answer before AMLAC documents were suddenly produced with the issuance of subpoenas, before the BIR box were concerned, that we are concerning ourselves with was presented before the Committee on Justice. Nasa panahon na yun, tapos na po kami sumagot. In fact, when they were saying that it was a non-answer, to be very candid with everyone, we wanted to say because it was a non-complaint. Kasi walang ultimate facts na naka-allege for us to even answer. Now, before this honorable court, I do recall that in our answer, we also took pains to discuss the lack of ultimate facts and also what we feel were violations of due process before the Committee on Justice, or at least with the proceedings that were conducted before the Committee on Justice. And that is also why we have a pending motion for exclusion na ikinalakip namin dun sa answer precisely because we were objecting to the fact that these pieces of evidence were produced after we had already filed our answer. Now, on the fishing expedition, I think on the fishing expedition, Your Honors, our main point is this. Even if we read the twin requests for subpoenas, paulit-ulit po, nakasulat po doon, because this may show context, because this may show, prove something. At para sa atin, this only shows, and at least, again, on the part of the defense, this is somewhat already an admission na hindi pa nga nila alam kung ano mismo doon sa mga hinihingi nila ang pwedeng sumuporta sa mga aligasyon na unexplained wealth. And that's why, if you read the entire request, it uses the word may several times, and it even says in one paragraph, I think it's 3.24, but I might be mistaken, that at least with the request for, with their memorandum, rather, in their memorandum, nakasulat po doon that this does not assume wrongdoing, but they want those documents nonetheless to see if something there will actually help support their allegations. That is why we are calling it a fishing expedition. Dahil in Tagalog, para po maintindihan, sa aming pananaw, sa dami ng hinihing dokumento, para po itong nagtatapon po tayo sa dagat ng isang napakalaking lambat At umaasa tayo na kahit papano may mabingwit kahit isang pirasong ebidensya. Maraming salamat po.
Counsel for the panel of prosecutors, the Honorable Jokno.
Thank you, Your Honors. The question propounded to this representation first is, what are the ultimate facts alleged in the Articles of Impeachment? Yun po ay nakasaad sa page 7 of the articles. And if I may be allowed to just read them briefly.
You may do so, Counsel.
Thank you, Your Honor. Respondent Vice President Sara Z. Duterte committed culpable violation of the Constitution and betrayed the public trust when she, A, amassed unexplained wealth manifestly disproportionate to her lawful income and earnings during her incumbency as a public official. B, failed to fully and truthfully disclose all her and her spouse's assets, liabilities, and net worth in her Statement of Assets, Liabilities, and Net Worth, including in her SALNs for the years 2022, 2023, and 2024. And C, failed to divest and instead willfully continued all her business interests during her tenure as Vice President for the years 2022, 2023, 2024, and 2025. Please allow me to briefly explain why these are ultimate facts. Ultimate facts are basically the essential factual elements that make up a party's cause of action or defense. Halimbawa po, pag murder, treachery, evident premeditation, lahat ng mga kinakailangan ng batas para mapatunayan na murder po siya. In our case, we are alleging, first of all, unexplained wealth. And based on the jurisprudence, the elements of unexplained wealth, the factual elements are amassing unexplained wealth, manifestly disproportionate to one's lawful income and earnings during one's incumbency as a public official. So, nasatisfy po namin yung requirement na pag-allege ng ultimate facts or essential factual elements sa tatlong bagay na po ito. The evidentiary facts follow in the succeeding pages of the articles. Doon namin dinetalye kung ano yung mga iba't ibang paraan kung paano nakuha o naamas ni Vice President yung sinasabi natin na unexplained wealth. On to the issue of fishing expedition. Fishing expedition po ay halimbawa may sabina na baka sakali meron tayong makita. Yun po ang ibig sabihin ng fishing expedition. When the party requests information does not know what might be produced and just as an off chance tries to use that instrument in order to gain evidence that may be used against the other party. Dito po, malaki ang pagkanang sitwasyon. Malo ninyo, during the hearings before the Justice, the Executive Director of the Anti-Money Laundering Council testified and produced documents showing that from 2007 up to the present, 6.7 billion pesos ang dumaan sa account ni Vice President Sara Duterte. On that basis, and if we go deeper into that report, says that during the period from 2007 to 2013, during the time that she served as mayor and mayor, umabot po sa o lampas 3 bilyong ito ang dumaan sa kanyang accounts. So may basehan po tayo pa ipalabas ang bank records. We are not just guessing that there is something there because the AMLA itself confirmed that there were covered and suspicious transaction reports submitted to them in those amounts that I mentioned. Malayo po ang fish edition sa ginagawa ng prosecution dito po. If we had no basis, if we did not know it was in the AMLA reports, yun po, maaring sabihin na fish expedition. But in this particular case, because these are matters of record presented before the committee this. Second po, ang fishing expedition, maaring magamit yan sa ibang mga alegasyon tulad na baka meron kang hindi clear sa iyong SALN. When it comes to issues of explained wealth, it's clear. The decisions of the court are clear. To know whether a government official has amassed unexplained wealth, we must look at the incumbency of that shell. Starting from day one, we look at their SALN, we look at the income that he or she earned, lawful and not, and from there make a determination whether there was explained wealth or not. These reasons, Your Honors, the fishing edition argument, in our view, totally untenable.
Senator Judge Pia, you have further questions?
It's actually just a follow-up at the prosecution, how the prosecution responded. I think Alan, Peter will go into it, but since this is my line of questioning, I'll follow on this point. No, His Honor, I mentioned the fruit of entry doctrine. And ulit po, pagka yung pinanggalingan ng nation nyo, bawal, hindi nyo na pwede gamitin yon. So, His Honor said, referring to Congressman Prosecutor Jokno, they know the contents of the AMLA report, something to that effect, because it was presented in the impeachment hearing in the House. That is correct, right? That is your statement?
Yes, Your Honor.
Yes, oo. And I asked my question, and again, I will give both parties the opportunity to respond. Ano yung basihan na i-reveal ng AMLC and their representatives sa inyo in the impeachment hearing in the House? Because ang nakasaad sa law, I don't even want to use my understanding of the law because it's what is read in the law. And I won't take up the time of this court na isa-isahin ko yun, pero nakasulat doon na confidential ito. So, ano yung basis na mailabas yun doon sa impeachment court? Because, and since the presiding officer has given me the permission to share in general the discussion in our caucus last week, isa dun sa napag-usapan namin precisely was yung information na lumabas doon. Kung yan ay walang basihan na ilabas, walang legal basis na ilabas yung information, hindi yan pwedeng idugtong dun sa mga allegations na meron kayo. So that's my question. And during our caucus, isa din sa lumabas na discussion, pero allowed ang AMLC and the specific officers to share that information. But the specific provision of the law, and please, both counsels, please respond, please elaborate on how this supports or does not support your case. A specific provision dun sa batas, yung sharing of information na yon, sabi, oy, kayo AMLC Council, mag-develop kayo ng rules kung paano kayo makakapag-properly share sa agencies. I believe, and again, you feel free to elaborate on this or correct me, that's referring to the bank institutions, the AMLC hierarchy, and the agencies they deal with, not in court. Because, ulitin ko, nakasulat doon, confidential. So, I will leave this here, that if it is confidential, it does not allow that this be divulged in the manner it was divulged. Then how do you use that? Because that is precisely the doctrine of the fruit of the poison tree. Please take your time to tell us why that information is not the fruit of the poison tree, and obviously for the side of the defense, they will tell us why they believe that it is the product of the fruit of the poison tree. Thank you, Mr. President.
Counsel for the panel of prosecutors will please respond.
Your Honor, Section 8A of the Anti-Money Laundering Law is really intended to prohibit or prevent leaks by officials of the Anti-Money Laundering Council. But it was never intended to prevent subpoenas coming from courts, including the impeachment court. Almost every week, the Sandigan Bayan issues subpoenas for AMLA records. And despite what would appear to be a very categorical prohibition contained in that section, every time subpoenas are issued by the Sandigan Bayan, they are honored by the AMLA and no one is questioning them. Ganun din po itong impeachment court. The subpoena issued by this impeachment court is for the purpose of determining accountability based on the power that is expressly given by the Constitution. Ang aming pong paniwala is that confidentiality cannot trump accountability. Thank you.
Counsel for respondent.
Thank
May
you.
reply.
Thank you, Your Honor. I cannot verify if indeed the Sandigan Bayan, as mentioned by opposing counsel, issues subpoenas against AMLAC every week. So that I will not comment on because I cannot verify that. What is clear to us, Your Honors, as we have demonstrated last week, is that 8A is an absolute prohibition. And again, this was the latest amendment of the law back in 2021. And for us, Your Honors, that is why when this was presented, the House Committee on Justice, we had our objections to such matter. And in fact, Your Honors, it is the subject of our petition, the Supreme Court, and aside from that, a subject of our motion for exclusion before this Honorable Court. Ngayon po, sa atin, talagang yung tinutumbok natin is, it is in fact within the fruit of the poisonous tree. In fact, I'm surprised, Your Honors, because, Your Honors, nabanggit na rin po ng aking distinguished opposing counsel na nakita na nila, may records na sila. In fact, if I'm not mistaken, it was also attached to the Articles of Impeachment. So kung meron na pala, bakit pa nila pinapasapina ngayon sa impeachment court? Is it because, I don't want to speculate, maybe I just won't go there. But ang sa akin lang po is, we have questioned this all throughout. No? Why? Because to us, unang-una, bawal siya. Pangalawa, hindi siya relevant. Bakit hindi siya relevant? Your Honors, transactions do not equate to wealth. Transactions do not equate to net worth. Especially if tinatali natin siya sa SALN. Because transactions happen over the course of the year, and in this case, years. Well, when you talk about SALN, we talk about net worth on a specific date in time, which is December 31 of every year. So sa atin po, ang aming pananaw dito ay hindi po relevant at hindi po, it will not directly show anything about wealth. Kasi, again, AMLAC transactions do not equate to net worth of a certain person. And that is why, Your Honors, we have opposed this. And we have opposed this since the time it was being presented at the House level. Thank you, Your Honors.
Just for the record and for the information of the Senator Judges, I'm not sure about the Sandigan Bayan issuing a subpoena every week as well against AMLAC. But I'm well aware, the court is well aware of cases decided by the Supreme Court precisely on subpoenas issued by the Sandigan Bayan vis-a-vis the AMLC. Senator Judge Pia, can you wind up? You're done? At this juncture, Chair will now recognize Senator Judge Alan Cayetano for his interjection and questions. You may proceed, sir, when you're ready.
Before I ask question, Mr. Presiding Officer, may I thank you, the Senate President Win Gatchalian, former Senate President Tito Soto, and the whole court, because in our caucus, you did three things. One, you allowed us to have the weekend to review all of the laws so that we can ask more intelligent questions. Two, you allowed to hear the discussions, mostly by Senator Pia, Senator Pangilinan, Senator Lacson, and former Senator Soto. And then number three, we discussed how a complex, or what word did you use a while ago, Mr. Presiding Officer, that it's two motions, but there are
may be issues underneath.
Issues and sub-issues. So that after we ask questions and after you make a ruling, we'll instead dalawang side today because you have the eloquent attorney Jokno on one side and the eloquent no joke on the other side. So sa pangalan pa lang baliktad na. But I think the discussions are very important and I do appreciate your opening, Congressman Diokno. I appreciate your oral arguments because I've been pondering these questions. What if, hindi ko na sabihin this administration, let's say in future administrations, this exact thing happens, 5 years, 3 years, 10 years, iba ang SALN, iba yung income ng COA chairman or ng ombudsman. Ombudsman files cases, many, mukhang maraming congressman makakasuhan ngayon. So, very, very much relevant yung ating pinag-uusapan ngayon. So, just in the spirit of liberality, same kay Senator Pia, after one answers, if one wants to make a quick rebuttal, I'll ask you the question, but let's try to be concise. So, Counsel, may I ask, let's start with the case of Duterte versus House of Representatives. Thank you for reminding us about certain precedents and how I voted last time. But you would agree, di ba, that when you have legal proceedings, even in legislation, you follow what the latest law is. So, for example, if you're allowed to issue a general warrant before Stonehill versus Jokno, but after Stonehill versus Jokno, so if before Stonehill versus Jokno, walang doctrine of the fruit of the poisonous tree, then some doctrine of the fruit of the poisonous tree, then some policemen will still submit evidence that was illegally acquired. But after that, we have to follow. So you did make your point about obiter dictum. I'll go to that. But I just want to start out by saying the fact is there is a Duterte versus House of Representatives. So with your permission, let's start discussing that. So this case of Duterte versus House of Representatives came out after the impeachment of CJ Corona, correct?
Yes, Your Honor.
And the two elements was discussed in this case. The act charge must be impeachable under Article 11, Paragraph 2 of the Constitution, and 2, the act committed must be committed during the term of the impeachable officer. You commented on that. Can you elaborate or give your stand regarding, I think you agree with letter A, right? That the charge must be an impeachable offense. I mean, we all agree on that, right?
Well, I would distinguish, Your Honor, please, between what we would call ratio decidendi, or the rule in that particular case, and obiter dicta, which are side comments or incidental remarks made in the opinion of the court. If we are speaking of the ratio decidendi of the Duterte versus House of Representatives case, I would have to disagree that it relates to the statements that you mentioned. My understanding of that case is it really relates to the first mode of impeachment and the procedures that must be followed, the one-year ban provided in the Constitution, how that will be applied when impeachment complaints are filed by at least 1/3 of the members of the House of Representatives. Yung pong nabanggit nila that the basis of any charge must relate to the incumbency of the official, in my view, that is obiter dicta, not necessary
I
for the
appreciate your
decision of
answer.
the
We'll go
case.
to that. But regardless of the Duterte versus House of Representative ruling, we do agree with letter A. The act charged must be an impeachable offense under Article 11(2) of the Constitution.
I would agree, but if
Yes.
I may be allowed to just qualify
No, this is just
that.
a general. It's not a trap question.
No,
So,
Your
diba,
Honor.
so the officer has to be impeachable, and the acts charge should be an impeachable offense. And since you have betrayal of public trust, that's quite broad. No? So this is not a trap question. This is just laying the basis. But go ahead if you want to comment on that.
Yes, the acts charged must constitute an impeachable offense, and that power to decide what is an impeachable offense is lodged exclusively with this honorable court.
Okay. So you disagree that part of the ratio decidendi is the act must be committed during the term of the impeachable officer. Thank you for bringing it up now, because I think all throughout the trial, especially in the articles where we will bring up acts before 2022, this discussion will be relevant, no? So by discussing this, it will pass upon the whether or not including proof like bank records, financial documents, before her term can be inquired into. The prosecution says it cannot, right? because you believe it's an obiter dictum. I'm just restating. You can say it in your words. You believe that the statement that the act must be committed during the term of the impeachable officer is not the law of the land. It's an obiter dictum.
In the first place, if Your Honor, please, that was not the exact statement of the court.
Okay.
The court said the basis of the charge must relate to the incumbency of the impeachable official,
Yes.
which does not rule out the presentation of evidence of acts or omissions that occurred before the person became an
So
impeachable officer.
let's take the judicial notice of the, as you said more eloquently and correctly, that the acts during her term. So can you define, you defined this in your opening statement, but for the sake of this discussion, an obiter dictum is what?
It's a side comment, Your Honor, that is not necessary for the resolution of that case.
Yeah, and I agree with that, and it's a remark made or opinion expressed by a judge in a decision upon a cause, or it's a by the way, that is incidentally or collaterally and not directly upon the question before him, or upon a point not necessarily involved in the determination of the cause, or introduced by way of illustration, analogy, or argument, such are not binding precedents. No? Just for the public and for all of us, di ba?
Yes,
So
Your
ang
Honor.
sinasabi, yes, there can be a Supreme Court decision, but that part could be an obiter dictum, meaning hindi yan yung doktrina that will bind us in making decisions, whether it's issuing the subpoena or admissibility. But are you aware of the Villanueva versus Court of Appeals, GR 142947, March 19, 2002? I won't take it against both of you if you do not. There are thousands of cases. It talks about what is obiter dictum. Have you passed about on this, both counsels? Yeah, so the prosecution characterization of the requirement that the basis of the charge must be for impeachable acts or omissions committed in relation to their office during the current term of the impeachable officer as an obiter dictum. But in the Court of Appeals, in Villanueva versus Court of Appeals, in that case, the Supreme Court held an adjudication on any point within the issues presented by the case cannot be considered an obiter dictum, even where the point is only incidentally involved. So we agree if it's incidental, pwedeng obiter, but if it's on point within the issues, sabi ng Villanueva case, it is not. So long as it is presented and decided in the regular course of the consideration of the case and led up to the final conclusion, or is a statement as to the matter of which the decision is predicated. The court added that a point expressly decided does not lose its value as a precedent because the disposition of the case is or might have been made on some other ground, and that where a court decides several points, none of such points can be regarded as having the status of a dictum. And one point should not be denied authority merely because another point was and more dwelt on and more fully argued and considered. So going back to the Duterte versus House of Representatives, the requirement that an impeachable act be committed in relation to their office and during the current term was not a remark made by the way. The Supreme Court en banc laid it down as one of the enumerated principles that due process requires, which is the very ground on which the ruling was predicated. Even if the court also struck down the 2025 impeachment complaint based on the one-year bar, so this is the question, does it not render the due process requirement laid out as a mere obiter dicta, or because it's based on due process, regardless of the mode of initiation, regardless of the mode of how the articles of impeachment got here, isn't due process still a requirement?
If I may be recognized,
Yes.
Your Honor.
Counsel for the panel of prosecutors may respond.
Precisely, Your Honor. If a matter is within the issues resolved by the court, then it may not be considered as obiter dicta. But if we look at the decision in the case of Duterte versus House of Representatives, ang mismong nangyari po doon ay may naunang dalawang complaints that were endorsed at may sumunod na complaint filed by at least 1/3 of the members of the House. At yun yung tinutukan po ng ating Supreme Court. It was in that context that the Supreme Court made pronouncements about the one-year bar and even about due process. At no time in that case was it ever a fact in issue about the mode of impeachment that is involved in our case today. Ang pinag-uusapan po natin dito ay individual complaints that were then referred by the House to the Committee on Justice, heard by the committee, and then brought back to the plenary and eventually umabot po dito through Articles of Impeachment. So kahit may sinabi ang Supreme Court about impeachable offenses in relation to the charges, kami po ay naniniwala na hindi po yan pumapasok o sumasakop sa issues that were decided in that case.
I'll not argue with you because that's not my job here. I'll follow the Pia Cayetano style and move to the defense. But just a follow-up question on that. So I respect your belief on that. But my point is, the legal principle of due process applied to that mode, is it not logical that it's the same legal principle on due process even if you use another mode?
First of all, if Your Honors, please, when we speak of due process, of course, there are two types, substantive and procedural due process. And when we speak of substantive, we're talking about protections to life, liberty, and property. Wala naman pong ganun na issue po dito sa atin because office is not a property. We're not talking about the life or liberty of the respondent. Ang pinag-uusapan po natin dito kung due process ang issue ay simply fundamental fairness. And I do believe that this proceeding does require fundamental fairness, but at the same time, it does not require that this court be hamstrung in terms of how to decide whether an offense is impeachable or not. That power is exclusively given to this court at dapat kayo lang po ang magdesisyon at magpasya kung ano nga ba yan. So when we speak of what is an impeachable offense, may kaugnayan po yan doon sa nabanggit ninyong the basis of the charge must relate to the incumbency because in our view, that is really something that each member of this honorable court will have to decide when the time comes.
Yeah, later on, I'll ask you that question, whether or not, what, if ever, can the Supreme Court decide or what of their pronouncements will be applicable to this court and that. But my point is, if we're saying that pag ang mode of initiation is by 1/3 na pumirma diretso at ang nakalagay doon committed in relation to their office during the current term, wouldn't it be illogical if you use another mode and pwedeng hindi committed in relation to their office and during their current term? I don't think the Supreme Court would be illogical in saying this is the principle for due process in this mode but not in this other mode.
Even if we assume, Your Honor, that that is not obiter, the statement that the basis of the charge must relate to the incumbency of the impeachable officer, we submit that that still applies and we have satisfied that test.
Okay.
As I mentioned in my opening statement, integrity cannot be divided. Hindi po pwedeng biyakin ang integridad.
So on that point, so if President, an ombudsman, a COA chair, who's let's say 60 years old but he started in government at 20 years old, he can be impeached by something he's done when he was 20 to 30, not only on what he's done when he was already an impeachable officer?
If we are speaking about unexplained wealth, Your Honor, I have repeatedly cited the cases of the Supreme Court that provide that we must look from the reckoning of the first day of service of that public official, look at all the income that person has amassed, and determine whether it is manifestly disproportionate to the lawful income that he has reported.
Yes, I agree in terms of holding that person liable and accountable. But what I'm saying is that, let's say he was a counselor, then he was a customs director, then he was BAR, then he's now COA. Isn't the remedy for all his other positions that weren't impeachable is through the regular courts and regular case build-up, etc. But once you're an impeachable officer, you're being held accountable during the term that you are, in fact, an impeachable officer because usually when you're an impeachable officer, it's too hard to prosecute you the normal way. Isn't that the logic there, or you disagree, Counsel?
I would have to respectfully disagree. Ang pinag-uusapan po natin kasi dito ay betrayal of public trust. And I think it's very clear that when we speak of betrayal of public trust, essentially we are looking at whether the public official is fit or unfit to continue in service. Kung siya po ay nakapag-amas ng unexplained wealth, nung siya ay vice mayor o mayor na umaabot sa bilyon-bilyones, I think that would have a very big impact on the court's decision whether that person should continue in office or whether they are fit to have that office.
Okay, as I said,
With the permission of Senator Judge Alan Cayetano, with your indulgence, sir, a request was conveyed to the presiding officer to declare a very brief break. This is not a break for all of us, but a very brief break of 5 minutes so that counsel may answer to the call of nature. That was the message conveyed to the presiding officer, including Senator Judge Cayetano. So, Chair declares a 5-minute break. We shall resume at 4:05. aircon daw, mainit yung sa plenary. Monday?
Monday, sir. Next time.
Alam mo nyo. Wala may The trial is resumed. We shall resume the interventions of Senator Judge Alan Cayetano pertaining to the issue at hand on the twin request for subpoena prosecution. You may proceed, Senator Judge Alan. You're ready.
Sir, Presiding Officer, if I may start, whether or not the defense, although they stated already opening statement, considers such statement in the Dutertes as obiter dictum, and I reiterate, it's very important that we understand and come to our own conclusion because many times during this trial and even in the decision to make, this question will play a center, will be front and center. So, ask Attorney Poa, do you think the statement was a obiter dictum?
As stated, Your Honors, thank you for the question. As stated last week, Your Honors, it is our position of defense that that is not obiter dictum, precisely because, Your Honors, it is our theory that when the Supreme Court decided the case Duterte versus HOR, that the one-year bar was triggered precisely because there was a violation of process. That's why, if you read the decision, Supreme Court, through its of course, Associate Justice Marvic Leonen, painstakingly discussed what due process is actually in an impeachment proceeding. In fact, there was a line in that decision that says that they wanted to clarify the guidelines on impeachment proceedings. Further to that, Your Honor, hindi lang po sa decision, pero pati po doon sa binibigay na primer or summary ng Supreme Court bago nila ilabas yung buong decision, they enumerated the guidelines which were around 7 points, if I'm not mistaken. And the 6th point is actually on what is an impeachable offense. And in fact, we have prepared copies of that primer for the senator judges, which we can distribute, so that makita po nyo na while ang effect ay na-trigger yung one-year bar, it was really due process that the Supreme Court was discussing in that case to guide. Yes.
Commission Counsel for Respondent, kindly submit that to the Clerk of Court.
Yes, Your Honor.
Thank you. You may proceed, sir.
So, while as I was saying, Your Honors, while yung ang end result is na-trigger yung one-year bar, and that's why void yung naging first round of impeachment, ang talagang pinag-uusapan ng Supreme Court dito is the observance of due process in every stage of the proceeding. And that is why it is very important na mapag-usapan natin na yung kasama doon is really kung ano ba talaga ang isang impeachable offense. At nakasulat doon, if I may quote, the basis of any charge must be for impeachable acts or omissions committed in relation to their office, meaning in relation to their impeachable office and during the current term of the impeachable officer. So that is why, Your Honors, it is the view of the defense na hindi po obiter lang itong pronouncement ng Supreme Court na to as to what constitutes as an impeachable offense.
Yes. I'm not texting. I got on my phone the Duterte versus House of Representatives because, of course, my follow-up questions was to get into the mind of the prosecution when to apply the Duterte case and when not to. So, but I'll still ask you the same question So what's more logical, that the due process requirement that that the acts committed should have been on the term is also applied to the other modes or just to the one-third mode?
All modes of impeachment, Your Honor. That is our position. Kasi po, we would veer into absurdity, no? Na kung dun sa one-third mode tayo, ang impeachable offenses limited lang sa term, pero pagdating doon naman sa other mode, which dinaanan, admittedly, at yun ang dinaanan nitong current proceedings natin, mag-iiba ang definition ng impeachable offense. I do not see any logic on why there's a difference because an impeachable offense is an impeachable offense. So para po sa atin, that should apply. And in fact, the Supreme Court did not make a distinction as to the guidelines that it laid down in that decision, Your Honors, please.
Yeah, so in the first page, sabi dito, second, considering the nature of the offices and the institution that are subject to impeachment, in effect, its effect on the independence of constitutional departments and organs, and its nature as a constitutional process, all legal issues involving impeachment proceedings are subject to judicial review. While the court does not determine when, who, and whether an impeachable officer may be removed and disqualified from political office, it has the duty to construe and process mandated by the Constitution. So is this for you part of the ratio decidendi, or is this a obiter dictum?
Ratio, Your Honors. In fact, that's why the Supreme Court, when it started the decision, said that the end does not justify the means, no? Because it was precisely discussing the means. Ano ba yung dapat nating sinusunod na proseso?
Yeah. So since we're talking about subpoenas, we'll go to the end and the means, the justified means.
With the permission of Senator Judge Allen, I would just like to get the assent of the counsel from the panel of prosecutors. The document sought to be distributed by the counsel for respondent is a July 25, 2025 discussion on the Duterte v. HOR on the one-year bar rule. Again, it's dated last year. With the permission of the prosecution, we shall distribute it without prejudice to the counsel for the panel of prosecutors to also furnish whenever it shall so desire, because this issue, as pointed out by Senator Judge Cayetano, will linger until the end of the proceedings, without prejudice to the counsel from the panel of prosecutors to so furnish also Senator judges with their rejoinder to this document being furnished to the Senator judges. Is that okay?
Your Honor, I believe that, first of all, may we request for a copy of that document. I believe that document refers to the office of the spokesperson.
That's correct,
of the Supreme Court, in which case, Your Honor, we would have to interpose an objection because any interpretation by the office of the spokesperson is not binding on the Supreme Court. What we must look at are the actual text of the decision.
Well, counsel, you can say that in your rejoinder. Point that out in your rejoinder and point that out in your submission.
We will do that, Your Honor.
So ordered. Clerk of Court is directed to kindly distribute the copies to the Senator judges without prejudice to the panel of prosecutors submitting a rejoinder to this document. Yeah. Senator Judge Alan Cayetano, you may proceed, sir.
Yes,
Apologies for the interruption.
Presiding officer, to be fair to the, I wouldn't have objected if you objected to the distribution, but realistically, we won't have time to read it because magruruling na after.
Yes.
So it'll be more of reference materials. But feel free also to, if you feel that you should submit in writing a rejoinder to be fair to everyone. So if the voting was tomorrow, and it would be unfair to distribute it. So can I ask the same question, Congressman? So I read, it's the first few paragraphs, no? Sabi kasi dito, you heard me naman, no? You want me to read it again, or?
If I may be allowed to respond already to the
yes, go ahead.
question. Well, first of all, Your Honor, I think we must point out one of the plainest reasons why that statement in the Duterte ruling is obiter dictum. And that simply is because there was no trial yet to speak of when the Supreme Court rendered that decision. Paano po magiging issue yung nangyayari ngayon sa trial, samantalang nung dinesisyonan po yan ay wala pa pong trial? Therefore, any statements by the court about how the trial should be conducted are outside the issues of that case, and while they may be guidelines, they are not binding as judicial precedent to us and to the future generations.
Actually, I was referring to a different matter already, but just to that point, it's not how, it's what. Because it's paragraph 6. So the basis of the charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. For the President and Vice President, these acts must be sufficiently grave, amounting to the crimes described in Article 11, Section 3.1 of betrayal of public trust given by the majority of the electorate. For the other impeachable officers, the acts must be sufficiently grave that they undermine and outweigh the respect for their constitutional independence and autonomy. So this doesn't really tell us how to conduct the trial. This basically tells us that if we don't follow that, we're endangered of having a trial that's void ab initio.
I would have to respectfully disagree, Your Honor.
Anyway, we've gone through that argument, and I won't argue with both of you. Going back to this is what I read, no? Second, considering the nature of the offices and the institutions that are subject to impeachment, its effects on independence of constitutional department and organs, and its nature as a constitutional process, all legal issues involving impeachment proceedings are subject to judicial review. I'll stop there. Kasi nabanggit mo kanina, may I speak English Filipino? Nabanggit nyo po kanina na that's for us to decide. And my interpretation, and I've felt like that many, many times, di ba, na zealous dapat ang impeachment court sa powers niya kasi not only because it's sui generis, wala tong apologize to Senator Judge Risa, my phone fell there. So, wala nga tong, you cannot appeal the decision of my belief, no? You cannot appeal the decision of to acquit or to convict to the Supreme Court, di ba? But the parameters, so let me use the words of the Supreme Court, no? Ang sabi niya, all legal issues involving impeachment proceeding are subject to judicial review. So, you disagree with this or you agree? In context ng sinabi mo kanina na it's within our power to make these decisions.
I believe the controlling decisions there, Your Honor, are the cases of Gutierrez and Francisco. Because in those cases, the issue of what is an impeachable offense was squarely brought before the court. And the court said very clearly that that is purely a political question that's not within the judicial power for us to decide. And I believe that that should be the controlling jurisprudence.
So let me be more specific. So for example, we issue some subpoenas and we do not issue some. Can one or both of you, meaning the prosecution and defense, go to the Supreme Court and question it?
Well, there is always the possibility that some side, perhaps the defense, may claim that there is a grave abuse of discretion, I believe, as they have done in their other petitions filed, and therefore make an attempt to stop the proceedings before this court. But as I have said last week, Your Honor, in our opinion, this court has the sole and exclusive power to decide what an impeachable offense is, and no one, not even the Supreme Court, can dictate on this court in making that decision.
Yes. Same answer.
No, Your Honor. I have a different...
So, okay, you can go back to that question. Then my follow-up question was, so let's say certain orders of the court, can the prosecution or defense go up to the Supreme Court and question its constitutionality?
Yes, Your Honor. It is our position that either of the parties can do that. Why? Because sa atin nga, ang sabi natin kanina, that the Constitution cannot be read in isolation. So while the Constitution gives the sole power to the Senate to try an impeachment case, to try and hear an impeachment case, we must read this in conjunction with, again, Article 3, Bill of Rights, and Article 8, specifically Section 1, which is the power of judicial review. So pag sa tingin po ng isang panig, merong grave abuse of discretion na naganap, We are of the position that, in fact, this is a justiciable issue and can be brought before the Supreme Court, Your Honor.
So at least in that small point, I think we all agree that if we think there's grave abuse of discretion, there's a possibility that the Supreme Court will take it up. I'm not referring to the subpoena, I'm talking in general. So I'll skip a few pages of my questions precisely because I wanted to elicit your opinions or your stand regarding the fact that the impeachment court is supreme, but it's not true that we can do anything or we can just make decisions that are not based on statutes and on legal orders. In fact, when the Supreme Court issued a TRO regarding the foreign accounts or the dollar account in the Corona case, the impeachment court voted to respect the TRO. No? But of course, we did vote. So there could have been a constitutional crisis if we voted not to. And then, of course, we know because of history, nag-waiver na lang si Chief Justice Corona. No? So can I go now to the ultimate facts? No? I don't know if Senator Joel, but Senator Pia asked a little bit about this. Just a quick review, or maybe, so we're also governed by the rules of court when it comes to ultimate facts. This is what Section 1 says. In general, every pleading shall contain in a methodological and logical form a plain, concise, and direct statement of the ultimate facts, including the evidence, on which the party relies on his or her claim of defense, as the case may be. If a cause of action or defense relied on is based on law, the pertinent provisions thereof and their applicability to him or her will be clearly and concisely stated. So does the two councils agree that sa ultimate facts, you have to include the evidence?
I would make a distinction, Your Honor, between what we call ultimate facts and evidentiary facts, which are the pieces of evidence that could be used to come to the conclusion or to decide whether those ultimate facts are present in the case or not.
Yeah, I think all of us lawyers agree with that. There's a difference between ultimate facts and evidentiary facts. But the rules of court says, including evidence. Kasi kung walang including evidence, de ang kailangan mo lang i-file, ultimate facts. Pero pag sinabing kasama ang evidence, for me, it doesn't mean that every single testimony in every single document should be attached. But so let me go to my second question. So pwede bang sa Articles of Impeachment, ultimate facts lang, walang naka-attach na evidence?
Ang requirement po sa pleading ay doon na dapat nakasaad ang ultimate facts. But if you look at the Articles of Impeachment that are before this court, it also contains evidentiary factual allegations to support the ultimate facts that are contained therein.
Thank you for that answer. Actually, that was my next question. Did it contain? And you answered it. So, with respect to the Saballa and Cabrera impeachment complaints, is it correct that there was no authentic records that were attached when they were filed? Factual lang tong tanong ko.
If Your Honor, please, first of all, I would have to raise an issue with respect to whether this honorable court is acting as an appellate or review court of what happened during the House proceedings. The power to initiate an impeachment complaint is exclusively lodged with the House, while the power to try and decide that impeachment case is exclusively lodged with this honorable court. And I don't believe that it is part of the function to go back to what may have happened during the proceedings before the House, since the articles have already been transmitted to this honorable
court. Counsel, even your students, colleagues, recognize that you are a brilliant man, you're very well learned sa law, but minsan mabilis. Kasi actually, that's not where I was going. Binaliktad ko lang. So two of my colleagues started with, or in your discussions, ano yung fishing expedition going down to ultimate facts and evidentiary. Ako, I wanted to distinguish when is it a fishing expedition and when it's not. So I just wanted to know as a fact. Or can we take judicial notice that there was no authentic records in the Saballa and Cabrera?
What's the point again, Senator Judge? There were no
it was-
authentic...
It was just preliminary because I wanted to compare it with other impeachment complaints. And I wanted to ask the question, when is it a fishing expedition o hindi? So these are legitimate questions. So factually, yung sa Balya and Cabrera ba, may authentic records attached. Ang information ko, wala. But I don't want to...
I believe, Senator Judge Alan, that the Zabalya and Cabrera complaints were attached as an annex,
yes,
if I'm not mistaken, to the respondent's answer. Would that be
Yes.
correct, Attorney Poe?
And to be fair,
Yes, Your
it
Honor.
was...
Yes. As well as the annexes.
Yes.
Yes, Your Honor.
In fact, the presiding officer noticed that it lacked a page in one of the annexes to the, I think, Zabalya complaint,
So,
which
anyway,
I think pointed out. So that's a fact.
Yeah,
so it's in the
lang-
records, Senator
yeah,
Judge
factual
Alan.
lang po. So, in the absence of authentic supporting record, what factual basis did the prosecution rely on to say that the allegations were sufficient in form and substance?
If I recall correctly, Your Honor, please, there were some attachments to both complaints. And I'm not aware of any rule in the House of Representatives as far as impeachment cases are concerned that limit what may be discussed or investigated by the committee to only what is contained and attached to the impeachment
I'm not
complaints.
questioning if there's an attachment. I'm questioning whether there was... I'm asking question. I'm not even questioning it. I'm asking questions on if there were authentic records. So I'll move on. No? In the complaint against President Bongbong Marcos, the finding was the complaint failed to establish any factual nexus between the president and an impeachable offense. What are presented were policy and disagreements and generalized accusations, not ultimate facts. Yun ang finding ng Committee on Justice. Correct?
Yes, Your Honor,
Okay.
to the best of my
So
recollection.
that's my question. After answering that question, does the prosecution agree that the requirement of alleging ultimate facts applies equally to all impeachment complaints, regardless of it's the president or the vice president, regardless if it's the ombudsman or the COA chairman?
Yes, Your Honor, and as I recall, when the members of the committee examined the complaint filed against the president, the conclusion of the committee was in fact that there were only conclusions of law contained in that complaint, not allegations of ultimate facts.
Yes, yet in that complaint, there were documents attached, authentic records, and the House did not ask na masupina yung AMLA, BIR, and bank records of the President.
The requirement, if Your Honor, please, of ultimate facts is really based on what is alleged in the petition or complaint
But
itself.
what was the exact words of counsel? Ang katotohanan ay hindi
confidential.
Hindi confidential. So why in the case of President Marcos is the katotohanan confidential, but in the case of Vice President Sara, it's not confidential?
Wala naman po akong maalalang ruling ng committee in the case of the president na meron silang sinabing confidential.
No,
What I recall is that the conclusion was that the complaint did not allege ultimate facts.
So there was a conclusion even before asking for all of this. But in this case, balikta, there was a conclusion that there's no nexus between the president and an impeachable offense. In this case, walang authentic documents, pero humihingi ng supina kasi yung katotohanan hindi confidential. So, which goes to my, well, first, let me honor who I should honor because it seems that the Lisa Masa complaint, which was endorsed by ACT party list, was here kanina, and I think Antonio Tino, I think Sara Elago was here the last week, and I think Representative Ko was here. So in their case kasi, I can say walang selective justice because they wanted the same standards of president and vice president. So that's my next question. We want fairness for everyone and for the Filipino people, but would it be unfair to require 20 years of documents from AMLA, BIR and bank accounts from Vice President Sara without requiring the same from President Bongbong, considering that all of these scandals is happening during his administration?
If the allegations of the complaint against the President did in fact contain ultimate facts, I would see no reason why the Committee on Justice should not have proceeded with it.
So I'll take that answer. May I ask the same question? Rule 8, ultimate facts including evidence. So the answer of the prosecution was that basta't may evidentiary facts. But ang nakalagay kasi sa Section 1 ng Rule 8, including evidence. What is the position of the defense on this?
The defense follows strictly the rules, Your Honors. While I agree with the distinguished opposing counsel na iba yung ultimate facts and evidentiary facts, no? I don't want to blur that line. Tama naman po yung sinabi ng ating opposing. But yun nga po yung punto namin, no? In the Saballa and Cabrera complaints, wala pong ultimate facts at wala din pong evidence or evidentiary na nakakalakip doon po sa mga complaints, and which is the very issue that we brought up to the Supreme Court, Your Honor.
So if you were representing now the President and the opposing counsel was also asking for 20 years of records of AMLA bank accounts and BIR, would you still have the same position?
Your Honors,
that unless it is relevant and definite. I read in your pleadings, di ba, in your position paper na yun yung... So kasi I'll ask na rin my next question. Why is it definite in your view?
Opo. So on the first question, yes, Your Honor. Even if I were to be representing the President now, I would have the same view, no? Na hindi po pwedeng ganun ka 20 years ang span ng mga documents na hiningi, precisely because the jurisprudence provides that for a valid subpoena to issue, it must be particularly described, plus yung sinasabi po natin na relevance. Now, to the second question as to why it is not particularly described, Your Honors, unang-una, let's start with the bank accounts. No? Yung bank accounts na naka-enumerate sa kanilang request, it is our position na yun po yung natawag kanina na fruit of the poisonous tree. Because as you can see, lahat po ng pinanggalingan na accounts na yan ay yung AMLAC, but which we are contesting. No? Sa amin po, unlawful po yung naging disclosure sa Committee on Justice. But more importantly, pangalawa, aside from just the mere bank accounts, the documents they're asking, Your Honors, while they are specified, kung titingnan mo talaga ng mabuti kung anong hinihingi nila, they're asking for all bank records, without any assertion as to why all of these are relevant to prove whatever allegation they have stated in the Articles of Impeachment.
I'll skip many questions here and go to that question. But to be fair, Congressman Dioknos, you said that's an exclusive authority, right, power of the House. So if I want to question the difference, I'll do that in either the Senate or as a private citizen. So I won't go into that. But I ask that now in context of whether or not the certain parameters in the subpoena you're asking for is valid or not. So let me just go to this series of questions. This is really a discussion into what is substantial facts, what's ultimate facts, what's essential facts, what are... and as you said, Attorney Powa, we don't want to bore everyone with that, but it's important in terms of due process. So basically, diba, the ultimate facts are that establish the charge, in this case, unexplained wealth. So let me put it this way in my question to Attorney and Congressman Prosecutor Joke. No. So like if I say that may kilala akong politiko, commissioner ng ganito, or congressman, senator, whatever, ang SALN niya was 1 peso, or what's a reasonable amount? SALN niya was 1 million, 20 years later, it's 20 million, versus the commissioner of BIR in 5 years, it gained 50 million compared to this congressman nito. Then I said, eto lang income niya, unexplained wealth yan. In your view, is that sufficient na for the impeachment court and to issue the subpoenas? Or do you have to specify na for example, you say that that commissioner, sa SALN niya, he only had 2 cars, but he actually has more than 4. Therefore, penging supina para sa LTO. O that commissioner, ang sabi niya, isa lang ang bahay niya. Pero supina sa LRA kasi 4 ang nakita namin. Diba? Kasi on the later examples, medyo mas malinaw yung ultimate facts. Pero yung pag sinabi mo lang, eto SALN, eto tumaas, which was my point actually in my last few vlogs, that just because tumaas yung SALN, that doesn't mean that there's ill-gotten wealth. But my question there was, does that give us now the authority to get the bank accounts, the AMLA and the BIR? Because whatever we do in the impeachment court is for impeachable officers. But nanonood din yung Sandigan Bayan, nanonood din yung RTC, MTC, nanonood din yung Supreme Court. So whatever rule we have here, that will influence then how we deal with barangay captains all the way to anyone who's not impeachable, no?
For unexplained wealth, Your Honor, I believe the ultimate facts must include the following. First, that the person involved amassed wealth. Second, that that wealth is manifestly disproportionate to that person's lawful income. So kailangan po natin makita kung ano yung kanyang kayamanan at kailangan natin ikumpara doon sa lehitimo niyang kinita. And that can be only determined by looking at the records that we are requesting from this honorable court.
No, but if you're just looking at the SALN at yung kinita niya, so I'll give you a example. No? I won't name the person para walang mag-react. But he was senator, I think in 1987, an outstanding human being. And he was telling us, etong lupa na to, nabili ko ng 1980 o 1970 na 50,000. Oh. Nabenta ko ng 1990. Kaya lang sa SALN, ang nakalagay kasi doon, yung acquired cost. So, nilagay ko 50,000. So, kung titignan mo kami, then he named some other great senators, etc., nakasabayan niya, congressman at dito. Titignan mo, si senator ganito, kami, lahat. O, ang SALN namin, baka 5 million. Pero yung 100,000 na lupa na binili namin noon, baka 5 million, 20 million, 30 million. So, if one of those officials suddenly sold the property and then placed the money that came in. So let's say the 100,000 property was sold for 5 million, but then, for example, pinang-blow out niya sa pamilya yung 500,000 before December 31 of that year, mag-i-increase yung kanyang SALN by 4.5 million. So if you just compare his income na sweldo niya with that will not show you that he has ill-gotten wealth. So compared na pagka inallege ko na ang sweldo niya 200,000, eto, pero bakit may bahay siya sa ganito, nawala sa SALN niya. Diba? So I agree na sundan natin yung ebidensya. If the SALN is much more than what you're making, that could spark your curiosity, your suspicion, and continue to investigate. But do you make the conclusion now and file the impeachment case that since malayo yung SALN sa income, therefore ill-gotten yon, without giving that person a way to explain before you subpoena every single document about their lives?
That's precisely why, Your Honor, they call it unexplained wealth. Doon po natin malalaman yan sa mga dokumento.
No, I agree.
Ngayon, kung
they call it
naipaliwanag...
Go ahead, sorry.
I'm sorry, Your Honor.
I'm sorry. I'm the one. Please continue.
Kung halimbawa sa binigay niyong example ay nag-appreciate yung value of the land, then I would not call that unexplained. I would call that explained wealth.
Yes, but you're introducing a new concept now, unexplained wealth versus ill-gotten wealth. I agree with you. Unexplained wealth is that if you look at the SALN at hindi tumutugma, may may unexplained wealth. That's why you ask them to explain it. And then pag hindi maganda yung explanation and may ebidensya ka, then you can go against that person for ill-gotten wealth. Diba? But like in certain parts here, I saw some that I would consider even without asking you evidence. But for example, yung mga kumpanya. Sabi dito, lugi yung kumpanya. So kung lugi yung kumpanya, hindi makaka-contribute yun sa kanyang ill-gotten wealth kung meron man. So why are we getting all the documents about those companies? Doon pumapasok yung criticism ng iba, is this a fishing expedition? Kasi if I had 5 companies, and they were all making money, and supposedly I only own 1% of that company but I'm getting half of that income, I would agree with you, isupina lahat yan. Tignan natin yung flow niyan, baka yan yung pumasok sa akin. Pero lugi nga yung mga kumpanya eh. As an example, as an example. So that's my point. Is it enough in the view of the prosecution panel just to allege, malaki yung SALN mo, bigger than your monthly sweldo? Both of us agree, it's unexplained. But is it ill-gotten? Or do you need more allegations to show that it was ill-gotten?
Well, Your Honor, please, the decision whether wealth is unexplained or, as you said, ill-gotten is really a decision that this Honorable Court will make based on the evidence. Ang gusto lang po namin ay mailatag ang ebidensya sa inyong harap para kayo na mismo ang magsabi. At para malaman po yan, we have to look at the statements of assets, liabilities, and net worth. We have to look at the lawful income reported in the ITRs. We have to look at the bank records in terms of kung ano yung pumasok at lumabas sa kanilang mga accounts. I'm sorry, Your Honor.
Go ahead. It's mine.
As far as the businesses are concerned, that has to do with the third subcharge under unexplained wealth. Yung pong continuing to participate in business interests despite the clear and express prohibition provided in the Constitution. We want to know whether those businesses, yung ba ay mga operational ba ito? Ito ba ay talagang sabihin natin na nandun yung sinasabi nga na inaamin ni Vice President sa kanyang SALN na business interest nga niya yon.
Yeah, I'm skipping because this is mostly questions on fishing expedition. I'll go to the defense after this, but can you tell us the difference between evidence and proof? In your layman's term or legal terms, or if you want to look it up, but in how do we explain to people the difference between evidence and proof?
Napakabigat po ng inyong tanong.
In our words lang.
I will
para
try
lang
my
maintindihan.
best, Your Honor, to answer it. In a court proceeding, whether we're speaking of an impeachment court or a regular court, the judges look at the evidence. They may never be able to know the entire truth kasi ang pangyayari ay nangyari dati pa po. Essentially, a trial is really a reconstruction of something that happened before. So it may happen in some cases that there is enough evidence to make conclusions as far as a judgment is concerned, even if the members of the court did not get to see the entire truth.
Yes.
Ang gusto po namin maiwasan dito sa impeachment court ay meron po tayong hindi mailatag na ebidensya sa mga mahistrado po na nandito para talagang maging buo yung larawan nila bago po kayo magpapasya.
Yeah. I don't think there's any question that all of us here want na mailatag yung ebidensya. The question is, do you have the evidence or are you fishing for the evidence? And that's a question not only for you, but for every single impeachment process, not only the umabot dito, because myself, Senator Subiri, Senator Chis Escudero, then later on Senator Villanueva, has been in the House many times during impeachments of presidents and chief justices. No? But the reason I ask between evidence and proof is because if you have the evidence, you want the opportunity, diba, to bring it here, show the relevancy, connect it to the crime, we admit it so that if it's true, then we can convict. The opposite sides na will either question, hindi admissible yan, or admissible pero walang relationship yan, etc. No? So what I'm saying is that if you're going to prove your case with no evidence, except that if you get all of that, then magiging arbitrary yung House of Representatives, sinong gusto nilang i-impeach. Because almost any public official who's been there for a long time, you will see discrepancies in their SALN because unang-una iba yung acquisition cost at iba yung current value at iba din yung deadline ng December 31, no? Which after this I'll ask the defense to answer, then I'll go into the AMLA, which is different from bank accounts, no? So if you're coming to the court with evidence already But kinukuha mo yung subpoena na yan, di ba, to further prove your point. I don't think there'll be a question there. As Attorney Powa said kanina na kung yung BIR box na yan, alam natin yung laman, and dapat gamitin dito, inallege nyo na. Pero kung hindi alam yung laman, are we fishing there if there's a tax evasion or wala? I don't know the answer. I'm asking you the question. You can answer it in any way you're comfortable in answering.
If I may briefly narrate the procedure that the House might had to undergo for the articles to reach this honorable court. When the complaints were filed before the House of Representatives, the Committee on Justice was tasked not with conducting a trial, not with ferreting out all the evidence, but simply determining whether there was probable cause to proceed with the case. So hindi po namin hinanap yung kabuuan ng ebidensya dahil hindi po namin tungkulin yon.
Yes.
When we made the determination that there was sufficient probable cause to proceed with that case, then that is what we submitted in terms of the articles of impeachment that reached this honorable court. Ngayon, syempre po, just like a preliminary investigation conducted by a prosecutor, ang hawak lang po niyang ebidensya, ang titingnan lang po niya ay kung merong probable cause. Not all the evidence yet is before that prosecutor because wala pa pong trial. Yeah. The presentation of evidence, even the subpoena or compulsion to present evidence will only happen when the trial takes place. And yung tinutukoy po ninyong fishing expedition, yun ay maaring sabihin natin nangyari kung only if the party requesting the evidence or documents ay nagbabaka sakali lang. Baka may makuha tayo dito. In our case, I have to disagree that there was any sort of fishing expedition because based on what the Committee on Justice and later the plenary of the House found was sufficient, there was enough cause to proceed with the case.
I'll go to probable cause, but yung sinabi mo, baka sakaling may makukuha dito. You said hindi ganon. So anong makukuha natin if we grant all the subpoenas you're requesting?
The evidentiary facts, Your Honor, that were not yet, hindi pa nakita ng House nung ang ginagawa lang po namin ay determinahin ang probable cause.
So nagbabaka sakali din?
Hindi po.
No, kasi you said...
Because there is basis for requesting for the bank records.
So what will you see? You still don't know what you'll see?
We are basing the request for the bank records on the evidence and information provided by the Anti-Money Laundering Council, which appears to show that there were billions of pesos that went through the accounts of the Vice President during that period of time.
Let's go to that with the permission of the defense, then I think you're listing down naman. So the Anti-Money Laundering Council, no, does not deal with income. They deal with flow, right? So pag sinabing billion, that doesn't mean that a certain official has billions in their account. So meaning if I have ₱1 million deposit on January 1, and then on January 5, I take it out and put it in time deposit for 1 month, and 1 month later it comes out with 2% time deposit, hindi na 1 million yon. 1 million in, 1 million out, 2 million, 1 million in the time deposit, 3 million. Paglabas na may 2%, 1 million 2 pesos, 1 million 2,000 pesos, 4 million na yon. So hindi evidentiary yun, speculation sa ikot ng pera. Meaning, all I have to do is find someone with a bank account and give them a long enough period, and I will say that they have hundreds of millions or billions.
Precisely, Your Honor, that is why we want the bank records to be produced. Because, as you mentioned, the only reports submitted by the Anti-Money Laundering Council pertain to covered and suspicious transaction reports. They do not show us the exact balances that were contained in those bank accounts. And it is only the bank records that will provide that information.
Agree. And it's suspicion. When you say suspicion, that doesn't mean necessarily suspicion that it's attached to a AMLA crime, but it could be suspicious meaning 6 months walang gumagalaw, biglang everyday ngayon gumalaw. Di ba? Yun yung definition ng part ng definition ng AMLA. But if you cannot connect AMLA and the bank accounts, that's precisely what the defense and other people are saying. Aren't you nga fishing between the three? Fishing means hindi mo pa hawak, so you're trying to get a fish, in this case, a very big fish. Diba? So, pag sinabing hindi fishing expedition, meron ka ng ebidensya. But you want to prove that in court, and you need that to prove it, but you know what to prove already.
If we bring Your Honor's logic to its conclusion, that would mean that the Committee on Justice would have to conduct a full-blown trial, get all the evidence at that level, so that we do not have to fish anymore when we get to this court. When that is not the contemplation of the procedure for impeachment under the Constitution.
I won't argue what the what the House.
With the permission of the gentleman who have the floor, Senator Cayetano.
Last two questions.
Thank you very much.
So, Senator Escudero, myself, we were in the Estrada and Arroyo impeachment. And it's harder to impeach a president than a vice president. Diba? But whether it was accounts, anong laman, property, kotse, we did our homework. So it's not my place to tell you, you did or not. Kaya nga tinatanong ko, may ebidensya ba o wala? Or is it a fishing expedition or not? But as I said a while ago, I won't argue. So I have one last question after that, but I'll go first to the defense. In the context of what I asked, no? Between those two examples, eto SALN mo, eto income mo, malaki SALN mo, we can agree it's unexplained. Kasi nga, you need to explain it further. But is it automatically ill-gotten wealth?
No, Your Honor.
So if it's not automatically ill-gotten wealth, in your view, I mean, I read this from your, maybe you can just restate, why is it a fishing expedition?
Opo. Your Honor, because precisely, yun pong sinasabi nila na unexplained wealth. They were basing it for 20 years, for one, no? Pangalawa, they couldn't pinpoint exactly bakit mo nasabing may unexplained. Alin dito sa properties yun unexplained, no? Third, and if I may elaborate from our memo, if you look at the Articles of Impeachment, it presupposes that the Vice President earned 30 million over a span of 20 years. Yes, they did not think about the Vice President not being in public office from 2013 to 2016. They didn't think about the income that could have, been generated by being married to a lawyer who had his own law office. So to us, it was basically a conjecture, speculation, conclusion of law and fact to say, biglang, uy, may unexplained wealth po dito. No? That's basically our point. And then secondly, the decision earlier, it was mentioned by distinguished opposing counsel, decision rests upon this court to determine kung meron ng unexplained wealth. I disagree with that. The ultimate decision rests upon this court, that is true. But the initial decision rests with the person accusing, hindi ba? Pero nung nag-accuse yung tao sa Sabalian Cabrera complaints, wala man lang nakasulat po doon. Kanina na-mention po yung should the Committee on Justice now conduct a full-blown trial? No, it shouldn't. It should just evaluate the complaint. Para nga pong piskal, parang preliminary investigation. Pag tayo po pumunta sa piskal at ang dala lang natin doon ay puro paratang, wala man lang supporting document, what will the fiscal do? Dismiss the case outright. Yan naman po ang totoo. No? So that was our point to begin with, and that is why we're saying fishing expedition ito. Kasi hindi mo man lang ma-pinpoint kung anong transaction yung sinasabi mong nag-amass ang Vice President natin. Anong taon na nag-amass yung Vice President natin ng ill-gotten wealth or unexplained wealth. At dahil doon, ngayon, we're asking for records spanning 20 years, both, BIR records, bank records, AMLAC records, which they already have, actually, from the Committee on Justice. Pero, hindi natin ma-pinpoint, alin ba talaga dito? We cannot specify kung ano yung act, ano yung omission na ginawa niya na nakapag-amass siya ng unexplained wealth.
Talking about both parties talking about the fiscal or prosecutor, actually binago na rin ngayon. Probable cause with reasonable certainty mako-convict. So meaning, you go to the fiscal's office that you point out ano yung crime, sino yung gumawa ng crime, and yung preliminary evidence mo might not be enough to convict at that time, but enough to say na Hindi lang to Marites. So if I go to the fiscal's office or ombudsman saying this senator has 150 million in SALN, 10 years ago it was 50 million, therefore it's ill-gotten wealth, and then wala pa akong ibang dala except yung magkano sweldo dito, I doubt the fiscal will file that case. But if I tell the fiscal that he has 2 cars in his SALN, but I see him using 4, then give him the opportunity. But I can subpoena the LTO. Na kanino ba yung plate number na yan? Baka namang nasa kapatid talaga niya, no? But the last set of questions, I'll just ask it once, no? So I think everyone understands naman the subpoena regarding the Vice President. The issue was really the dates and how specific or hindi. Actually 2 questions. The corporations, do you not have to pierce the corporate veil, considering there's no allegations in the articles that these companies were used to amass ill-gotten wealth? In fact, I haven't read everything, but so far sa binasa ko, is hindi kumikita tong mga kumpanya na to. Because there's a Supreme Court decision that if it's a joint account, may rights din yung isa. And I don't even know if we informed all of those companies that we might subpoena their records. So did we give them that opportunity? Isama ko na yung last question, Mr. Presiding Officer, and I won't follow it up, no? But yeah, the question was, because a law student asked me, Sir, bakit dinala yung box dito sa Senate? Ba't na lang hindi nila binuksan sa House? So sinagot ko sa kanila, ano ba turo ng professor nyo? Sir, hindi naman nakalagay impeachment trial in cases of impeachment. So the House was actually empowered to open the box there. So I just wanna know the position of both parties kasi nahihiwagaan ako sa box na yon. Si Neil dinala dito, ibabalik sa inyo, then magsusupina tayo. But dun sa graduate na yung nagtanong sa akin doon, they discussed it daw in class, and their professor and their class, ang consensus is that the House could have opened it because the wording in the is it the BIR case or the bank accounts? No, bank accounts ata, yung in cases of impeachment yung nakalagay dun sa sa
Bank
batas.
accounts. Secrecy of bank deposits.
Yes. So ang question niya, let me rephrase, is that did you do that there? Kasi if you did that there, hawak nyo na ngayon. Hindi na namin problema sana, no? So those 2 questions lang regarding do you think nag-comply yung requirements dun sa companies, and should we give notice to the companies? And secondly, about bank account, could you have opened it already in the House? Yung BIR din ba?
Counsel for the panel of prosecutors may respond. Thereafter, counsel for respondents.
Thank you,
Your Honor.
And we would like to thank
Counsel, thank you very
Senator
much.
Judge
Thank you,
Allen for his
Senator
interjections.
If Your Honor, please, the doctrine of piercing the corporate veil applies when we are determining liability of the company or corporation involved. In this particular case, that doctrine has no application at all. We are asking for those records to be produced so that we can determine the extent of participation of the Vice President, as she herself had admitted those business interests in her SALNs. Kaya po namin hinihingi po yon. Kaya sa tingin po namin ay wala pong aplikasyon ang piercing the corporate veil. Second, as far as opening the box is concerned, while it is true that under Republic Act 1405, there's no qualification that impeachment trial lang po ang pwede. As I understand it, it was the better judgment of the committee out of sheer discretion and prudence not to, because at that time we were already being bombarded with petitions left and right seeking to restrain our proceedings. And we felt that it would be more prudent to bring the matter to this honorable court. Thank you.
Your Honor.
Counsel for the respondent.
On the first point, Your Honors, on piercing of the corporate veil, para sa amin, pwede lang naman under jurisprudence mag-pierce ng corporate veil Ibig sabihin, kasi separate and distinct personality mga korporasyon, you can pierce that veil if there's an allegation of fraud. And in this case, wala naman pong allegation ng fraud. Pangalawa, kung totoo po na talagang hinahanap lang po ng kinakagalang-galang na prosecution ay tungkol dun sa divestment issue, then they will not need the tax records, the bank records, or even the AMLAC records of these companies because all they need would be the GIS. The General Information Sheet would show you exactly the extent of the interest of the stockholders, hindi po ba? Pangalawa, pagdating naman po dun sa what's our position, pagdating sa bank secrecy and the exception on cases of impeachment. Sa aming pananaw, at the committee level, meaning Committee on Justice, ay hindi pa po applicable yung exception na ito. And we are holding on to the ruling of Marquez versus Ombudsman or Desierto, I believe, no? Wherein it was said na pagdating sa preliminary investigation, hindi pa po applicable yung mga exceptions under the Bank Secrecy Act and there has to be a pending case before such bank documents are in fact subpoenaed. That is our position, Your Honors.
Thank you, counsels for the parties. Chair will now make a ruling, but prior to that ruling, Chair would like to inquire very, very briefly from the counsels. First, for the counsel for respondent, may the court know when the respondent was married to her spouse and what is the property regime governing their marriage?
Your Honor, I believe they were married, but let me just check the facts just to be sure, but I think it was 2007. 2007, Your Honor. Can I get back to you on the specific date for that?
The date would not be necessary because 2007 would mean they would be covered under the family code. So may the
Yes, Your Honor.
chair ask, what is the property regime governing their marriage?
As far as I know, there are no property regime arrangements or prenup. That's why, Your Honor, I would assume it would be the default property regime, which would be
The absolute community of property. Thank you, counsel. Chair will now make its ruling. The impeachment court will now resolve the prosecution's renewed request for the issuance of subpoena ducis tecum dated July 6, 2026. You may seat, counsels. Directed to the concerned banking institutions and Anti-Money Laundering Council. The court begins with the standards governing the issuance of subpoena ducis tecum. These are set forth in Section 3, Rule 21 of the Rules of Court, which provides, among others, that in the case of a subpoena ducis tecum, it shall contain a reasonable description of the books, documents, or things demanded, which must appear to the court as prima facie relevant. Settled jurisprudence has affirmed and clarified these requirements in the 2021 case of Republic versus Sandigan Bayan, dated 2/15/21, where the Supreme Court stated, quote, a subpoena ducis tecum may be issued if the tests of relevancy and definiteness are satisfied. The court must ensure that, number one, the books, documents, or other things requested must appear prima facie relevant to the issue, subject of the controversy, the test of relevancy. And number two, such books must be reasonably described by the parties to be readily identified, the test of definiteness. In the case of BSB Group, Inc. versus Go, GR number 168644, the court stated that evidence is relevant when it bears such a direct relation to the fact in issue as to induce a belief in its existence or non-existence, and when it relates to a collateral fact from which the existence or non-existence of the principal fact may logically be inferred. These requirements are intended to ensure that the subpoena is not used, as mentioned earlier and discussed earlier, as a tool for a fishing expedition as held in Apostol versus Lubingan Rafael, GR number 260640, dated October 1, 2025. We are also aware of the ruling of the Supreme Court in HC Libenau versus Philippine National Oil Company, GR number L13463, quote, a general inquisitorial examination of all the books, papers, and documents of an adversary conducted with a view to ascertain whether something of value may or may not show up will not be enforced. However, after a careful examination of the records requested, the court finds that the requested documents meet the requirements set forth above. They are reasonably described, readily identifiable, prima facie relevant, and material to the allegations under Article 2. This is not the first time that bank records have been examined by an impeachment trial. During the impeachment trial of former Chief Justice Corona, the Senate, sitting as an impeachment court, granted the prosecution's request for the production of bank records. In granting that request, the court cited Section 2 of Republic Act Number 1405, which expressly recognizes cases of impeachment as an exception to the confidentiality of bank deposits and the rights to privacy of depositors. As to the requested period from 2007 to 2021, the defense's objection is overruled. The respondents' invocation of what they refer to as offenses in term, quote unquote, in their memorandum, doctrine in Duterte versus HOR, does not avail. First, the documents requested under the subpoena ducis tecum will not be used to allege additional independent impeachable offenses. The court will not allow this in adherence to the doctrine laid down in Duterte v. HOR, as this will violate the respondent's right to be informed of the nature and cause of the accusations against her and her rights to due process at every stage of the proceedings. Rather, the court will only allow these records to be used to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. Establishing such a factual baseline is recognized in settled jurisprudence involving allegations that a public officer's wealth is manifestly disproportionate to the lawful income and financial capacity of the officer and the officer's spouse. As held by the Supreme Court in Concerned Taxpayer versus Doblada Jr., dated 8 June 2005, quote, in determining whether the properties acquired were manifestly out of proportion to the lawful income of the spouses, necessarily requires comparing their value with the spouse's salaries, benefits, other lawful income, and revenues from legitimately acquired properties or businesses. Further, in the case of Ombudsman V. Bernardo, GR number 18-1598, quote, respondent's beginning net worth must be considered for purposes of determining whether his disposable income was more than sufficient to justify his property acquisitions and foreign travels for the covered period, and whether he possesses the financial capability to acquire or purchase properties as reported in his SALN. Quote, such net worth of the respondent as declared in the statement filed by him or her from the first day of his employment with the government shall be considered as his true net worth as of such date for purposes of determining his capacity for future property acquisitions during his tenure as a public officer. Any unexplained increase in his net worth thereafter may fall within the ambit of the presumption provided for in Republic Act Number 1379. The production, therefore, of the records from 2007 to 2021 is authorized strictly for that limited purpose only. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term in relation only to Article 2 of the Articles of Impeachment. Now, with regard to the bank records held separately by Attorney Manasseh Carpio and jointly by him and the respondent, the defense's objection is likewise overruled. The respondent's reliance on Republic v. Eugenio is unavailing. That case involved only an ordinary civil inquiry into spousal assets that were not statutorily aggregated. On the other hand, Section 8 of Republic Act Number 6713 requires public officials to disclose their assets, including that of their spouses. Their financial interests are therefore statutorily intertwined for purposes of disclosure. Respondent likewise insists on the separate legal personality and distinct right to privacy of Attorney Carpio, but this is likewise untenable. Article 75 of the Family Code explicitly provides, which is why the presiding officer earlier asked the property regime governing them, in the absence of a marriage settlement or when the regime agreed upon is void, the system of absolute community of properties established in this code shall govern. Under this regime, Article 91 dictates that community property shall consist of all the property owned by the spouses at the time of the celebration of marriage or acquired thereafter. Furthermore, the Family Code imposes a strict statutory presumption under Article 93, which mandates that property acquired during the marriage is presumed to belong to the community unless it is proved that it is one of those excluded therefrom. The law is clear on the matter. The legal necessity of examining the financial records of Attorney Carpio is firmly cemented by the default property regime of absolute community of property governing his marriage to the respondent. Absent any proof of a different property regime governing their marriage, any funds deposited in the bank accounts of Attorney Carpio are legally presumed to form a single, indivisible mass of community property jointly owned with the respondent vice president. Because Philippine civil law legally merges their assets, properties, and income into a single absolute community, it is a legal and mathematical impossibility to determine the respondent's true net worth or lawful income without examining the bank accounts of her husband. Investigating Mr. Carpio's financial records is therefore not an unwarranted intrusion into a third party's privacy, but an absolute legal prerequisite in determining the actual aggregated wealth of the respondent. The defense likewise invokes the Data Privacy Act, classifying the records as sensitive personal information, requiring strict scrutiny, quote-unquote, citing Zoleta versus Ombudsman. The court, however, in Zoleta did not really use the phrase strict scrutiny, but said strict adherence to the Data Privacy Act. Accordingly, Section 16B of the Data Privacy Act expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of the DPA, Data Privacy Act Implementing Rules, expressly permits the processing of sensitive information, personal information, when provided to government or public authority pursuant to a constitutional or statutory mandate, and when necessary for the protection of lawful rights, interests in court proceedings. Now, as to the 21 listed corporate entities and partnership, the requests are granted with respect only to 19 corporate entities and partnership. The respondent's connection to these entities is prima facie shown by the general information sheets in the Articles of Partnership, which have been pre-marked in evidence, and by her admitted SALNs from 2022 to 2025. The request, therefore, is not considered as a fishing expedition, and subpoenas may issue for their peso-denominated accounts strictly only in relation to Article 2. However, the request directed to banking institutions concerning JTC Group of Companies and Pikimong Philippines Corporation are denied. Their general information sheets do not identify the respondent or her spouse as shareholders, and the prosecution at this time failed to show either a direct business interest or a clear and convincing basis to disregard their separate juridical personalities. As held in Pantranco Employees Association VNLRC, GR 170689, and Lanuza versus BF Corporation, GR number 174938, the corporate veil may not be pierced on mere suspicion or speculation. Misuse of the corporation as an alter ego, conduit, or instrument of fraud must be clearly established. Absent such proof, these entities cannot be subjected to the compulsory process intended for another. As to the request for subpoena against the partnership of Carpio lawyers, the same is granted with the following reservation: in adherence to Subido versus Pagante Certeza Mendoza and Binay Law Offices versus Court of Appeals, GR number 216914. The chair notes the practical reality that an examination of a law firm's bank accounts may incidentally disclose sensitive information relating to its clients and legal engagements. The court acknowledges that the partnership and/or the clients of Carpio lawyers may seek appropriate remedies and to challenge compliance with applicable legal requirements, particularly in light of the potential legal implications, including concerns relating to attorney-client privilege, which may also be raised during the trial proper. Furthermore, the court must draw a legal firm line regarding foreign currency deposits. Foreign currency deposits are governed by Republic Act number 6426, particularly Section 8, which recognizes only one exception to confidentiality: the written permission of the depositor. This is also guided by the President, arising from the 2012 Corona impeachment trial. On February 19, 2012, the Supreme Court issued a temporary restraining order in PS Bank versus Senate Impeachment Court, GR number 20238, enjoining the Senate from opening the Chief Justice's Corona dollar accounts in the absence of a written waiver of the depositor. Accordingly, insofar as the request covers foreign currency deposits of the respondent, her spouse, separately or jointly, as well as the corporation and partnership, it is denied. Such accounts shall be excluded unless and until a written consent of the respective depositors is produced. The court now turns to the records held by the AMLC, or Anti-Money Laundering Council. As to the request directed to the Anti-Money Laundering Council, the same are granted with respect to the 19 to the respondent, her spouse, and the 19 entities and one partnership for which a prima facie connection has been shown through the pre-marked general information sheets, articles of partnership, and the respondent's admitted SALNs. However, the requests as to JTC Group of Companies and Pikimong Philippines Corporation are denied for failure at this stage to establish a prima facie link, the respondent or her spouse and said entities, or any sufficient basis to disregard their separate juridical personalities as previously stated. The defense vigorously argues that AMLC is absolutely shielded from this court's compulsory process by the confidentiality provisions of Section 80 of the Anti-Money Laundering Act, as amended, and warrants that compliance would expose AMLC officers to criminal sanctions for breach of confidentiality. The court, however, finds this argument unavailing. Section 8A regulates unauthorized and arbitrary disclosures by AMLAC personnel. It does not and constitutionally cannot nullify the lawful subpoena powers of the Senate sitting as an impeachment court, where compliance with the lawful constitutional subpoena is a justifying circumstances that, if at all, would extinguish any penal liability under Article 11, Paragraph 6 of the Revised Penal Code for any person acting in obedience to an order issued by a superior or some lawful purpose. In the landmark case of Republic versus Sandigan Bayan, GR 2322724, the Supreme Court explicitly rejected the AMLC's attempt to quash a subpoena ducis tecum, ruling verbatim, quote, "The Anti-Money Laundering Council is not merely a repository of reports and information on covered and suspicious transactions. It was created precisely to investigate and institute charges against those suspected to commit money laundering activities. The criminal prosecution of such activities would be unduly hampered if we were to prohibit it from disclosing such information. For the Anti-Money Laundering Council to refuse disclosing the information required of it would be to go against its very function under the law." Further, as held by the Supreme Court in Sabio versus Gordon, GR number 174340, by parity explained that statutory provisions on confidentiality and exemptions from inquiry cannot be invoked to deny access to information by Congress in aid of legislation. It is therefore the position of this court that if the Sandigan Bayan, pursuant to its subpoena powers, cannot be denied AMLC records, as well as the legislature in aid of legislation, it most certainly cannot be denied to the Senate, sitting as an impeachment court. The defense also vehemently objects to the production of AMLC documents by pointing out to the agency's own printed footnotes, which restrict the reports for intelligence purposes only, quote unquote, and explicitly state they are not to be used as evidence in any formal proceedings. The court, however, overrules this objection. The admissibility and evidentiary weight of documents in an impeachment trial are determined by the Constitution, the rules of court, and the judgment of the impeachment court, not by unilateral disclaimers printed by an executive agency on its letterhead. An administrative footnote or internal intelligence sharing protocol cannot rise to the level of a constitutional or statutory exclusionary rule. While the AMLC's internal protocols are validly designed to prevent premature leaks during ongoing investigations, they cannot legally operate to tie the hands of the impeachment court once the documents are lawfully subpoenaed. Because the requested suspicious transaction reports and covered transaction reports satisfy the threshold of prima facie relevance in tracing the alleged accumulation of unexplained wealth under Article 2, they shall be produced. The defense further invokes the 5-year record retention period under the AMLA regulations. The 5-year period is a minimum mandatory retention requirement imposed on covered institutions. It is not an absolute prohibition against keeping or producing all the records. Accordingly, let AMLC invoke this limitation in its return, which this court shall take into account and inform the parties thereon accordingly, should they be unable to comply with the subpoena. As for the partnership of Carpio lawyers, Section 1 of Republic Act No. 10365, amending Section 3A7 of Republic Act No. 9160, treats as covered persons those, including lawyers, who manage client money or assets, manage bank savings and securities accounts, organize contributions for companies, or create, operate, or manage judicial persons or arrangements. Section 2C of AMLC Regulatory Issuance B number 1, series of 2018, adopted on May 10, 2018, and filed on June 13, 2018, expressly reiterates this activity-based rule. The Court recognizes the statutory exception for lawyers acting as independent legal professionals, where the information concerns their clients or disclosure would compromise client confidences or the attorney-client relationship. Absent any showing, however, that the particular record sought contained such information or would compromise a protected confidence, the exception cannot be invoked merely because the entity concerned is a law partnership. It protects client confidences. It does not confer a blanket immunity upon every financial record bearing the law firm's name. The request for the issuance of subpoenas for the identified financial records, therefore, pertaining to Carpi lawyers is granted, subject to the remedies in law and/or their legal right to assert a specific claim of privilege over a particular document at the proper time. No generalized blanket invocation of attorney-client privilege should exclude compliance at this time. Therefore, to summarize, the Court rules as follows. The request for subpoenas directed to the concerned banking institutions covering the accounts of respondent, Attorney Manasseh Carpio, separately or jointly, the partnership of Carpio lawyers, and the 19 listed corporate entities is granted. The banks are ordered to submit to the Clerk of Court the documents on July 30, 2026 at 9 a.m. with the attendance of parties and counsels. The request, insofar as it seeks the records pertaining to JTC Group of Companies and Pikimong Philippines Corporation, is denied for failing to establish prima facie relevance. The subpoenas granted shall apply only to peso-denominated accounts relevant to Article 2. Foreign currency deposits are excluded absent the written consent of the respective depositors. The subpoena directed to the Anti-Money Laundering Council covering respondent Attorney Manasseh Carpio separately and jointly with the respondent, the partnership of Carpio and lawyers, and the 19 listed corporations and entities is granted. The request, insofar as it seeks records pertaining to JTC Group of Companies and Pikimong Philippines Corporation, is denied for failing to establish prima facie relevance. Finally, the Court is cognizant of the Supreme Court ruling in Almonte v. Vasquez, GR 95367, where it stated that a government privilege against disclosure is recognized with respect to state secrets, and it is not amiss to state that even matters of national security have been inquired into in appropriate in-camera proceedings by the Court. Therefore, the Court ex abundante ad cautela, or out of an abundance of caution, hereby directs, in order to prevent the unwarranted exposure of sensitive AMLC methodologies and information, to submit the records strictly in camera to the presiding officer through the Clerk of Court first on July 30, 2026 at 9 a.m., who shall review these documents privately before turning them over to the parties as may be warranted. The parties are directed to be represented by counsel on the aforementioned time and date for the proper inspection, comparison, photocopying, and/or marking of these documents as the case may be. So ordered. Moving now on. BR. The impeachment court will now resolve the prosecution's request for the issuance of subpoena dated July 6, 2026, directed to the Commission or Internal Revenue. At the outset, the presiding officer reiterates and adopts by reference the court's citation of applicable rules regarding the issuance of subpoena ducis tecum, which forms an integral part of this order. The foregoing standards are deemed reproduced and shall govern the court's disposition of the present subpoena requests. After examining the records sought, the court finds that the requested documents meet the requirements set forth. They are reasonably described, readily identifiable, and prima facie relevant and material to the allegations under Article 2. However, the court, similarly, requests, insofar as it seeks the records of JTC Group of Companies, Philippines Inc., and Pikimong Philippines Corporation. The prosecution failed to establish a prima facie nexus between these entities to either the respondent or to her spouse. The records sought, therefore, do not at this time satisfy the requirement of prima facie relevance under Rule 21 of the Rules of Civil Procedure. The court also resolves the respondent's objection to the requested period from 2007 to 2021. They anchor their opposition on the Supreme Court's pronouncement in Duterte v. HOR that the basis of any charge must be for impeachable acts or omissions committed in relation to their office and during the current term of the impeachable officer. The argument, as stated earlier, fails because first, the documents requested under the subpoena ducis tecum will not be used to allege additional impeachable offenses. This court will not allow it. For the same reasons discussed in the court's earlier order, consistent with the same jurisprudence which are hereby adopted by reference, the court likewise holds that the requested records are sought to establish respondents' financial baseline and capacity only, not to inquire into or prosecute alleged impeachable acts occurring outside the present Articles of Impeachment. Accordingly, these records are required to establish a factual baseline against which the respondent's assets, financial transactions, and business interests during her present term may be assessed. We are also not without precedent. During the Corona impeachment trial, the SALNs prior to his appointment as Chief Justice in 2010 were presented on the January 18, 2012 hearing of the court. Likewise, evidence and testimony concerning properties and transactions before his appointment as Associate Justice were presented before the court on March 13, 2012. Therefore, the production of records from 2007 to 2021 is therefore allowed and authorized strictly for purposes of establishing a comparative baseline only. They shall not be used as proof of another independent impeachable offense. Their admissibility and evidentiary use shall remain subject to the prosecution establishing their connection to the alleged unexplained wealth during the respondent's present term. The defense's invocation of the Race to the Privacy Act is likewise unavailing. As previously stated, Section 16B of that law expressly states that the right to privacy does not apply when personal information is needed pursuant to a subpoena. Furthermore, Rule 5, Section 22F of its implementing rules expressly permits the processing of sensitive personal information provided to government public authority pursuant to a constitutional or statutory mandate and when necessary for the protection of lawful rights and interests and court proceedings. The court is likewise unconvinced by respondents' argument that the issuance of the subpoena will usurp the authority of the BIR under Section 5 of the NIRC. This court is not determining the tax deficiencies or civil liabilities which remain within the province of the BIR. It is exercising its constitutional mandate to determine public accountability under the Articles of Impeachment. Neither does the pendency of a BIR audit suspend or limit the Senate's exclusive jurisdiction to try impeachment cases. The respondent invokes Section 270 of the National Internal Revenue Code to prevent the production of the requested records. The objection is overruled in part. The Supreme Court expressly ruled in DepEd v. Spouses Olivan, GR 168771, that Section 270, quote, of the NIRC obviously does not address the confidentiality of ITRs. It merely penalizes the unauthorized disclosure of taxpayer information, except as otherwise provided for by law. It does not bar the production of the documents. However, the respondent correctly invokes Section 71 and other provisions of the NIRC which recognizes only 3 instances in which a taxpayer's records may be opened for inspection. Number 1, upon order of the President or authorization of the President. Number 2, upon the request of a foreign tax authority with the approval of the President. Or number 3, upon the taxpayer's waiver. Nevertheless, the existence of these statutory limitations does not at this stage preclude the issuance of the requested subpoena. The issuance of subpoena is merely a preliminary procedural step and does not by itself authorize the disclosure, inspection, or admission of the requested tax records into evidence. In fact, this issuance is the order that shall set, if at all, things in motion. Upon service, the BIR Commissioner may refuse compliance, very much like what they did with the House, or comply by invoking any of the exceptions under the NIRC as previously mentioned, without a satisfactory showing of faithful compliance with any of the enumerated exceptions. This court shall not receive any subpoenaed records from the BIR, similar to what was done when the sealed box ordered by this court to be returned to them. There is also a precedent during the 2012 Corona impeachment trial. The Senate issued the subpoena and thereafter awaited the return of the BIR commissioner. The requested records were produced only after the requisite presidential authorization had been obtained, one of the recognized exceptions under Section 71 of the NIRC. The respondent, however, is not without recourse nor remedy. In the event the requested tax records are lawfully produced pursuant to any of the statutory exceptions, the respondent may at the appropriate stage of the proceedings raise any and all objections concerning their relevance, materiality, authenticity, admissibility, and other evidentiary infirmities. The issuance of subpoena should not be construed as a ruling on the admissibility of the documents ultimately produced. On this basis, the subpoena shall therefore be issued, and we shall await the return of the BIR commissioner, at which time the court shall take such action as may be deemed necessary and appropriate. Accordingly, in view of the foregoing, the request for the issuance of subpoena directed to Commissioner Carlito Martin R. Mendoza of the BIR is hereby granted. The request insofar as it seeks the records pertaining to JTC Group of Companies, Inc. and Pikimong Philippines Corporation is hereby denied for failure to satisfy the requirement of prima facie evidence. The Commissioner is directed to make the appropriate return to this court in accordance with the law on July 30, 2026 at 9 a.m. before the Clerk of Court. The court shall await the return before taking any further action as may be warranted. The parties are likewise directed to be represented by counsel on the aforementioned time and date for inspection, comparison, photocopying, and or marking as the case may be. So ordered. Senator Judge Alan Cayetano is recognized.
Thank
you were
you
seeking
for that
recognition earlier.
exhaustive ruling, Mr. Presiding Officer. I won't ask you to repeat it. Because you explained both in the caucus and here that there are only two motions, there are parts, I'm talking about myself first, but I think some feel the same way. There are some parts that we agree, some parts we disagree. For example, to subpoena the certain records between 2022 to 2026. Then in my case, I agree with the know your client opening balance just for reference so that you have a starting point. So may I suggest that instead of objecting, I don't know if I'm alone or with others, I will not manifest anymore, but may I submit in writing which parts of the ruling I disagree, and if anyone wants to either manifest or submit in writing. But I do have one question to the presiding officer. So you narrated everything. In the page 2 of the request for subpoena for 004, nakalagay, all records filed with, submitted to, or maintained by the BIR for taxable year 2007 to 25, including but not limited to. So sinabi 1, 2, 3, 1 and 2, pero not limited to. The other one, 4, page 4 of the request number 004-2026. Sorry, that's the case number. So the other one is to the, this one's to the anti-money laundering. Nakalagay po sa page 4, and all other relevant documents. So I just like to ask, was your narration exclusive? Because you did say that it's specific enough, but I don't think specific yung all other relevant. The test of if it's definite is that wala nang iisipin yung pinadalan mo ng subpoena. So kung anong nire-rate, yun ang kukunin.
That is a common practice perhaps used by lawyers, but the understanding of the court, and let this be part of the ruling of the court, is that only the documents specifically mentioned
Thank you for
and will not include that catch-all phrase, because I doubt too if the banks, the BIR or AMLC would be able to supply the and such others unless it was specified.
So with the permission of the court, I'll submit my, where I agree and disagree.
Permission granted, and any other senator judge who wish to submit the written explanation in regard to the twin orders may do so. Senator Judge Marcos and Legarda are both raising their hands, so the same applies to them. Submit. Senator Judges Marcos, Legarda, and Villar Camille, are manifesting that they will be submitting their manifestations in regard to the twin rulings of the court, and the same is allowed and will be made part of the records. For the information of the court, yes, Senator Judge Pia Cayetano is recognized. What is your pleasure, ma'am?
Mr. Presiding Officer, I'll just make a short manifestation because
The lady may proceed.
Alan's written submission might be so long, it might just be easier for me to make my own manifestation. Para tumawa naman kayo, guys. Sobrang seryoso natin. But it is a serious topic. Very simply, Mr. President, personally, on the issue of the dates, no, for the submission of the, what was it, 2007? Goes back as 2007 to 2026. And the term of the Vice President in question is 2022 to 2026. My humble position is, and I'm cognizant of the case that was cited by the prosecution. I also found that my own research, the presiding officer used it in the justification of the decision, says that you go back to set that baseline. I understand that. Madali naman siyang intindihan. Ang sa akin lang naman, in the interest also of considering the rights of the person under trial, we could have considered starting at 2022, and if there's more than, kung dun pa lang, it already shows that unexplained from 22 to 2026, there may be no reason to go back and at least respect that part of the record. So yun lang naman ang sa akin. Kasi hindi naman mahirap na tingnan yung 2022 to 2026. O hindi mo makita yung baseline pero may trend, then dun, saka tayo pupunta doon. Diba? That's our way of showing respect also for the persons who are brought here to trial. But anyway, we submit to the ruling. I just wanted to explain that that could have been a middle ground, Mr. Presiding Officer. Thank you.
Noted and well taken, Senator Judge Pia Cayetano. Chair would now like to take up some administrative matters. We are in receipt of a motion to set conference for the transfer of markings and comparison of video exhibits filed by the prosecution. Since this was received only last Friday, the court was not able to act on it on their requested dates. Court therefore sets this to July 21, tomorrow at 9 a.m. Due notice is given to both parties for this purpose. Likewise, the court is in receipt, the presiding officer rather, as well as the Senate President, of a letter of manifestation signed by Senator Judge Marcoleta, citing a rule in the Arab impeachment trial and wanting his vote to be considered. Chair, the presiding officer in this court will not act on it at this time, but instead, since we will be resuming next week, we'll be referring this matter to the Senate as a legislative body, given that it's the Senate that will be amending the rules, to allow participation through a vote. Because apparently, as pointed out by Senator Judge Marcoleta, during the Estrada impeachment trial, a rule was adopted, which we are confirming, that allows the Senate President to provide a mechanism by which a senator who cannot vote under any unavoidable circumstances to cast his vote on any matter. But since this impinges upon the rules of the impeachment court, this matter should properly be taken up by the Senate as a legislative body. And whatever decision the Senate will have as a legislative body, the court shall implement it. But let it be placed on record that personally, once we convene the Senate as a legislative body, I am inclined to agree with the suggestion of Senator Marcoleta, for as long as there is no suspension, according to him. Yes, Senator Judge Cayetano.
I'll not object to that at this point in time. Just as an additional information, I think Senator Estrada elevated to the Supreme Court the denial of the Sandigan Bayan to allow him to attend. But may you also refer my previous manifestation that as a court, we can also communicate whether it's with the Sandigan Bayan or the... But if you're going to say it's going to be through the rules, that's not in conflict. But maybe we can take it up whether in caucus once the Senate convenes.
The point of Senator Judge Allen is well taken. We shall do so at the appropriate time. Now, on other matter, Senator Judge Padilla is recognized. What is your pleasure, sir?
Mahal na tagapamahalang hukom, patungkol po doon sa nangyaring ruling, nais ko lang po sanang magmanifesto.
The gentleman may proceed.
Ginoong tagapangulo at mga kasama, matagal ko na pong isinusulong ang freedom of information dahil ito po ay bumagsak sa aking komite. Ito po ay tunay na kailangan natin sapagkat dito po talaga natin mapapatunayan yung sinasabi nating public trust. Pero meron din po kasing napakahalaga yung tinatawag na equal protection of the laws. Sang-ayon po sa Artikulo 3, Section 1 ng ating Konstitusyon, Bill of Rights, ang nagsasabing hindi dapat alisan ng buhay, kalayaan o ari-arian ng sinumang tao ng hindi kaparaanan ng batas. Ni pagkaitan ang sinumang tao ng pantay na pangangalaga ng batas. Ang mga pamantayang ginagamit natin ngayon ay dapat pareho ring ipinatutupad sa lahat ng impeachable officials, anuman ang kanilang pangalan o posisyon. Hindi ko po makakalimutan ang naging pahayag ng dating Senadora Miriam Santiago dito mismo. Siya po ay isang huwes at ginagalang na propesora ng batas. Ang sabi niya, constitutional analysis is a technical field. Ang pagsusuri sa konstitusyon ay hindi isang sining. Isa itong technical na larangan. Hindi po dapat ito ini-interpret ng basta-basta o kailangan may due process. Nung una ko pong narinig kanina na ipaliwanag po ng ating Senator Judge Alan Peter Cayetano, tinanong sa prosecution kung ganito rin ba ang ginawa nila noong may impeachment kay Presidente Bongbong Marcos. Napakalinaw po na ang sagot nila ay hindi naman sila nagtanong. Hindi sila nagsaliksik kung paanong ginagawa nila ngayon sa pangalawang Pangulo. Ang akin po lamang, makatarungan ba na hindi parehas ang trato natin dito? Dapat sana parehas. Kaya po, ang hinihiling ko sa atin, total naman, lahat naman kayo ay sumang-ayon na sa Freedom of Information Bill ko. Hindi pa nga lang nagsasubmit ang House of Representatives. Bakit kung ganito ang pamantayan natin, edi buksan na natin lahat ng bank records natin. Lahat na. Tayong lahat ay buksan na natin. Lahat. Para mapakita sa taong bayan na wala tayong kinikilingan dito. Ito ay oras na para samantalahin natin ang pagkakataong ito na ipasa yung FOI. Kasi kung ganito, na parang meron tayong tinititigan sa tinitingnan, hindi maganda ito para sa taong bayan. Tandaan po natin, pantay-pantay tayo sa harap ng Diyos at ng batas. At hinihingi ko po sa inyo na ilagay sa record ang aking pagtutol sa ruling na ito. Maraming salamat.
For the record, there is a pending bill as well requiring all public officials filing a SALN to execute a waiver in favor of relevant government agencies together with their SALN on top and in addition of the FOI bill filed by the Honorable Padilla na tinatalakay din po natin sa ngayon. Before proceeding on one more matter, May I inquire from the lead prosecutor or someone from the panel of prosecutors who their intended witnesses will be for tomorrow and Tuesday? Sorry, tomorrow and Wednesday. Forgive me.
Your Honor, our intended witness for tomorrow is Attorney Melvin Matibag, the NBI Director. And for Wednesday, Your Honor, it will be Marivic Pareja of the Legislative Archive Office of the House of Representatives, Your Honor.
And on Wednesday, the bank officials?
In addition, Your Honor, but considering that we only have Tuesday and Wednesday for trial, but after Marivic Pareja, we will also be presenting the two land bank officials, Your Honor.
Yes, because we issued a subpoena ad testificandum against these two bank officials to attend tomorrow and Wednesday.
Yes, Your Honor.
So for the information of the two bank officials, if they are listening, they may simply attend the Wednesday trial, not the trial tomorrow, although the subpoena indicates tomorrow and Wednesday. Would that be okay, counsel, for
Yes,
the
Your Honor.
panel for prosecutors? Lead prosecutor, rather? Yes? So Attorney Melvin Matibag tomorrow, and if at all, Ms. Marivic Pareja and Ms. Marivic Pareja and the two bank officials on Wednesday. Counsel for the respondent, ma'am?
Good afternoon, Your
What is
Honor.
your pleasure, ma'am?
May I be recognized, Your Honor?
Yes, ma'am. This is regarding what matter, ma'am?
Just two administrative matters, Your Honor. The
Please,
first
ma'am.
one with respect to the motion to set conference for the transfer of marking and comparison of video exhibits. We would also like to request that the respondent be allowed to also mark additional documents at the appointed time tomorrow. In effect, we're asking
Also at
the
9
same
o'clock.
latitude. Yes, Your Honor. In fact, some of the documents that we intend to mark tomorrow would be also our copies of some of the listed items in this motion, Your Honor.
Of
And-
course, that motion orally made by counsel for respondent is hereby granted. The respondent, in similar fashion to the prosecutor, may also mark or change the markings or mark any pieces of evidence they wish to do so in order to facilitate the trial. So ordered.
Yes, thank you, Your Honor. And just to place on record the additional marking of evidence and whatever transfer of markings that the prosecution will do tomorrow is without prejudice to Section 3, Administrative Matter Number 2026-001 of this impeachment court with respect to the guidelines for the conduct of the pretrial conference, which explicitly states that the marking is without prejudice to any questions on admissibility, relevance, etc., Your Honor.
That is the understanding, counsel, yes.
And the second
The
matter,
chair
Your
confirms that.
Second matter, Your Honor, with respect to the earlier ruling given by this court on the two requests for subpoena, Your Honor, defense requests for certified true copy of that ruling, Your Honor. Thank you.
Chair will address that. It will be included in the journal. However, the journal will have to await the manifestations to be submitted by any senator judge who may agree or disagree with the ruling. So we might not be able to approve the journal tomorrow, although we will do as best as we can. But as soon as the journal is approved, we shall make it available. But the TSN can be made available perhaps by tomorrow.
Thank you, Your Honor. That's all, Your Honor.
Your Honor, may I make a short manifestation with regards to the order of presentation, Your Honor, earlier mentioned by the prosecution?
Of witnesses?
Yes, Your Honor.
Subject to the limitation mentioned by Senator Judge Allen the other week, if you remember.
Yes, Your
counsel?
Honor, I understand.
The lady may proceed.
We are maintaining the presentation of NBI Director tomorrow, that is Tuesday, July 21. And then following the NBI Director, Your Honor, will be the two land bank managers in the person of Violeta San Constantino of Shaw Branch Manager and Denita Camposano of DepEd Branch Manager. As to the presentation of the Legislative Archive Officer, we will be determining I'm going to present her, Your Honor.
So the court recalls or withdraws the earlier statement that the two bank officials may appear on Wednesday. The subpoena stands, therefore, requiring their appearance to respond to the subpoena ad testificandum tomorrow, July 21 and July 22.
We confirm, Your Honor.
So noted. Any other matters that any of the parties wish to raise? There being none, since we did not have a break, trial is hereby adjourned until July 21, Tuesday at 2 p.m.
panalo ito ng taong bayan. Kanina naman ay isa-isang senador ni House Prosecutor ang mga kalumpa ng ilang senator judges. Recognized yes, Senator Judge hinggil sa allegation ng fishing expedition at yung tinatawag nilang irregularity at relevance ng hindi ng para sa bank at tax records na VP Sara at kanyang asawa. Ay pinchok mo na yun ang kanilang sabihin. Sa ngayon ay mailabas lamang ang mga naturang dokumento upang patunayan ang yaman ng Pangulong Pangulo at hindi pa sa punto na magpapasya kung tatakot pa ito bilang pinag na ebidensya. Dagdag pa ng prosecution, ang SALN at Instant Computer so ITR ng Vice President ay gusto lang snapshot o short video lamang. Hindi yung sa back records na magbibigay na buong larawan ng kanyang kabuuan ni yaman upang papatunayan ang aligasyon ng Unexplained Wealth. Narito ang pahayag ng House Prosecutor Sheldon.
Tulog ako.
Okay na guys? Okay na? Cut? Wait lang. Sige sir, start po tayo.
Good afternoon, everyone. The Senate President Sherwin Gatchalian opened the session at exactly 2 p.m. on July 20, 2026, with 21 senators present, constituting a quorum. For administrative matters, the impeachment court was in receipt of the House Prosecution Panel's motion to set conference for the transfer of markings and comparison of video exhibits last Friday, July 17, 2026 at end of day, requesting the same to be scheduled today, July 20 at 9 a.m. The presiding officer granted the motion only to the extent necessary to allow the proper transfer of markings, comparison, and verification of documentary and video exhibits that had already been identified during pre-trial. He emphasized that the conference is purely administrative and evidentiary preparatory and cannot be used to introduce new evidence, substitute different exhibits, cure evidentiary deficiencies, or prejudice the respondent's right to inspect the evidence and raise objections. The conference was, however, set for July 21, 2026 at 9 a.m. instead of today before the clerk of the impeachment court with both parties' counsel present. The order likewise expressly reminded the prosecution that the court will not countenance trial by ambush and that any material deviation from the pretrial disclosures may result in the exclusion of evidence or the issuance of other protective orders necessary to safeguard fairness and due process. The respondent was also given the same right to transfer markings on July 21, 2026. The presiding officer likewise ensured the prompt implementation of the court's compulsory orders. The Office of the Sergeant-at-Arms formally reported that the subpoenas and subpoena duces tecum issued by the court had been successfully served upon the identified witnesses and custodian of records, including officials of the House of Representatives and Land Bank of the Philippines, with corresponding proof of service submitted to the court. This confirms that the court's directives are being promptly enforced in preparation for the presentation of evidence during the impeachment trial. The presiding officer and the Senate President also confirmed receipt of a letter from Senator Marcoleta, which the presiding officer deferred ruling and merely referred the matter to be taken up the Senate as a legislative body. For preliminaries, Senator Judge Erwin Tulfo objected emphatically about the use of the time of the impeachment court by the senator judges in manifesting their own personal concerns not relating to the merits of the case before the court, which according to him is an injustice to Respondent Duterte. After the manifestations and rebuttals of Senator Judge Alan Cayetano, Senator Judge Robin Padilla, Senator Judge Vicente Soto moved that the matter be referred by the impeachment court to the Senate as a legislative body, seconded by Senator Judge Kiko Pangilinan. The presiding officer ruled that the manifestation of Senator Judge Robin Padilla shall remain on the records but referred to the Senate as a legislative body, and apologize to the parties and councils why these matters are being allowed because there is no other venue or forum to ventilate since the Senate as a legislative body is still in recess. He is hopeful that once the session resumes in a week, all these matters will be ventilated in that forum and not before the impeachment court. Senate President Sherwin Gatchalian reiterated that the matters will be surely discussed before the Senate as a legislative body and thanked his colleagues for both the understanding and their active participation. After the clarification of the Senator Judge Joel Villanueva, the presiding officer confirmed his ruling that the vote will not be per issue but per motion, as the motions are indivisible and should be taken as whole, citing as precedent what happened in the Corona impeachment trial. As to the oral arguments, the House Prosecution Panel was represented by Chel Jokno and the respondent was represented by Attorney Michael Poa. Senator Judge Joel Villanueva asked the House Prosecution Panel whether the request for subpoena already goes into the admissibility of the evidence. He also asked the defense whether such issuance would already prejudice the respondent's rights relating to the inadmissibility or admissibility of the records or documents. Senator Judge Pia Cayetano and Alan Cayetano also asked questions regarding the effect of illegally acquired evidence, about the due process requirements of any compulsory process, about the decision of the Supreme Court in Duterte versus House of Representatives in relation to documents before the respondent's term as an impeachable officer. The presiding officer asked the defense when the respondent and her husband got married, to which Attorney Powa admitted 2007. He further inquired the existence of any prenuptial agreement, to which Attorney Powa also admitted that there was none and that the absolute community property regime applies. As to the resolution of the court, it was surgical, not sweeping. Today, the Senate, sitting as an impeachment court, issued a calibrated, meticulous, and legally unassailable resolution regarding the prosecution's request for subpoenas directed at the BIR, the AMLC, and various banking institutions. The guiding principle of the impeachment court today was simple. The search for truth will be unyielding, but it will not be an unbridled fishing expedition. The court's actions are surgical, not sweeping. Here are the 6 critical takeaways from today's rulings. First, on the spousal accounts, the court granted the subpoena for the peso accounts and tax records of the respondent vice president, her husband, Attorney Manasa Scarpio, and 20 specific corporate entities. To those asking why a private citizen's accounts are included, Philippine civil law is clear. Under the family code, the couple is governed by the absolute community of property. There is only one marital pot. It is a legal and mathematical impossibility to audit the wealth of the vice president without auditing the community property she jointly shares with her husband. Also, Section 8 of Republic Act Number 6713 requires public officials to disclose their assets, including those of their spouses. Their financial interests are therefore intertwined for purposes of disclosure. Second, the exclusion of dollar accounts. The court strictly denied the subpoena for any foreign currency deposits. The court is bound by the rule of law. Republic Act 6426 provides absolute secrecy for dollar accounts unless there is a written waiver from the depositor. The court learned from the Supreme Court's temporary restraining order against the Senate during the 2012 Corona impeachment in the case of PS Bank versus Senate Impeachment Court. The court will not overstep these statutory boundaries again. Third, the 2007 to 2021 timeframe. The court approved the request for historical records dating back to 2007. These are not being admitted to charge the Vice President with new past offenses. They are strictly allowed as a factual baseline based on the cases of Office of the Ombudsman versus Bernardo and Concerned Taxpayer versus Doblada Jr. To determine if wealth accumulated today is disproportionate, there must first be an establishment of what the spouses legitimately owned yesterday. Fourth, on the corporate entities. The court proved its refusal to allow fishing expedition by outright denying the subpoenas for JTC Group of Companies, Philippines, Inc., and Pikimong Philippines Corporation, as the documents submitted to the court neither show the names of the respondent and or her husband in the general information sheets of the two corporations, nor the admitted SALNs by the respondent disclose these two corporations. Absent concrete prima facie proof tying these two corporations to the respondent, the corporate veil of fiction remains. The impeachment court only granted subpoenas for the 20 entities where the respondents' links were prima facie proven by documents submitted to the court and or admitted by parties. As to the Carpio Lawyers Partnership, the court acknowledged that the issuance is subject to whatever legal remedies they may resort to in order to raise any attorney-client privilege over particular documents at the proper time. Fifth, on the BIR records, the court granted the subpoena to the BIR as to the respondent, her husband, and 20 entities, which is composed of 19 corporations and 1 partnership. Based on the case of DepEd versus Spouses Olivan, that states Section 270 of the Tax Code obviously does not address the confidentiality of ITRs. The Tax Code recognized disclosures permitted under its specific provisions, other statutes, or in any other manner provided by law. The constitutional authority of the Senate Impeachment Court under its rules to compel the production of relevant evidence constitutes such lawful process. But the court recognizes that under the tax code, the commissioner may still invoke the requirement of the president's authorization to release these documents. The court has done its constitutional duty. It will now await the official return of the BIR commissioner on July 30, 2026 at 9 a.m., cognizant of the fact that the issuance of the subpoena is not necessarily the final act with respect to the requested documents. Finally, on the Anti-Money Laundering Council, the court granted a subpoena covering the respondent, her husband, and 19 listed corporate entities and 1 partnership, guided by the doctrine in the Supreme Court case of Republic versus Sandigan Bayan that the confidentiality wall under Section 9C of the AMLA protects covered banking institutions from liability when reporting to the AMLC, and does not paralyze it from answering a lawful subpoena issued by the impeachment court. However, to protect state secrets and intelligence methodologies guided by the Supreme Court doctrine in Almonte versus Vasquez, the presiding officer ordered that AMLC records be submitted first in camera for his review first before turning them over to the parties to determine if any AMLC methodologies would unnecessarily be disclosed that is not proportionate to the requirement of the subpoena. The impeachment court remains an impartial tribunal. The court will compel the evidence the law allows, and it will protect the rights the law guarantees. The impeachment court provides the following summary of the presiding officer's resolutions pertaining to the issuance of subpoenas to the BIR, AMLC, and the banks, which you will see in your printed media briefer. I made a table or matrix for easier referencing. As to manifestations and motions, upon Senator Judge Alan Cayetano's motion, the presiding officer granted the filing of written dissents to the presiding officer's ruling and the other senators who will also file their written dissents for the record. Upon the query of the presiding officer, the lead House prosecutor confirmed that they will be presenting Ms. Marivic Pareja and 2 land bank officials, namely Violeta Constantino and Ninita Camposano, on July 21 and 22, 2026. Following rulings by the presiding officer, the trial was adjourned. Pursuant to the rules of procedure on impeachment trials, the impeachment court will resume session tomorrow, Tuesday, July 21, 2026 at 2 p.m. The agenda is a continuation of the presentation of the House Prosecution Panel's evidence-in-chief for Article 4 with NBI Director Attorney Melvin Matibag as witness. Any questions?
Questions? Hello. Attorney, bakit hindi na umabot sa punto na magbotohan ang mga senator judges dun sa ruling sa dalawang motion ng prosecution?
Isa lang sagot ko. Rule 6 of the Senate Impeachment Rules allowed the presiding officer a wide latitude of discretion to be the one to resolve any matter or motion based on evidence. And only, as I explained before, only if the presiding officer decides on his own to throw the question back to the court, to the impeachment court, that voting will happen. Now, another voting can happen if there was a senator judge who will appeal the resolution of the presiding officer, but that did not happen. So there was no voting for today.
Another, last on my part. yung decision na binasa ni Presiding Officer Chis Escudero, was it done today or over the weekend? Kasi kung over the weekend, bakit nagkaroon pa ng pagtatanong yung mga senator judges dun sa defense and prosecution, gayong may written decision na siya, hindi ba waste of time yun?
As I said, during the July 6 first day of impeachment, because this request of the prosecution has been already stated in their pre-trial briefs, the presiding officer, as a matter of course, was already ready to rule on the subpoenas. However, upon manifestation of House Prosecution Panel, Congressman Chel Jokno, that they have filed a renewed request for subpoena, that the resolution of the presiding officer was deferred, and it was only after the request of the defense to be given a copy of such and the senator judges asking that oral arguments be done, that the presiding officer yielded to such oral arguments that have been scheduled last Monday. So basically the main chunk of the decision of the presiding officer has already been prepared even before July 6. So I think the presiding officer also during the caucus consulted his fellow senator judges about it and asked about their views regarding the matter, and that is the request of the other senator judges to study it for until the weekend and until today. So handa naman siya ever since.
Attorney, so yung Anti-Money Laundering Council and yung mga banks are mandated, obligado sila, tama po ba, na mag-comply. Pero as to the BIR, subject to the authorization by the President, tama po ba?
Obligado rin po siya mag-comply. However, she has a recourse in law which is under, he has a recourse in law which is under Section 71. So as I was explaining, this was the same course of action that happened during the Corona impeachment trial. The subpoena was issued to Commissioner Henares at the time, and then Commissioner Henares, she asked the permission of the President at the time to be able to comply without violating the subpoena, and to also not to put her in jeopardy of criminal case. She asked the permission. So as the presiding officer has said, it is cognizant that this is the first step that might trigger such permission to be had. And he also explained it in his resolution that without such permission, no evidence from the BIR will be allowed to be taken by the impeachment court.
Pardon the ignorance po, Attorney. So ibig sabihin, yung BIR Commissioner ang gagawa ng pamamaraan para ma-comply ang subpoena ng impeachment court.
He now has this subpoena to show the President, for the President to now respect a co-equal branch of the government, for him to issue the permission to the BIR Commissioner.
Sir, just on the technical side, can the BIR Commissioner, I'm sure he is watching now, pwede na po ba niyang i-trigger already? Can he already ask the President for permission, or dapat po ba mag-a-appear muna siya sa court at saka pa lang po maisesend yung request sa Malacanang?
The schedule for him to comply rather. Nakakalimutan kong na pala, hindi na si Commissioner Henares. For him to comply with the July 30, he should already secure the permission before July 30 because the deadline for his compliance is July 30.
So, ibig sabihin, anong date po yung mismong issuance ng subpoena ng court if ang compliance is July 30?
Today i-issue yung subpoena, tomorrow siguro masasend.
Question lang po regarding dun sa after the subpoena, does it mean na pwede na siyang buksan or para bang meron pang another deliberation on that?
Wala na po.
So meaning pwede na siyang i-deliberate and use as an
Wala na
evidence?
pong bubuksan kasi wala namang box tayong tinutukoy. Ang hinihingi po ng korte, diretso ay dokumento na isasubmit ng BIR Commissioner sa korte. So whether that's in a box or in a folder or in a clear folder or in a Manila folder, it's his discretion to submit to the court.
For the deadline naman po ng other institutions like banks, aside dun sa BIR, meron ba silang deadline?
Lahat po July 30 at 9 a.m. pati po yung Anti-Money Laundering Council. Kaya lang po bago makita ng both parties yung mga dokumento na galing sa Anti-Money Laundering Council, titignan muna ng presiding officer kasi based on Almonte versus Vasquez, titignan niya kung doon ba sa mga reports ng Anti-Money Laundering Council, meron bang unnecessary disclosure ng methodology ng pag-iimbestiga ng Anti-Money Laundering Council pag ibinigay yung papel na yon, yung reports na yon. So, kailangan lamang iklaro ng presiding officer in camera before the clerk of court, i-confirm niya lang doon sa representative ng Anti-Money Laundering Council kung meron ba o wala. Kung wala namang madidisclose na methodologies, then the parties will have unbridled access to those documents and upon presentation to the impeachment court, makikita rin natin yung mga dokumento na yun.
Attorney, clarify ko lang po. Meaning po ba yung binasa kanina ni Senator Cheese, it was a ruling purely by him as presiding officer, or do we take it na since walang nag-contend from senator judges, nakuha yung support ng ibang senator judges?
The ruling of the presiding officer is the ruling of the impeachment court under Rule 6 of the Senate impeachment rules. So wala pong pinag-uusapan na ruling ng presiding officer, tas ruling ng mayorya, wala pong ganon. Ruling po yon ng impeachment court.
Wala pong bilang nung simple majority na
Wala po.
inaabangan?
Wala po. Because under the rules, he is allowed to do such ruling. Under Rule 6.
Wala rin pong napag-usapan kaya na, kasi supposedly kung may point of contention from senator judges, meron at merong magsasalita. Pero nagkaroon po ba na pag-uusap nun during the caucus o conditions or compromise na lang?
I'm not privy to that. But of course, since no majority senator judge raised any issue on that and no minority senator judge appealed the resolution of the presiding officer as held by previous impeachment courts in the Corona and the Estrada impeachment, the ruling of the chair will stand as unquestioned.
Thank you, Attorney.
Sir, just to paint a picture dito sa subpoena, is there a possibility na, or allowed ba na mag-decline si President Bongbong Marcos? And if so, if he declines, what happens?
Of course, that is within the realm of possibility, but President has already shown, history has already shown that merong basihan naman yung ating presidente para i-issue yun. And as I said, it is not really an act against the Vice President. I think that will be unfair to characterize the President's giving permission to the BIR Commissioner for the disclosure to be seen as an act against the Vice President. It is actually an act of respect to a co-equal branch of government. And since the impeachment court has officially acted on the request for subpoena and the BIR Commissioner has remedies in order for him not to be in trouble with the law under Section 270 and be cited in indirect contempt, then he can get the permission of the President, and the President already has the legal standing or the legal reason to issue such permission.
Attorney, last na lang po from me. Yung sa manifestations po ng senators not related to the impeachment trial proceedings, do we take it na pag sa mga susunod na araw, merong gustong mag-manifest na walang kinalaman sa impeachment, bawal na po ba?
I think the policy is they will hear it first. And then upon hearing the manifestation, the presiding officer or any senator judge can determine if that is relevant or irrelevant for the impeachment court to be taken up. And they have a body of arsenal and weapons to use in order to either expunge that from the records or keep it on the record or refer it to the Senate as a legislative body, which we have seen earlier that there was no expunction of the manifestation made by Senator Judge Robin Padilla. There was just a referral to the Senate as a legislative body.
Thank you po.
Okay na po? Ay.
Ano lang, administrative matters. Administrative matters lang, attorney. Attorney, napag-usapan na ba paano anong oras yung trial simula next week?
Wala pa po. Pero siguro in the next few days, makakaroon tayo ng update regarding that. Kasi malapit na rin naman yung SONA next week na. So I think the presiding officer will give his final resolution on that, yung sa scheduling. By Wednesday siguro ang latest. Thank you po. Thank you.
Vice President Sara Duterte, Impeachment Trial, Special Coverage.
With sufficient clarity doon sa request.
Idagdag ko lang po, no? Ang ginawa ng Kongreso ang ginawa ng Kongreso ay nakita ang probable cause. Ibig sabihin, nasilip ang posibilidad na talagang may basehan ang impeachment sa ating pangalawang Pangulo. Ngayon, heto na tayo sa Senado dahil sila ang impeachment court kung saan susuriin nila ang lahat ng bagay para yung nasilip ay maipapalawak pa. Padakuon pa siya para makita ang tanan-tanan. And in this case, ang naging desisyon ng korte ngayon ay ang pagpayag na magkaroon ng ebidensya, basehan, para kapag sila'y magdesisyon, pwede nilang sabihing relevant ito or may kinalaman ito, or pwede rin nilang sabihing walang kinalaman sa akusasyon base at sang-ayon dun sa nakikita nilang financial documents or BIR records. Sa madaling sabi po, ito ay dagdag dokumento para anuman ang desisyon ng ating senator judges, ito ay gagawin nila na bukas at hindi nakapikit ang kanilang mata. Dagdag na dokumento para makita nila kung meron ba talagang basehan ang reklamo o kung wala naman. Kaya nga ito ay one big successful step dahil ang layunin naman natin ay hindi sabihing guilty o not guilty, kundi mabuksan, ipagpatuloy ang proseso, matuldukan sa pararaan ng tamang pagdesisyon sang-ayon sa mga dokumentong makikita.
Ma'am, just last na lang po. Do you already know po ba in advance or may advance info na po kayo that the court would rule in your favor ngayong araw? Kasi mukhang, handa po na yung ruling o binasa na po kanina right after all the questions po.
Wala kami, of course, any advance information about that. But what we can say is that confident po yung prosecution na ito ay mag-grant in the sense na alam naman namin na may basehan talaga yung mga requests na yon for the bank records, for the AMLAC reports, and also for the BIR tax records. So in terms of confidence, we had it even from the very time that we filed those requests. Confident kami na may mga basehan and therefore walang dahilan para i-deny yung aming mga requests.
Wala pong advance information. Maski sinong judge, gugustuhin niyang makita ang lahat ng kailangan at gusto niyang makita para maging tama ang kanyang desisyon.
All right.
Hello.
Rosalie?
So, good evening po, ma'ams and sirs. Ano pong lawful production ng tax records ni VP Duterte at ng asawa niya po ang ine-expect nyo from the BIR Commissioner?
I'm sorry, can you repeat that? Lawful
Ano
what?
pong lawful production ng tax records ang ine-expect nyo from the BIR Commissioner? Is it asking authority from the President?
I think what the presiding officer stated a while ago is that in order for the impeachment court to accept these BIR filings, if the BIR will also comply with the exemptions provided under the NIRC. And ilang beses naman na naulit yan na ang consent of the President is one of the means by which disclosure could be allowed. So, ito naman din ho yung sinasabi din namin, paulit-ulit na wag natin pangunahan kung anong magiging aksyon ng BIR Commissioner sa bagay na to. So, mahalaga ngayong araw, pinagbigyan na, naaprubahan na yung request natin for issuance of subpoena. Ngayon, hintayin natin kung anong hakbang na gagawin ng BIR Commissioner dito.
Tama po yun kasi kailangan nga ng response from the BIR Commissioner. Although yung mismong mga requirement na yun sa Section 71 of the National Internal Revenue Code, including the securing of the approval or consent of the President, hindi yun naging hadlang sa pag-issue pa lang ng subpoena. It's up to the BIR Commissioner now what to do in compliance with the subpoena. So kung gusto niya talaga maging safe, na he will not be in any manner, in any way violative or in any way violating Section 71, then he may just as well secure the consent or authority of the President. Kaysa naman yung mapapakontempt siya kasi he would refuse to comply with the subpoena by just invoking Section 71. He cannot just be invoking Section 71. Kailangan ipakita niya na nagko-comply siya sa Section 71. Kung gusto niya, kung ayaw niyang, to be disobedient to a lawful order, the lawful process from the impeachment court. Kasi ganun din ang nangyari noon sa Corona impeachment trial. Di ba ang pinasubpoena doon, then Commissioner Kim Menares. So nag-issue ng subpoena and then wala namang sinabi sa subpoena na kunin mo yung authority of the President. But then naging ready, naging handa si then Commissioner Kim Menares. So she made sure that before she appeared before the impeachment court in compliance with the subpoena ay dala-dala na niya yung authorization para wala nang maging issue sa kanyang production of the subpoenaed documents from BIR.
Okay po. Ma'am, pero hindi nyo naman po nakikita si President Bongbong Marcos Jr. na pigilan or wag magbigay ng authorization if the BIR Commissioner asked for his authority.
We certainly would hope that he would give the authority. Wala kami nakikitang dahilan para hindi ibigay ng Pangulo yung authority or yung consent niya doon sa pag-comply noong subpoena, sa pag-produce nung pinasubpoena based on the order, based on the subpoena of the impeachment court. Wala po kaming nakikitang dahilan para hindi siya magbigay ng ganong authorization.
Last na lang po, sorry. Since ito pong development na ito ay napaka-significant, is there a chance po na i-present nyo po earlier ito pong article na ito na Unexplained Wealth, even before the bribery article?
At this point, we cannot say yet what would be the next article after Article 1. Article 1, which is confidential funds. Magsisimula na nga sa Wednesday yung pag-present ng witnesses relating to Article 1 or confidential funds. Is it going to be bribery ang next, or is it going to be unexplained wealth na? So we will cross the bridge when we reach it, and that means it requires an assessment, an evaluation of the proceedings with respect to Article 1. Kasi patapos na nga yung Article 4, right? So isusunod na yung Article 1. We will decide at the proper time.
Sorry, just to press on that, but it will be allowed by the Senate Impeachment Court.
Yes, it is within the discretion. The prosecution is given the discretion to choose or to modify the sequential order of the presentation of the articles.
Okay, Rosalie, kindly pass the mic to Mark. Let's hear it from Mark.
Thank you, isa lang maiksi po. Yung hindi po pinayagan na foreign currency na mga accounts, gaano to kaliit o kalaki sa gusto sanang patunayan ng prosecution na unexplained wealth ng Vice President and husband?
First of all, you have to clarify that with respect to foreign currency deposits, no, ang hindi napayagan yung pagsabina ng mga bank records. Pero meron pa rin tayong records relating to this, no, dahil naka-indicate din dun sa AMLAC reports yung transactions dun sa covered transaction reports and suspicious transaction reports. So naka-indicate dyan both peso and foreign denominated accounts, no. Now as to dun sa total amount, no, but what you can say is it will not affect the strength of the totality of the evidence that we have, no, that could establish itong articles of impeachment relating to unexplained wealth.
May tansya po kayong amount na foreign currency involved?
Well, mas malalaman sana natin ang exact amount na yan kung makikita at mabubuksan natin yung mga bank accounts, ano. But again, what you can say is based dun sa AMLAC reports, majority of those are peso-denominated accounts.
Konting dagdag lang, I don't think the prosecution would be further taking issue on the matter. It's enough na grinant na nga yung subpoena with respect to the peso-denominated accounts kasi very substantial naman yung peso-denominated transactions or peso-denominated accounts. So malamang hindi na rin kailangan yung tungkol sa foreign currency. That's how I see things. I may be wrong, pero I don't think we will take further issue kasi malaking tagumpay na yung pag-grant mismo ng mga requests for subpoena.
Thank you, Mark. Ann, it's your Ann, it's your turn. Kindly pass the mic to Ann. Yes.
Hello sir, sorry. Good evening po ma'am and Kongs. May ano po ang mensahe ninyo sa publiko? Ang soberano po pala ng Bombo Radio. Ma'am, ano po ang mensahe ninyo sa publiko tungkol sa naging takbo ng presentasyon ng prosecution sa Article 4 o grave threats?
Unang-una, hindi pa po tapos yung Article 4, although patapos na. Kasi nga, yung last witness na lang ang ipipresent bukas. Ang mensahe po namin sa publiko is that tingnan yung Article 4 na hindi lang ito, yung tungkol sa grave threats, it doesn't matter actually kung ito ay isang criminal offense. Kasi hindi naman ito a criminal court. Hindi naman ito regular judicial proceedings in criminal cases, kundi this is an impeachment court at ang pinaka tinitingnan dito is the fitness, the fundamental fitness of the respondent to continue holding such a high office, which is the Vice President. Tama ba yung ganyang asal? Tama ba na basta-basta na lang siyang bibigay ng ganoong threats, irrespective of whether or not it's a criminal case. It's a criminal offense. So hindi na nga dapat dito kailangan kung yung pagtutukoy o pag-identify nung assassin o yung kinausap ni VP Sara na papatay sa Pangulo, sa First Lady at sa former Speaker of the House. Pero siyempre, ang kalahatan ng mga naging resulta ng investigasyon, yung investigasyon una ng Cybercrime Division, yung HINED, ang head doon is si Attorney Jeremy Lotok at member si Senior Agent John Mark Calilong at yung follow-up investigation. Kaya yan nga po yung magiging laman ng testimonya bukas ni Director Matibag, yung naging resulta, paano ginawa, bakit ginawa, ano yung mga proseso, ano yung mga leads na tiningnan nila, ano yung mga factors, ano yung mga consideration na tiningnan din nila doon sa kanilang pag-conduct ng follow-up investigation.
Para dagdagan ko lang no ma'am, yung magandang maintindihan din ng taong bayan na yung desisyon ng impeachment court hindi lang naman yun panalo ng kung sinong side o ng prosecutor o ng defense, more on yung pagkapanalo nung pagpayag nila upang masubpina tong mga records na to, no? So sa dulo yung sa hinahanap nga po nating katotohanan. So papalakasin po nito as evidence po. Nakikita nyo naman po kung saan tumutungo at kung gaano po kaganda ang preparasyon ng prosecution. Ngunit at the end of the day, kailangan maintindihan ng taong bayan na yung pagpayag nila is pagpayag po sa katotohanan. Ganun lang po kasimple.
Sir, another question lang po. Since sa mga susunod na araw ay tatalakayin na po yung tagong yaman, confidential funds, inaasahan po ba ng prosecution na may mga hakbang mula sa defense na maaring magdulot po ng delay sa pagtalakay sa issue?
Well, unang-una siguro hindi na maitatago. Kasi kung papayagan po na masubpina itong mga records na to, may open shot saka mabubusisi po. Again, sabi ko, malaking hakbang to towards kung ano man ang pinaglalaban ng prosecution. At sa mga susunod na araw po, I'm sure na magiging interesting yung mga susunod na hearing days dito sa ating trial.
Thank you, sir.
Ang masasabi ko rin po dyan sa victory ngayon, dyan sa pagpayag nga na isabina yung mga dokumento na yon, it makes the prosecution, the panel of prosecutors, more determined to prove its case against the respondent.
If I could add quickly, we won't speculate on their motives as to whether or not they'll try to intentionally delay the proceedings, but based on their actions and their strategy from the start, we anticipate that they will try to continue to prevent us from presenting evidence. But that's something that we've anticipated already, and we're prepared for it. Sisiguraduhin namin, malalatag namin ng mabuti
about the subpoena today. Are we expecting a challenge in terms of objections? Are we prepared for this po?
We can always expect those things from the defense. They would be interposing, or they would be posing objections to certain questions in the course of presentation of witnesses doon sa Article 2. In the same manner na gano'n naman ang ginagawa nila in the examination of witnesses, nag-object sila. And then, of course, hindi naman natin yan maaalis sa kanila na they would be questioning even the admissibility of certain evidence na kahit na-produce na, napayagan na, naipakita in the course of the trial, they will still raise issues of admissibility kasi hindi naman yun covered pa sa pag-issue. Pero napaka-importante, malaking bagay na po yun, na pinayagan na ng impeachment court, yung pag-produce mismo, ang paglatag mismo nitong mga ebidensya na ito. So other questions will have to be raised in due course or in due time, and then the prosecution just have to respond to those objections.
All right. Haji?
Good evening po, Haji sa Brigada News FM. Balikan ko na po yung issue dun sa bank documents or bank records ni VP Sara. Ano po yung, kumbaga, para po maipaunawa sa publiko kung bakit kailangan pong ungkatin or bulatlatin yung kanyang bank records? Kasi baka may mga magsabi naman po na, kumbaga, parang hinahalukay na po yung lahat. Although sinabi naman na po na hindi naman ito fishing expedition. Pero may mga binabanggit din po kanina yung defense na may mga pagkakataon naman po o ilang taon na hindi naman po naglilingkod o hindi naman po public servant si VP Sara during that time.
So, una-una, para address natin ulit yung fishing expedition, although na settle naman na yan, no? Kailangan magandang alalahanin natin na dun sa proceedings before the House of Representatives, no, diyan unang lumabas itong mga financial transactions nito sa pamamagitan no executive director ng AMLAC. Kung kailan napakita, no, may financial transactions involving the Vice President and her husband amounting to no less than 6.7 billion pesos. So, anong kahalagahan nitong mga bank accounts na to? Ngayon, dyan natin malalaman, no? Dahil dun sa mga AMLAC reports na doon, naka-indicate na doon ano itong mga specific bank accounts, account numbers, anong branch yan, no? Kung saan ginamit ng Vice Presidente at ng kanyang asawa para magkaroon itong financial transactions na to. So, ngayon, itong bank records na to, titignan na natin isa-isa itong mga bank accounts na to para mabuksan at makita. So, magkano ba talaga ang linalaman ng mga accounts na to? Magkano ba talaga ang fresh inflow of funds na pumasok sa banks na to? Dahil again, alalahanin natin, ang naging sagot nila nung lumabas itong 6.7 billion financial transactions, ang naging sagot nila ay pwedeng bloated yan, pwedeng same amount, transfer from one bank account to another. Hindi yan lahat fresh inflow. Pwedeng pumasok, lumabas. So ito na ang pagkakataon, ito na ang susi para malaman talaga natin, at the end of the day, magkano ba ang kabuoang yaman na pumasok sa mga bank accounts ng Vice Presidente at ng kanyang asawa.
Napagdebatehan naman ng maigi, no? Na-explain actually through the debate sa kanang presiding officer yan kanina. Meron pa kang manifestation from senator judges about dun sa na ba't di na lang natin buksan lahat. May point naman po, magandang suportahan po yung advokasiyang yan, pero hindi naman po kasi lahat impeachable. Hindi naman po lahat ng government officials ay impeachable, pero magandang suportahan yung advokasya na yan. Siguro mas pasimplehin na lang natin kasi kung mas malaki yung ating opisina, kung mas malaki ang ating kapangyarihang hinahawakan, mas malaki rin dapat yung standard sa yung accountability na ipapakita natin sa taong bayan. Siguro malaking bagay nga po talaga tong hakbang na to na na-allow tong impeachment court, no? Kasi na-allow ng impeachment court tong pagsubpina ng mga records. Kasi when you're
when you have declared that you will run for the presidency or you are the vice president, siyempre mas matataas po yung kailangan nating standard at pananagutan sa taong bayan. So, malaking hakbang talaga yun para sa pananagutan. Diba? Sabi nga ilang beses ko nang kinote si Kong Chele, diba? Yung integridad, ano yan, hindi humihinto, continuing yan. So, kung nagsimula ka kahit kapitan hanggang naging presidente ka ng Pilipinas, dapat yung record mo ng integrity, hindi nagbabago yan o hindi adjustable, depende sa kapangyarihan mo.
Kanina po parang napag-compare na naman yung treatment nung impeachment case against the president and against the vice president. Can you just explain po kung bakit, kumbaga, nauwi po tayo dito, tapos yung kay President Marcos parang di naman daw umusad?
Alam nyo, hindi tama yan na binabalikan yung mga ganyang issues o ganyang mga matters, no? Kasi na-take up yan sa Justice Committee sa House of Representatives. And hindi nga appellate court, hindi appeals court ang impeachment court, Senate as an impeachment court, na pwede niyang i-review kung ano talaga yung nangyari noon sa proceedings before the House Committee on Justice. May batayan kasi yun na nga, under the rules of the of impeachment ng House, yung Justice Committee in determining probable cause, ang una munang dinidetermine is sufficiency in form and substance. So may dahilan kung bakit declared as insufficient in form and sufficient nga in form pero insufficient in substance. So hindi tama yon na binabalikan yung mga ganyang issue. Tapos na po yun. Ito po ay tungkol na sa trial, sa paglilitis. Ebidensya na po ang mga titingnan dito, hindi yung mga pangyayari noon sa Justice Committee, sa House of Representatives which determined probable cause, and that's within also the exclusive, the sole power to initiate impeachment cases. Kung yung Senado as an impeachment court has the exclusive power to try and decide impeachment cases, ang nauuna po ay yung House of Representatives at exclusive authority rin niya po ito na hindi na dapat po pinapakialaman. Iba na pong mga issues ang nasa harap ng impeachment court. Hindi na po yung mga yun na mga na-tackle na-resolve na, nag-decide on the merits yung House Committee, on the Justice Committee, doon sa mga issues that were raised at that point or at that stage of the proceedings.
Nagawa na po kasi ng Kongreso yung trabaho niya. Maaari po nilang balikan yung mga proceedings, saka yung mga records, pati yung mga debate po, paukol dyan. May mga tanong din po na similar sa kaso ni Presidente, saka kaso ni Vice President. Pero lahat po yan dumaan sa proseso at nagawa na po ng Kongreso yung trabaho niya. At nandito na tayo ngayon sa impeachment court. So, tama nga po si Senator Laila. Trial na po to. So, ibang tiyempo na to, ibang oras. So, dapat dito na yung focus.
Okay. Last na lang po. May wisdom po ba behind kung bakit uunahin na yung dalawang land bank officials at sa imbis na si Marivic Pareha po sa darating pong Wednesday? Thank you.
Yan naman, under the complete discretion ng prosecution yan, how to present our evidence, no, yung dun sa sequence of witnesses. But it just seems that to better tell the story, no, with respect to this issue on confidential funds, the prosecution, specifically the team handling the confidential funds, has deemed it appropriate to start with this land bank officials.
Hello po. Kenneth po from the Philippine Daily Inquirer. My question is addressed to Attorney Benjamin Tolos and Tutor Laila de Lima. So how will today's ruling chart the direction of proceedings insofar as the unexplained wealth charge is concerned, and specifically how pivotal is the ruling in helping bolster the case that the Vice President enriched herself while in office? Thank you.
As stated a while ago, no, by Congresswoman Lila de Lima, this is a major victory for the search for truth, no, for transparency and accountability. So, napaka-importante ho nitong mga dokumento na to para mapakita natin ang complete na picture, no, ng kabuuang yaman ng Vice Presidente, no, at nagagalak ko kami, no, na mabibigyan na tayo ng pagkakataon na pare-pareho nating makita at masuri itong mga dokumento na to, no. Again, ang charge ho dun sa Unexplained Wealth is yung actual na yaman, kabuong yaman ng Vice Presidente ay higit na mas malaki kumpara dun sa kanyang yaman na dineklara sa kanyang Statement of Assets, Liabilities, and Net Worth. So, sa pamagitan ho ng pag-issue ng sabina na to, magkakaroon na tayo ng oportunidad na ikumpara yung buong yaman na dineklara sa SALN versus ano ho yung yaman na dineklara naman dun sa tax filings, no, dito sa BIR. And ultimately, magkano ang totoong yaman na linalaman ng mga bank accounts, no, ng Vice Presidente at ng kanyang asawa na makikita naman natin dito sa mga bank records.
Nothing further to add.
All right. Now, Ed.
Pwedeng dagdagan ko lang ng konti, no?
Yes,
Bilang
ma'am.
isang nanay kasi, minsan ang hirap magluto ng sinigang kung wala kang sampalok. And in this case, napaka-importante nung hakbang na ginawa ng Senate Impeachment Court. Kasi kinumpleto nila yung materyales. In other words, ang prosecution ngayon ay may pagpapatuloy ang kanilang obligasyon na talagang ipakita kung meron bang basehan na masabi nating hindi karapat-dapat ang pangalawang Pangulo sa kanyang posisyon. On the other hand naman, ang defense naman ay nandiyan para maidepensahan nila. Kasi pag andyan nakalatag ang lahat, andyan ang lahat ng ingredients na iyong lulutuin, syempre mas magagawa mo ang iyong gagampanan. So both the prosecution and the defense can openly kanya-kanya silang magprepresenta ng kanilang mga dokumento at mga pahayag para mabigyan ng mas karapat-dapat na basehan ang desisyon ng ating senator judges. In other words, uulitin natin, makakapag-desisyon sila na hindi nakapikit ang mata, yung mga bagay-bagay na hindi kayang gawin dun sa Kongreso, yung mga dokumentong hindi pwedeng mabusisi kasi hindi nga pwedeng makuha. Ngayon ay nakalatag halos lahat. Kaya napaka-importante ng hakbang na ito.
All right, let's hear now from Ed.
Good evening po. Ed po from DSME. Ma'am, sirs, mukhang the way it looks at it, parang winning ang prosecutors sa mga arguments na hinaharap po ninyo. Patapos na sa Article 4, and then the next article is mukhang maganda rin yung mga inaano nyo. So, yung voting, ma'am, yung voting sa to convict the Vice President, 16 po yung sinasabi. Until now ba, hindi ho ba nagbabago to? And marami rin nagsasabi na it will reach the Supreme Court. So may justiciable issue na ba to raise the issue sa Supreme Court?
Ang pinaka-position kasi dyan ng prosecution ng una is that premature pa. Kasi wala pa nga sa botohan. Wala pang justiciable controversy. Hindi pa ripe, hindi pa hinog yung pag-resolve ng issue na yan. Kasi nga, kakasimula pa lang ng pag-present ng evidence and then wala pa ngang botohan. How do we know now the actual circumstances that would prevail at the time na magbobotohan na? Ilan ba talaga sa mga members, the mga senator judges ang nakapag-participate? Nakita yung ebidensya, nakinig sa mga witnesses at nakapag-participate. Kasama sa mga nag-manifest at nagtanong doon sa mga witnesses. Hindi pa natin alam ano ba talaga, ilan ba talaga sila na totally na walang magiging participation. But then again, inano nga ng impeachment court na that ruling of the presiding officer is the prevailing rule now. But we are hoping na bubuksan pa rin nila, i-revisit pa rin nila, i-reopen pa rin nila yung pagtalakay sa issue na yan at the proper time. Now, in the meantime, maybe a party, an interested party, a proper party would be able to raise it before the Supreme Court. Pero kahit walang mag-raise niyan sa Supreme Court, nothing would prevent the impeachment court from revisiting the issue, from discussing again the issue and voting on the issue as to whether ilan talaga, i-determine nila ilan ang required to secure, to get, to achieve conviction. Kasi it's not yet ripe. Yung merong tinatawag na doctrine of ripeness, na hilaw pa. Wala pa yung controversy. Kasi wala pang ang botohan. Who knows? Makuha ka agad yung 16 or more than 16 votes. Then there's no justiciable controversy kasi nakuha na nga yung 16. What if it's not achieved? 16 was not met, but there are circumstances that can point to the fact na kailangan i-consider din na wag nang ibilang doon sa baseline din, yung numerical baseline ng pag-determine ng 2/3 votes. Thank you.
Dagdagan ko na rin yung kay Kong Laila, no. Maganda naman po na nakikita natin na medyo may momentum po sa side ng prosecutors, pero medyo maaga pa nga. So, ang pinagmamalaki po namin lagi is yung paghahanda po ng prosecution side. Kung ano man ang maibato, kung ano man changes na mangyari dito sa impeachment court, pinaghahandaan po maigi ng prosecutor. So, sa tingin ko, yung question po ng threshold, kasama na rin po yun sa pinaghahandaan. Although maaga pa nga, pero kailangan paghandaan pa rin. Eventually, ang diskarte po, patuloy na palakasin yung ebidensya at patuloy po na palabasin yung katotohanan at paglatag po ng tama ng mga witnesses at saka mga dokumentong ilalabas. At garantisado po yun na ang prosecution ay naghahanda every day.
Any other question? Kung wala nang katanungan, siguro let's hear a parting word from our guest, Prosecutor De Lima. What can we expect tomorrow?
Last week, no, nagtanong kayo kung may paputok, papasabog ba? Di ba, 5-star? Sabi ko, 5-star. Sabi ko, malamang bukas, sawa. Sawa. Mga siguro mga 25 feet. Hindi, masaya ito bukas. I'm sure ina-expect nyo na rin yun. So, again, from our side, side of the House leadership and sa prosecutors, maraming salamat po. At patuloy po nating panoorin at makialam at obserbahan itong ating impeachment trial kasi araw-araw po nag-e-evolve siya. Saka nakikita natin kung gaano ka-importante itong mekanismo na to ng Constitution. Maraming salamat po. Mahaba, tapos maraming putok. So, sawa nga
Magte-take off lang ako dun kay Kong Pao, yung sinabi niyang mahaba, no? So balikan natin. Whether it will be 16, 15, 14, maski ano man yung numero, wala pa tayo dun. Pero ang pinaka-importante ay ipripresenta, susuriin yung mga bagay-bagay na bawal buksan at bawal isabina nung sa Kongreso pa ang impeachment complaint. So ngayon, moving forward, regardless of the number, what is more important now, ang mas importante, mabuksan, masuri, ipagpatuloy ang pag-uusap-usap para maging sang-ayon at karapat-dapat ang desisyon ng ating senator judges doon sa mga may prepresenta na ebidensya.
So, sa last word, no? Again, as what you stated, our first two witnesses have already established very important matters with respect to the grave threats. Sa ngayon, napakaliwanag na wala ng question dun sa authenticity ng video kung saan ginawa yung pag-amin ng Vice Presidente na meron siyang isang kasunduan sa isang mamamatay tao na patay ng Presidente. Na establish na din sa pamamagitan ng aming second witness na malinaw, hindi ito isang isolated event lamang. Pinakita niya dun sa mga interview statements done before, during, and after that November 23 live interview na meron talagang intensyon, no, na gawin ito. No? Magmula dun sa pagsabi ng gusto kong pugutan ng ulo niya hanggang sa pag-amin, meron siyang naging kasunduan sa mamamatay tao at hanggang dun sa after 3 days, hindi niya to binawi at pinanindigan pa. Ngayon, inaanyayahan pa rin ho namin lahat ng mga kababayan natin na subaybayan pa rin natin, no, itong paglilitis bukas dahil napaka-importante pa rin ng magiging testimonya ni NBI Director Matibag. Kung meron pa mang mga konting katanungan, no, na nakabinbin pa dahil nga nasabi ni NBI Regional Director Lotok na dun sa mga follow-up investigations regarding this assassin, hindi na ho siya naging parte niyan bilang parte ng Cybercrime Division. Si NBI Director Matibag na ho ang sasagot niyan. So, sana ho, samahan niyo kami ulit bukas at subaybayan ho natin ito.
Alright, on that note, salamat po muli sa ating mga panauhin ngayong gabi, si DS Garin, Representative Leila de Lima, DS Pau, and Attorney J. Tolosa. Sa inyong lahat at sa ating mga kababayan na sumusubaybay, ano kaya ang mga pasabog na mangyayari bukas, subaybayan natin. Magandang gabi sa ating lahat.
Po ito kukunin at ano po yung possible next actions?
Well, to be perfectly clear, we're not even sure if a motion for reconsideration is something that we're allowed to do. No, that's parang wala yan sa rules nung huli naming tiningnan. Of course, there's always the possibility of going up because, as I mentioned earlier, everything is subject to judicial review depending on the circumstances available. But we have not made that decision yet. So gusto ko lang i-clarify yon na this is something that we have to discuss as a team and also, of course, in consultation with our client, the respondent, no, Vice President. So, ano lang naman, yan yung mga parati naming may kolatilya kasi para sa mga abogado na without prejudice to ganito, ganyan. But it doesn't mean that we will be doing it. It doesn't mean that we will not be doing it. But this is something we'll have to discuss, no, amongst ourselves.
So there's a possibility na i-appear ba ninyo sa Supreme Court?
That remedy is always available, but as to is it possible, syempre anything is possible, but are we going to do it? Hindi pa namin napag-decision, hindi pa namin napag-uusapan because as I said, no, hindi naman namin din kumbaga diniscount yung possibility na mangyari talaga ito, considering it happened in previous impeachment trials. Although, syempre, ang posisyon natin is nung corona trial na parati nilang kino-compare, marami nang nangyari in between, no? From then till now. That's why we had our legal position on the matter. But as I've said, we anticipated that this might happen and we're ready nonetheless.
Sa decision sa ruling court, yung picking mo, and then JP said was denied po yung kanilang subpoena for that. So how do you take this? Is this somehow small win for the defense team?
Well, our position really was that it wasn't particularly described, meaning it didn't pass the test of definiteness and it didn't pass the test of relevance. So I wouldn't even take that as a win, no? I mean, yun kasi clear-cut talaga, wala talaga silang participation dun whatsoever, but yung kahit naman dun sa mga pinayagan, we really strongly felt about our position. But again, that doesn't mean mali yung impeachment court or anything like that, no? Kasi we really have, I mean, at the end of the day, ultimately, sabi ko nga kanina, the decision will lie upon the impeachment court. They rendered their ruling kanina, and we respect that.
Attorney, any reaction po dun sa wording ng impeachment court without directly addressing kasi the term fishing expedition ang sabi nila, the documents requested under the subpoena duces tecum will not be used to allege additional independent impeachable offenses. Any reaction to that?
it's very difficult for us to fathom how we will proceed on that. But if that is the position of the impeachment court, then we will respect it. But yun nga, no, hindi namin alam. I think ang ibig sabihin nila doon is hindi yan mako-consider for the impeachable offenses alleged in the Articles of Impeachment. But again, we'll have to see. We'll have to wait and see. Total, tama naman na sa PINA stage pa lang to. So tingnan muna natin how the evidence will be appreciated. And nasabi din naman ng ating presiding officer that this ruling is without prejudice also to the admissibility of the evidence to be obtained, no? Or documents rather to be obtained.
Nakausap niyo na ho ba si Vice President?
Hindi pa po. Hindi pa po. Because as you saw, we just came from the session hall. So hindi pa po. That's why I said whatever happens in the next few days regarding this decision, at this point we fully submit and respect the decision of the impeachment court. But kung as far as remedies are concerned, this has to be discussed with the persons involved.
Attorney, generally, maraming nag-grant on the part of the prosecution.
Yes.
But may mga safeguards din naman, may mga caveat din naman na nilagay itong impeachment court with regard to the granted parts. Tinitingnan niyo po ba yung small wins pa rin kahit paano? Those little safeguards na nilagay nila?
Sa amin, to be honest, no? Yes, you could consider it small wins, but sa amin, we felt strongly talaga on why we felt that the requests were overbroad. So, even if you were to say it, even if you were to consider them as small wins, palagay ko at the end of the day, talagang on the substance, no, of what happened, I think it's something we really have to look into and see if we want to avail of remedies.
Attorney, since sa PINA pa lang po, yung pag-open nito sa impeachment court, pag-uusapan, magkakaroon din po ba ng oral arts?
Hindi, wala naman siguro mangyaring oral arguments sa ngayon, no? I don't foresee that. Ang next step kasi dito, syempre, will be objections to certain documents being presented, 'di ba? So, kasi nga ang pinag-usapan pa lang natin ngayon is the issuance pa sa PINA. Titingnan natin kung ano din yung sasagutin ng mga agencies that will have to comply. And then once mag-comply and these pieces of evidence or documents will be presented in court, of course, you can expect certain objections also. And then it will go to the formal offer, di ba? Kasi dun, yung admissibility naman sa evidence, dun yun sa sinatawag nating formal offer. Ibig sabihin, once natapos na sila sa mga testigo, ang susunod na mangyari is there will be a formal offer of evidence, no? At nakalista yon lahat ng mga documents na ino-offer nila sa evidence, and the defense will be given an opportunity to comment, to oppose, to object, etc.
Attorney, yung nangyaring desisyon na ipasubpi na itong BIR, bank documents, yung sa AMLAC, kaka-apekto ba to sa usad ng trial bukas, sa susunod na araw? Ano nakikita po?
Hopefully hindi naman. I don't want to say na makaka-apekto to kasi baka ang lumabas parang this will just cause further delay. Hindi naman siguro. Sabi ko nga, both parties naman are very reasonable in terms of the way they present, no, their evidence. So, sa tingin ko hindi naman. And since inaasahan namin din tong mga na pwedeng mangyari ito, we already have a game plan as to how we're gonna approach these things. At sa tingin ko naman, hindi naman makaka-unduly delay yan.
So tuloy-tuloy kayo bukas. Si Director Matibag naman, ready na din kayo?
Opo. In fact, tomorrow, nabanggit na rin that Director Matibag, in fact, will be presented tomorrow. And we are prepared for that.
Attorney, yung Section 8A ng RA 11521 na hindi nila pagbigyan, sunod dun sa inyo pong argument kanina. Ano ba ito? Delikado ba ito sa ibang mga bank depositors?
Well, syempre, yun po yung position namin only because Section 8A is not with bank deposits, no? It's with AMLAC, actually. It's with AMLAC. So, Section 8A, ang position namin is absolute prohibition yan. But again, nagdesisyon yung court and we'll just have to accept the decision of the court.
Pero may dapat mga barin, mga
Ayokong puntahan yung ganyan because it's a way of criticizing rin the order. So I hope you'd understand, sir. Hindi ko munang, I don't want to sensationalize the decision. No? That was the ruling of the court and we just have to respect it.
Attorney, if ever man papanik kayo sa Supreme Court, how soon yun? Next week? 2 days from now?
Hindi ko masabi kasi it's something that we have to discuss. Kung aakyat ka sa Supreme Court, syempre you have to also draft the pleading itself and make sure that all of your arguments ay malatag ng mabuti, di ba? So, hindi pa natin yan masasabi dahil in fact, yung pag-akyat pa lang sa Supreme Court ay hindi pa namin na-decisionan. Meaning, you never know, baka hindi naman kami umakyat talaga.
This is a decision to ask Vice President herself or decision within the defense team?
Both. It's a decision between us, a defense team. It's something we need to discuss. If we think it would be advantageous for our case to go up, plus definitely it has to be a discussion. There has to be a discussion with the client, diba? Kasi at the end of the day, we can only advise. And kung ano yung sabihin ng client, yan pa rin naman yung gagawin namin. For as long as it's within confines of law.
Attorney, medyo light question. Kasi yung para observation ng mga tao ay ang ganda daw ng cross-exam, ang ganda daw ng oral arguments from last week, tas ngayon, kayong dalawa, Prosecutor Jokmer and then kayo po for the defense. Could we expect the same cross-examination in the next coming days from the part of the lawyers?
Ano kasi yan eh, each lawyer has his or her own style. At nabanggit ko to sa interview not long ago na pwedeng calm ako ngayon kasi iba rin naman, in fairness to my co-counsels, no? Iba rin kasi yung setting, oral arguments kasi ngayon. So, while nagsasalita si Attorney Diok, no, syempre, as you know, bawal akong sumingit, and pag nagsasalita naman ako, ganun rin naman si Representative Diok, no? So, iba rin kasi yung setting. Hindi ko rin masabi kung anong mangyari kung ako na yung nakasalang tapos cross-examination. And it will also depend on the witness, diba, kung gaano ka responsive. So, but my point really is different strokes for different folks, diba? So each lawyer has his or her own style, and one style may not necessarily be better than the other. Kunwari, yung style ko, baka pag may isang particular witness, baka hindi yan maging effective dahil mabait ako. So, kung sinasabi niyong kalmado ko, baka hindi yan effective. Not mabait, no, sorry. But kalmado, baka pagdating sa isang witness, hindi effective yung pagkalmado ka. So, it will really depend on the lawyer and the reaction of the witness to the lawyer.
So, bukas po si Atty. Matibag. So, ano ang expectation?
Well, sa amin naman po, we will take our cue from the presentation that will be made by the prosecution. At syempre, yung nakarang araw na rin naman na pag-usapan na yung mga NBI agents, so iikot naman doon yun, no? Baka may dagdag sila, as I've heard over the news, may sinasabi silang may mga dagdag. So, we will just take our cue, but we're ready to cross-examine, and if there's anything new, we're also ready to quickly adjust and address those matters in our cross-examination. But hopefully matapos naman bukas, both direct and cross-examination. Okay?
Despite yung ruling, tinitingnan din ba yun ng defense na baka naman may blessing in disguise on their part kung sana niya?
Ano pong blessing, sir? Blessing?
Baka naman mas mapuprove nyo yung innocence nga.
Sa amin, we anticipated it. At parati ko naman sinasabi, hindi namin kinakatakot yung mga dokumento, diba? Ang punto lang naman talaga namin is meron tayong mga batas, meron tayong due process clause sa Constitution. And sa akin kasi, pagdating sa Bill of Rights, it's tested not when it's convenient. It's tested when it's inconvenient. Diba? Katulad ngayon, that's how you really test kung uubra yung due process in a situation that's difficult to decide, that's inconvenient for everyone. So, but then again, sa atin naman, no, na-anticipate natin to. So kung mangyari man, I don't think it will affect the defense. I don't think it will be incompatible with our theory and our strategy all along. So we're not so down about it. No? But of course, if sabi ko nga may mga remedies under the law, we'll still ask the client kung gusto niya. Ang trabaho naman ng mga abogado is presenta lahat ng options sa aming kliyente. Okay? Thank you very much, everyone. We'll see you tomorrow. Maraming salamat po sa inyong pasensya. Thank you.
Kay sabihin mo. Maybe. Pre-trial lang. Pre-trial. 9 o'clock? Hindi na po. Sige. Thank you. Well, depende po. Yeah. Hindi sir, ay yan kasi yes. So kami, yung mga profile nila. So baka bukas, pwede kami magkaroon ng mga like okay. Ito yung thank you.